Court officer sitting later.
Right time start ಆಗ್ತದೆ sir. Start ಆಗ್ತದೆ.
Video ಇಲ್ಲ ಅದಕ್ಕೆ.
Yes sir, usual time sir. ಬರ್ತಾರೆ.
Okay.
ಬರ್ತಾರೆ sir ಸಾಹೇಬ್ರು.
Okay.
Yes. What is? Who's on the other side? Day after tomorrow. Serial number 23. At the request of the learned counsel for respondents, release this matter. On 21st of November.
Serial number 16, madam.
Others,
Impleading application has been filed by the other side.
Hmm.
I want to file objections.
For
Appellant is
impleading.
out of station. Next week, any date.
For
16. BK Rematter.
16.
16. 16.
Repeat after
16.
Mr.
16.
Ravi B. Patil.
16. ಅದು ಮಾಡಿದ್ದೇನೆ ಅವರು ಇನ್ಫ್ಯಾಕ್ಟ್ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ ಹಿಯರ್ ಆಗಬೇಕು. He is the main.
Serial number 16 at the request of learned counsel for the appellant.
Next Tuesday or Wednesday, man. 26 or 27. 26 or 27.
Release this matter on 26th of November.
Please.
My lord, serial number 17, madam.
17.
Yes, madam. Appellant, madam.
Huh?
Objection ಹಾಕ್ಬೇಕಾಗಿದೆ ಆಯಗ್ 1 week time.
Objection.
Yes, madam.
Including application. And in fact, my lord, this writ appeal itself does not suffice for consideration.
Hmm.
In view of the order passed by committee, my lord, grievance self, I will make out.
My lord,
Order is
I
passed in favor of the appellant itself.
Yes.
Huh?
Order is passed in favor of the appellant. So now the writ appeal does not survive. Ma'am.
my lord, detailed objection we will be filed about this.
ಏನು objection file ಮಾಡ್ತಾರೆ?
IMA
Subsequently order has been passed in your favor ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ. ಏನು objection file ಮಾಡ್ತೀರಾ?
pass or
Will not adjourn the matter. We'll see. Yes.
Lordship, serial number 56, my lord.
Ah.
Last date, we both advocate, my lord, made submission that there is a settlement, my lord. Already compromise petition is after only maps to be prepared, my lord. Landed property is divided in bits. Myself and Hangarge, sir.
Huh?
Myself and Hangarge. I am for respondent.
Kinder key.
Matter is settled, my lord.
Where is he?
I have already intimated him, my lord, matter is settled. And I request, my lord, to have it on 21st, my lord. I already talked to him, my lord. Our map and the land, some bits of land have been given to the parties.
So Sudhir Kulkarni is there. ಬಹಳ ಜನ ಇದ್ದಾರೆ. ಉದಯ್ Manguntikar is there. We will see if the matter reaches.
Please.
Serial number 53, 53, my lord. I am for the petitioner, my lord. Kindly have it tomorrow, my lord. Scenario is not well. Kindly have it.
Yeah, petitioner.
Huh.
B group.
How so? Scenario is not well tomorrow, my lord. Kindly.
Serial number 53 at the request of learned counsel for the petitioner. Release this matter
Tomorrow, my lord.
on
Already-
21st of November, day after tomorrow.
my lord, serial number 34, my lord. I am proxy counsel, my lord.
34.
Yes, my lord. ಮೆಮೊ ಕೊಟ್ಟಿದ್ರು ಅವರು ಬಟ್ ಹೆಲ್ತ್ ಆರಾಮಿಲ್ಲ ಅಂತ ಹೇಳಿ ಅಪಿಲೆಂಟೇ ಮೆಮೊ ಕೊಟ್ಟಿದ್ರು ಮೇಲೆ ಸ್ಟೇ ಸಲುವಾಗಿ ಬಟ್ ಅವರಿಗೆ ಆರಾಮಿಲ್ಲ ಅಂತ ಹೇಳಿ ಬರ್ತಾ ಇಲ್ಲ ಜಾದವ್ 34 ಮೇಲೆ
ನಾನು ಆಗ್ತಿದ್ದೀನಿ for hearing on IA. Filing the appeal. Already you admission ಬಂದಿಲ್ಲ matter. ಅಡ್ಮಿಷನ್ ಬರ್ದೆ ಇದಕ್ಕ ಹಿಯರಿಂಗ್ ಅನ್ನ ಐಗೆ ಹಾಕಿದ್ದಾರೆ. ಏನ ಯಾಕೆ ಹಿಂಗ್ ಮಾಡ್ತಾರಪ್ಪ? ಆಗಿಲ್ವಲ್ಲ, ಅದನ್ನ ಸೆಪರೇಟ್ ಆಗಿ ಫಸ್ಟ್ ಐಎ ಕೇಳಕ್ಕಾಗತ್ತಾ? ಅದೇ we have noticed so many things and so many times they are doing this one. Allah, he is not the learned counsel, he
Toxic.
is asking for adjournment, sir.
1 week.
At the request of serial number 30, request of learned counsel, the appellant. ಯಾವಾಗ ಬೇಕು?
1 week.
Huh?
Next week.
Release this matter on 25th of November.
Serial number 20,
Repeat ಆಗ್ತದೆ ಆ ಕಡೆ ನೋಡ್ರಿ.
serial number 25.
ಹಾ. ಹಾ,
ಇದರಲ್ಲಿ ಮಾಂತೇಶ್ ಪಾಟೀಲ್ ಅಂತ ಆಗ್ಬೇಕು, ಮಾಂತೇಶ್ ಎಸ್ ಪಾಟೀಲ್ ಅಂತ ಆಗಿದೆ ರೆಸ್ಪಾಂಡೆಂಟ್. ಲಾಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಆಸ್ ಡೈರೆಕ್ಟ್ ಟೇಕ್ ನೋಟಿಸ್. ಅದು ರಿಜಿಸ್ಟ್ರಿ ಮೇ ಬಿ ಡೈರೆಕ್ಟೆಡ್ ಟು ಶೋ ಆಸ್ ಮಾಂತೇಶ್ ಪಾಟೀಲ್ ಅಂತ. ಅವ್ರು ಮಾಂತೇಶ್ ಎಸ್ ಪಾಟೀಲ್ ಇಲ್ಲ ಅಂತ.
ಎಸ್ ಇಲ್ಲ.
ಹಾ.
Anyway, they are here.
ಅವ್ರು
What the problem?
they have not noticed.
Huh?
I am also seeking time alone. Next week it may be taken.
Advocate name change.
Here, election matter, why are you asking for time? Huh?
This matter, my lord, pertains to, my lord, redo the entire voters list have been, my lord, challenged. Voter list is passed.
Early. Election matter and it has to be heard early. Otherwise, it will become infectious. Why do you want to take
Idರಲ್ಲಿ
adjournment?
election, my lord, at the filing of nomination, my lord, date of election before 2 days prior to, my lord, date of election.
See, whatever. You want us to hear on merits, we will hear.
Next
Why are
week,
you asking for adjournment?
next week, my lord, some papers.
Serial number 25.
25.
Office is directed to show the name of learned counsel for response number 10 to 52 as Mantesh Patil.
Yes.
Stop. Next para. At the request of learned counsel for the appellant, release this matter on 25th of November.
Yes.
But,
Yes.
kindly, my lord, serial number 64, my lord, I am ready with the matter. One small request is, my lord, the party also wanted, my lord, the assistance of the senior counsel. If lordships permit, my lord, with
No,
25th,
no,
25th.
not at this stage.
Bless.
After everything is over.
No, no, my lord, that is why, my lord, I sought for time. 25th.
Please, ಇನ್ನೇನು ಮಿಕ್ಕಿದ್ದು sir.
ಇಲ್ಲ, ಸ್ವಾಮಿ, I was ready. Just, my lord, because of the repercussions, my lord, some assistance, my lord, 25th, my lord, Mr. Chandrasekhar, SM Chandrasekhar was coming, my lord, for another matter. If it could be accommodated and if
No,
it's
no.
permitted, my lord, otherwise I will.
We can't permit the learned senior counsel to argue the
Oblige.
rest of the matter.
Oblige.
Not possible.
Great.
Go ahead, we'll see.
Great.
Yes.
Complaints of office objections for 6th time, serial number 1. Iringoda, Malipati.
My lord, kindly pass over, my lord. Pass over. Court fees to be paid. Pass over, my lord. We'll do the needful.
ಮಾಡ್ರಿ ಕಟ್ರಿ
ಅಲ್ಲ, ಅದು
ಪಾಸ್
ಕಟ್ತೀವಿ.
ಓವರ್ ಏನಕ್ಕೆ?
ಅಲ್ಲ, ಇನ್ನೊಂದು council submission ಬರೆದಿದೆ. We'll write council submissions ಬರೆದಿದೆ. Remaining matters you have written council submissions. For that,
If you want to comply,
yes, my lord.
learned counsel for the appellant submits that the office objections will be complied during the course of the day.
Please.
ಇದು admission ಬರ್ಬೇಕಾ ಇನ್ನು?
It has to come for admission, my lord.
If office objections are complied, list this matter for admission on 25th of November.
Please, my lord.
Order, serial number 2, government advocate.
Order. Response number 3 is the, my lord, penal advocate, my lord, Alali, my lord, I may be permitted to serve the copy to the Alali. He's appeared before the learned single judge, my lord.
Response number 3 is
Yes, yes, Halali, my lord.
Development Authority, my lord, Mr. Alali is appearing for the response. Page number 12, my lord.
the Commissioner Vijayapura.
House, Urban Development Authority. Mr. SS Alali is appeared before the learned single judge, my lord. I
Learned
may be-
counsel Shri SS Halali is requested to take notice for response number 3. Learned counsel for the appellant is directed to serve a copy of the appeal memo along with annexures on learned counsel for response number 3.
Date may fix, my lord. Date may fix, my lord. In the similar issues, my lord, this honorable court was, this number has, number 3 issued, my lord, layout map, my lord. Next date of hearing, I filed a memo along with necessary document, my lord.
What is that, which is that, order in, 201228?
The similar set of fact, my lord,
ಎಲ್ಲಿದ್ದೀರಿ? You are not,
I filed, my lord, along with memo, my lord.
it's there at annexure K. 20122.
23, man. Along with memo, I'll furnish you, madam.
ಎಷ್ಟು ಸರಿ ಫೈಲ್ ಮಾಡ್ತೀರಿ ಅಪೀಲ್?
Because, my lord, para 10 of my grounds, my lord, para 10 of my grounds, my lord, it is against the order of the apex court.
Huh?
The single judge order is, my lord, against the order of the apex court, my lord.
You
In
know,
civil
when was the first order passed?
That,
Huh?
that is, my lord, 19, my lord, 14,
Number 200570 of 2017.
14/6/2019, my lord.
Huh?
14/6.
No, ಅದಲ್ಲ. Data.
How the date of the order.
ಹಾ.
That's why, my lord, para 10, my lord, and my grounds, my lord, I taken the contention.
ಸರಿ. Challenge was not raised in that writ petition.
That's why, my lord.
What is the use of raising a challenge now?
R3 has to, my lord, say this one part. That is the reason, my lord, I may be permitted to serve the copy to the, already also to fix the date, my lord. 26, 27, my lord.
Already is appearing for the
Like this is, my lord, this which is extracted also, my lord.
Urban Development Authority.
Development authority. ಅವರೇ
It's appearing for Urban Development
ಹೌದು
Authority.
ಅವರೇ appear ಆಗುತ್ತೆ.
The question here is regarding conversion and approval of the layout.
Yes.
It is not about the lapsing of the scheme.
That is the
That could
contention.
have been challenged only in that writ petition.
That notification was issued, my lord, long back. That is, my lord, 13/8/2010.
Adhe, it is held as lapsed.
So, my lord, apex court observed, my lord, that is, my lord, I
What
quoted.
is the
that,
use of saying that now, sir, in this writ petition and in this writ appeal?
Even
That order was passed in the year 2019, according to what you are saying.
Yes.
Then
Let him appear, my lord, on next date of hearing, my lord, you will also consider.
it doesn't depend on his submission. Now, what we are concerned is the your prayer was against whom? Deputy Commissioner. Adu aito, conversion aito.
Mandamus Inspector, respond number 3, my lord.
Idu Urban Development Authority
Yes,
for
ma'am.
sanctioning of the plan.
Yes, ma'am.
There is a direction to us also, my lord, para number 4. Respond 1 is directed to communicate the order passed by so and so, dated to all concerned authorities under their jurisdiction. When
Adhe,
that, when
so
that,
that every department will know what exactly was the orders passed earlier.
because, my lord, this one not to,
Not go on raising objections after objections like this.
this apex court judgment was not noticed by the learned second judge. That is the
What
problem.
is the use of saying that in this writ petition, sir?
ಅದು ಒಂದ್ಸಲ ಇದಾದ್ರೆ that will be precedent to the, my lord, to all the cases. For that is the reason, my lord, we filed this writ.
That advantage has been taken by the petitioners who filed that writ petition in the year 2017. ಅವ್ರಿಗೆ ಕನ್ವರ್ಷನ್ ಆಗಿದೆ, ಲೇಔಟ್ ಪ್ಲಾನ್ ಸ್ಯಾಂಕ್ಷನ್ ಆಗಿದೆ.
ಆಗಿದೆ.
How can you deny it now?
I will produce this order copy.
ಯೋಚನೆ ಮಾಡ್ಬೇಕು ನೀವು.
I will produce this office court.
ಅವ್ರು ಯಾರೋ ಏನೋ ಹೇಳ್ತಾರೆ ಅನ್ಬಿಟ್ಟು you file appeal.
Yeah, this is my lord, actually my lord, contrary to the order of the office court. That is my lord quoted also.
That objection should have been raised in the year 2019, sir.
That is the reason my lord we filed.
ಅದಾದ್ಮೇಲೆ there are so many developments, many other landowners have been permitted to form a layout.
Even in future also that cannot be taken for. That is the reason my lord we filed it. Lots of 25th or 26th my lord have it my lord. Let the allies also appear my lord, then we'll dispose of on that dates.
Release this matter on 25th of November.
Please publish.
CL number 3, Deepak V. Barat.
In this matter, my lord, I filed the memo of appearance, my lord, and also filed the affidavit for compliance. Request of the complaint is rejected by issuing the endorsement. Last occasion, my lord, it has taken time.
With liberty to challenge that, Lord.
Learned government advocate submits that complaints affidavit of the respondent, Commissioner for Sericulture, Sericultural Development and Director of Sericulture has been filed along with endorsement, copy of the endorsement dated 30/4/2024. Issued to the complainant. Next para. Learned counsel for the complainant submits that liberty may be reserved to the complainant to raise a challenge to the endorsement dated 30/4/2024. Full stop. Next para. Accordingly, the contempt petition is closed while reserving liberty to the complainant to raise a challenge to the endorsement dated 30/4/2024 issued by the respondent. Full stop.
Today I filed the memo of appearance, my lord.
ಹಾಕಿದಾರ?
Today I filed.
CL number 4, Preeti Patil.
Respond number 6, I filed the dispensation of respond number 6 of order.
Huh?
R6 is dispensation.
Learned counsel for the appellant has filed a memo dated 10/9/2024 seeking dispensation of notice to respond number 6 on the ground that respond number 6 is the owner of the stored vehicle and the liability has been fastened on the appellant insurer. Stop. The appellant is not disputing liability. Stop. Next para. At the risk of the appellant, notice to respond number 6 is dispensed.
Nitesh Padyal.
In this matter,
For
my
the
lord,
complainant's motion.
we requested the my lord government to. This is the my lord authorization letter. My lord. Communication is sent. This is the my lord matter. Learned single judge directed, even though my lord is not entitled for regularization and taking into humanity ground, my lord, 2,50,000 rupees each. My lord, there is a, then we filed the writ appeal. Writ appeal came to be dismissed. And for that is the reason now, my lord, we requested the government for further action in the matter. On 14/11/2024, my lord. Lots of 3 weeks time may be granted, my lord.
This litigation involves since from the year 1983, Your Lordship. From then on, this litigation has been continued.
Last para, that letter, my lord, last para.
Writ appeal was
Dismissed.
dismissed when?
Yes, ma'am.
The last date of hearing only it was dismissed, Your Lordship.
No, we have done it.
Yes.
Is on the ground of maintainability.
Regarding that is maintainability, my lord, that was.
Learned government advocate submits. When did we dismiss the appeal?
The date was
Even date and other date. Other date. That in view of the dismissal of the writ appeal filed at the hands of the state on 5th of November 2024, communication has been made to
Principal Secretary of Forest.
the Principal Secretary of the Forest Department for compliance of the orders passed by the learned single judge.
Or permission to,
Or for permission to file SLP. Full stop. The Chief Conservator of Forest, Kalaburagi, has made the communication on 14/11/2024. Full stop. Learned government advocate would therefore seek for a week's accommodation. Full stop. Next para. Release this matter on 26th of November.
first week of December, my lord. First week of December. Also.
2 weeks out. On 2nd of December.
Please.
Okay.
Serial number 6, Hitesh Gowda.
My lord, I appear for a complainant's counsel, my lord. The contempt matter. Last time the government advocate said he seeks instructions and submit.
That memo of calculation which is given, that is not given. But I will appraise a week's time, my lord. Last occasion, your lordship, he said that memo of calculation has to be given to us. Today they are giving, my lord. Your lordship, I have 25th or 26th, my lord.
Memo of calculation, they also did it, my lord. Let them partly deposit at least gratuity amount. My lord. They cannot hold the gratuity.
Even you filed an appeal.
That's why, my lord, there is no instruction, my lord, for that is the reason, my lord.
No, no, writ appeal was dismissed, my lord.
Writ appeal was dismissed, my lord. Thereafter, my lord, we communicated because here, my lord, the complainant himself is, my lord, appointed against the,
all these issues have been
the law.
decided in the writ appeal.
Approval
That
itself is not given to
11th
them.
of September 2024.
Yes,
Huh? 11th of September 2024, the appeal was dismissed.
yes, my lord.
Yes,
Ah.
but
That's why, my lord, now I place another week, my lord. You also have it on 26th, my lord, will.
my lord, this is
Get
the
the
fourth
information,
time
my
they
lord,
are.
that memo of calculation, my lord, given to me, my lord, that
No,
will
no.
also will communicate to them.
Let them deposit the gratuity amount at least.
But
my
I
lord.
don't know how they calculated that. My additional advocate general is on the line, my lord.
No, no.
Lords can permission.
Ah.
Please, my lords. Lords, in this matter, challenge was made to the order passed by the department, my lords, where the respondents, the complainants appointment, my lords, which was not in accordance with law. So he challenged that when writ petition is succeeded, my lords, in the writ appeal, so it was clearly understood that he may not be entitled for pensionary benefits.
No, no, no. This is a wrong submission.
No, I
Please,
may
please.
make my submissions, please.
Please, Vijay Kumar, don't.
Please, sir. No, sir. No,
please.
sir. Please let me make.
No.
Sir, please.
Order is there.
My lords, my humble submission is his appointment, my lords, is at the year 2006. Is after the year 2006. As my lords are aware, after the year 2006, the question of payment of pension does not arise at all because it's a contributory pensionary scheme. The erstwhile pension scheme where government employees could draw pension is not available to existing employees who are appointed after 2006.
So anyway, on the merits of the matter, you are unsuccessful.
No, my lords may kindly see in that order also, the issue with regard to whether he is entitled to pension, there is no whisper on that. So for that, my lords, the GO has been issued by the government to file a review petition.
Single judge order was upheld by the
My lords may,
retirement benefits.
the learned senior counsel may permit me to make my submissions, please.
No, no, you cannot derail the entire argument, Vijay Kumar. The writ appeal of yours has been dismissed. See, pension was not an issue. Your retirement benefit means pension. Kindly peruse. You can't. Otherwise, you would have preferred an SLP. That's not like issue. No, both date only ನೀವು kindly peruse.
Allah, why?
No, see.
One nimsha. Please wait. Please wait. So you are saying you want to file a review petition?
Please, my lords. My lords, my humble submission is, my lords, the backdrop for this case is, my lords, because there was a fraud played upon and the recruitment was obtained by playing fraud on the government, my lords, by furnishing incorrect information. my lords, the audit department took objections to that, my lords. Based on that, we issued notice and we terminated his services. And we had filed a suit for recovery of the salaries which were paid to him. There it stood. He challenged the order of termination. No problem. He succeeded. Please.
Yes. All that
He
has
is
been
suc-
considered by the coordinate.
Please, I have no, my lords, in fact, when the court suggested that he's worked for that many years, we understood, my lords, on equity, yes, for the years salaries that he's drawn, it's okay. But now, my lords, even if you were to be appointed in accordance with law, let alone the backdrop in which he is obtained the appointment, after the year of 2006, if anybody is appointed, they are not entitled to pension. Pension is a contributory scheme now. What he wants is a treatment which is not available to any other government servant anywhere in the country. I'll place all that material before my lords. And anyway, my lords, be that as it may, a GO has been issued for filing of review petition, and I'm yet to obtain instructions whether the review petition is filed or not. So I sought today morning, my learned government advocate had told me the matter was listed. So I requested him to take a week's time. I also pray for a week's time, my lords, so that I can place all the material before my lords. In 1 week's time, my lords, nothing. I do not understand what prejudice could be caused to the complainant within 1 week. Apart from the fact that if he is worried that the facts will be placed as it is before my lords.
No, pretext of this has been repeatedly argued before the bench 4th or 5th time.
No,
the issues have
the
been
humble submission, my lords, because we relented on humanitarian grounds, because we relented on humanitarian
all these issues are considered in the.
What about gratuity amount?
We will place it before my lords, my lord.
20
lord,
lakhs is the gratuity amount.
Gratuity
may have
contributory.
Something to say about pension. What about the gratuity amount of 20 lakhs?
I will seek instructions and place it before my lords. This even
immediately deposit 20 lakhs towards gratuity amount.
Next week, I'll obtain all the instructions.
There is no dispute regarding gratuity amount.
Pensionary benefits include everything, my lords.
What you are trying to raise is regarding pension.
Please.
What about gratuity amount?
Contribute ಮಾಡಿದಾರೋ ಇಲ್ಲ ಅಂತ. 20 lakhs on what basis they arrive at that figure is also not clear. Because with my humble submission.
Gratuity means 15 days work after every 5 years. Gratuity is a statutory right, my lord. My learned friend is also aware of it.
If I am not interrupted, I can make
you want to I have no objection, but the thing is that at least human and humane approach should be there for government also.
My lord, that is the reason why we had written to the government not to proceed with the recovery proceedings. That is what is humanitarian.
That has been
gratuity amount to matte earned leave encashment. These are all something that you had to settle immediately after.
I will have to secure instructions. See the records. I'll place it. Where in my lord's hands. In 1 week's time. In 1 week's time, where am I to go, my lords? I am state. I will not run away.
No, you will not run away. State, mighty state. My humble submission. Let the secretary appear before your lordship, my lord.
Respondent state and its authorities are contemplating to file a review petition in respect of the orders passed in writ appeal number 200134 of 2024, since the complainant herein was appointed in the year 2006 and all those appointees in the year 2006.
After 2006, not 2000.
No, it's a fact.
I think it's
correct, my lord. 2008, this new pension scheme has come.
2008, when was he appointed?
2006, my lord.
What is?
He was appointed earlier, confirmed on 2006.
No.
14/11/2006.
Yes, my lord.
Please.
Are not entitled for pension, and on the other hand, they fall under a different scheme of contributory pension. Next para. At this juncture, learned senior counsel, Sri Divakar, appearing on behalf of the complainant, draws the attention of this court to the memo of calculation filed at the hands of the complainant on 21/10/2024, wherein the respondents are also required to pay gratuity amount of about 20 lakhs and earned leave encashment of 186 days of rupees 16 lakhs 14,852. Learned senior counsel would therefore submit that at least insofar as the gratuity amount and earned leave encashment is concerned, the respondent should be directed to deposit the same before this court at the earliest. Full stop. Next para. Release this matter on 26th of November. Full stop. Whether a review petition would be filed by the respondents or not. The respondents will be required to deposit the amount as requested by the learned senior counsel for the complainant. Full stop. Necessary orders would be passed on the next date of hearing, depending on whether a review petition has been filed and on instructions to be obtained by the learned AAG insofar as the gratuity amount and earned leave encashment is concerned. Yes.
Serial number 7, Ravi B. Patil.
Here.
In this matter, my lord, lordship, last occasion, your lordship directed us to, my lord, what of
yes.
Now, my lord, you issued the letter for attending the counseling on today only at 3 p.m., my lord. That letter I produced, my lord, and if they are eligible for others, my lord, definitely they will, after scrutinizing the documents, my lord, if she is eligible, my lord, further steps will be taken. That is last letter, my
Document
lord.
verification is already been done. We are, my lord, said that, my lord, all our documents are in order. 3 o'clock is, my lord, time fix for giving a allotment of, my lord, post.
Verification also we have to send.
ಅದೇ ಕರೆದಿದಾರಂತಲ್ಲ ಈಗ ಕೌನ್ಸಿಲಿಂಗ್.
Affidavit ಹಾಕ್ಬೇಕು ಸ್ವಾಮಿ ಅವ್ರ ಮೆಮೊ ಹಾಕಿ. Affidavit ಹಾಕ್ಬೇಕು ಮೆಮೊ ಹಾಕಿದ್ರು.
This is the letter admitted.
This is only the to bring the documents on record.
Yes.
It's not a complaints affidavit has not been filed.
Please.
As yet. Learned government advocate has filed a memo along with certain documents, including a communication dated 16/11/2024 made to the complainant calling her for counseling. Full stop.
Today at 3 p.m.
Learned government advocate submits that the counseling will be held today at 3 p.m. Full stop. Next para. Release this matter on 25th of November.
Please. I request you, lord, so first week, because, my lord, after verification the documents, my lord, then, my lord, we will proceed. If this is not eligible, my lord, we will issue the endorsement. That 15 days other bill.
One nimshad.
Verification.
Lord's kind permission. My lord, the candidate. My lord, this is called for counseling today, my lords.
Yes, yes.
Based on the material, based on the certificates which will be furnished by her, verification has to be done, my lord. Sindhutva certificate alla irutte, it has to come from the concerned departments. That will not be within my power, my lords. It is not only for this, even the candidates who are first list candidates, some of them Sindhutva certificate barde idre, or appointment orders issue madiralla Swami now. So I do not want to make a submission that we will finish the process in 2 weeks, my lords. This is the compliance affidavit which we have filed, my lords. In fact, my lords, the order, we have already complied by issuing a communication saying that she is not entitled to. But my lords directed us to consider her case again.
Affidavit has not been filed, these only documents that are filed. You
Please,
want to
please,
file a
please.
complaints affidavit, you please file it then, next.
Please, I bow to my lords. I will, please. Please.
Okay, release this matter on 26th of November. To enable.
My lords, could it be on first week, my lord, so that we will find out what happens today, and we will also guide her as to how to apply and secure.
2nd of December.
Second, please.
Yes.
Please, oblige.
Serial number 8, Prakash R. Kulkarni.
My lord, compliance affidavit is ready, my lord. It may be taken up at 2:30, my lord. I'll file it.
Also.
Please.
Serial number 9, Liaquat Farid Ustad.
Waiting notice, my lord.
Huh?
Awaiting report, my lord.
In service of notice, sir.
Yes, ma'am.
Accused number 1.
Accused number.
Tahsildar.
Yes, ma'am.
Yes, my lord. I will take notice, my lord. This is also same matter, my lord. Last week, my lord, you will also regarding mutation entry. But he given the application to mutate his name only without his, giving the death certificate. That's why, my lord. Same, my lord. You will also pay next week, my lord. I will furnish that document. If he is furnished, my lord, then we'll proceed with we'll file the affidavit of the Tahsildar.
In those other matters,
Yes,
we had directed you to supply a copy of the death certificate.
my lordship, can taken the directions of my senior, my lord.
Huh?
My senior kelkundam.
No, last week these similar matters had come.
Yes, ma'am.
So it was pointed out that you have not furnished a copy of the death certificate of your father. So same thing he is saying in this matter also, it's the same thing. You'll have to furnish a copy of the death certificate.
Yes, my lord.
Similar matters had come up last week.
Please, last week.
So we have given directions to you to submit a copy of the death certificate. Same thing.
Yes, please.
That is, my lord, contempt number 200212 of 2024. You will also pass the order. 212. Last one.
2
of 2024.
Same, is it not?
Yes,
2000212.
Same. Even survey number also same.
Madi,
Same.
we have disposed of.
Yes, you will also be disposed of. my lord.
Has been disposed of.
Disposal.
Learned government advocate takes notice for respondent number 1 ಅಂತ ಹಾಕೊಂಡು 200212 of 2024. Same order. Closed.
Please.
Yes. ಅಲ್ಲಿ learned government advocate submits that similar to the case in CCC number 200212 of 2024, the complainants herein are required to furnish, the complainant herein is required to furnish copy of the death certificate of his father along with the geological tree to consider the representation given. ಅಂತ ಹಾಕೊಂಡು ಅದನ್ನು ಮಾಡಿ.
Please.
Number 10.
All matters are pertaining to the uranium project match. All matters are pertaining to the uranium project match. In this matter, we deposited the 50%, 5 lakhs per acre match along with the interest.
My lord, before that, my lord,
some matters are
serial number 10.7 is wrongly
not
connected. It
dealing
is a
10.7.
It is a matter pertaining to motor vehicle case.
It is MVC matter.
MVC matter is wrongly connected with this matter.
Dealing MFA 200485 of 2023 from these matters.
Please. In serial number 10, my lordship, I take grant 1 week time to I take steps, my lordship. And 10.1, my lordship, I complied the office objections but affidavit is not filed, my lord. 1 week time may be granted. And 10.2 and 10.3, my lord.
ಲಾಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಇದನ್ನ ನೋಡ್ಕೊಂಡು ನೀವು ಈಗ ಸೀರಿಯಲ್ ನಂಬರ್ 10 ನಲ್ಲಿ learned counsel for the appellant submits that the correct address will be furnished. Correct address for service of notice on respondent number 1 will be furnished along with the necessary process within
1 week. 1 week.
ಆಗುತ್ತಾ?
ಆಗುತ್ತೆ. ಕೊಟ್ಟಿದ್ದಾರೆ ಅಡ್ರೆಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
Within a week's time. Stop. Next paragraph. If steps are taken, notice may be issued to respondent number 1. ಮತ್ತೆ ಇಲ್ಲಲ್ಲಿ ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ. Next para, learned counsel for the appellant would also submit that the office objections raised in several of these matters will be complied.
Complaint. Court fee is paid. Court fee ಕೊಟ್ಟಿದೀವಿ ಎಲ್ಲಾದ್ರಲ್ಲಿ.
Within a week's time.
Please.
All right.
And 10.8, my lordship. 10.8, stay may be granted as per the 10, my lordship. 10.8.
ಸ್ವಾಮಿ ಸ್ಟೇ ಮೇಂಟೈನಬಲ್ ಸಮ್ ಜಜ್ಮೆಂಟ್ ಆಗಿದ್ದು ಅವ್ರ ಅಮೌಂಟ್ ತುಂಬಿದ್ರು ಸ್ವಾಮಿ ಹಿಂದೆ ನಾ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮೆಮೊ ಹಾಕಿದ್ದೇನೆ ಇವಾಗ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮೆಮೊ ಹಾಕಿ ಸರ್
ಕ್ಯಾಲ್ಕುಲೇಷನ್
ಇದರಲ್ಲಿ ಅಮೌಂಟ್ ಕಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ ಅವರು
50% ಡೆಪಾಸಿಟ್ ಮಾಡ್ತದಾರಲ್ಲ
ಇಲ್ಲ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ ಇದು ಹಿಂದಿನ
ಮಾಡ್ತಾರಮ್ಮ ಇವಾಗ ಡೈರೆಕ್ಷನ್ಸ್
5 lakhs already some landlords are taken away amount, my lordship. ತಗೊಂಡಿದ್ದಾರೆ ಅಮೌಂಟ್ ತಗೊಂಡಿದ್ದಾರೆ some landlords are
ಅದರಲ್ಲೇ ಇನ್ನೂ ಅಮೌಂಟ್
ಡಿಪಾಸಿಟ್ ಮಾಡಿ ಅಮೌಂಟ್ ಕೊಟ್ಬಿಟ್ಟಿದೀವಿ.
ಯಾವ್ದ್ರಲ್ಲಿ?
ಕಡಿಮೆ ಅಮೌಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಎಲ್ಲದರಲ್ಲಿ ಮ್ಯಾಟರ್ ಎಲ್ಲ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ
ಕಡಿಮೆ ಅಮೌಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
10.8
ಅಲ್ಲಿ ಇದರಲ್ಲೂ ಮಾಡಿದೀವಿ. ಇನ್ ಆಲ್ ಮ್ಯಾಟರ್ಸ್ ಯು ಡಿಪಾಸಿಟ್ ಮಾಡಿದೀವಿ. ಕೆಲವೊಂದು ಲ್ಯಾಂಡ್ಲಾರ್ಡ್ಸ್ ಅನ್ನು ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಇದು 10 ಇನ್ನು ರಿಮೈನಿಂಗ್ ಮ್ಯಾಟರ್ ಸರ್
ಅವರು ಅಲ್ಲ ಸ್ವಾಮಿ ನಮ್ದು ಮೆಮೊ ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಸರಿ ಇಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. ಅವ್ರದ್ದು ನಾವು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿದ್ದು ಸರಿ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ರಿಜೆಕ್ಟ್ ಮಾಡ್ಬೇಕು ಸ್ವಾಮಿ ಅದು ಯಾಕಂದ್ರೆ ಅವ್ರು ಅಮೌಂಟ್ ಕಟ್ಟಬೇಕು ಅಷ್ಟು 4,40,000 ಕಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ 10 lakhs ಆಗಿತ್ತು ರಿಮೈಂಡಿಂಗ್ ಆದ್ಮೇಲೆ 8 ಲಕ್ಷ ಆಗಿದೆ. 8 lakhs ಪ್ರಕಾರನೇ ಅವ್ರು ಕಟ್ಟಿಲ್ಲ ಇನ್ನು ಅಮೌಂಟ್. ಇವೆಲ್ಲ ಮೆಂಟಲೇಬಲ್ ಆಗಲ್ಲ ಸ್ವಾಮಿ ರಿಜೆಕ್ಟ್ ಮಾಡ್ಬೇಕಂತ ನಮ್ಮ ಪ್ರೇಯರ್. ಅಮೌಂಟ್ ತುಂಬಬೇಕು ಅವ್ರು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಅಮೌಂಟ್ ಹಾಕಿಲ್ಲ ಅವರು. ಇಲ್ಲ ಸ್ವಾಮಿ ಹಾಕಿಲ್ಲ ಸುಮ್ಮನೆ ಅಂಜಾದ್ಮೇಲೆ
ಇಲ್ಲ 10.8 ಅಲ್ಲಿ ಅವ್ರು ಇಲ್ಲ ಸ್ವಾಮಿ.
10.2
ಒಂದು ನಿಮಿಷ ಯಾವ್ದಮ್ಮ ನಿಮ್ದು
10.2 10.2 14 ಮ್ಯಾಟರ್ ನಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ
ಯಾವ್ದಮ್ಮ ನಿಮ್ ಮ್ಯಾಟರ್ ಯಾವ್ದಮ್ಮ?
ಸೀರಿಯಲ್ ನಂಬರ್ 10
ಸೀರಿಯಲ್ ನಂಬರ್ ಏನು?
ಸೀರಿಯಲ್ ನಂಬರ್ ಇಲ್ಲ ಅಂತಂದ್ರೆ ಕೇಸ್ ನಂಬರ್ ಹೇಳಿ.
10.10 ಅಲ್ಲಿ ಸ್ವಾಮಿ
10.10 ಸ್ವಾಮಿ
10.10
ಇಲ್ಲ 10.3 11 15 ಮ್ಯಾಟರ್ಸ್
14 10.16 ಅಲ್ಲಿ ಆಗಿದೆ.
15 cases 8 9 10
ಅದು ಯಾವ್ದು ನಂಬರ್ ಕೇಳ್ರಿ ಅದು ಯಾವ್ದೆಲ್ಲ ಹಾಕಿರ
204264
10.9
10.10 ನಾವು
ನಿಮ್ ಪ್ರಕಾರ 43 lakhs
yes sir
92,375
ಹೌದು ಸರ್ ಹಾಲ್ ಕೇಸಸ್ ಇದು 5 ಕಾರ್ಡ್
MFA ನೀವು ಇದರಲ್ಲಿ ನೋಡ್ಕೊಳ್ಳಿ ನಿಮ್ಮ ಇದರಲ್ಲಿ MFA 204264 10.11 ಫೈಲ್ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ?
ಇದೆ ಸರ್
ಫೈಲ್ ಇದೆಯಾ? ಎಷ್ಟು ಅಮೌಂಟ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದೀರಾ? ಅವ್ರ ಪ್ರಕಾರ total 92 lakhs 124. ಅದರಲ್ಲಿ
LIC
50%
that is
ಅಂತಂದ್ರೆ
the LIC 27, my lordship. 17 of 14. LIC 17 of 14.
Correct.
We deposited 48 lakhs, 48 lakhs, 7, 48, 7,
7749.
please, my lordship.
ಮಾಡಿದಾರಲ್ಲಮ್ಮ.
ಅಮೌಂಟ್ ತುಂಬಕ್ ಸಮಯ ಅದು ಅಂಜಾದ್ಮೇಲೆ ಕಟ್ಟಿದಾರೆ ಸರ್.
The amount paid, my lordship.
ಅಂಜಾದ್ಮೇಲೆ ಅಮೌಂಟ್ ತುಂಬಿದಾರೆ ಸರ್ ಅವ್ರು ಅಂಜಾದ್ಮೇಲೆ ತುಂಬಿದಾರೆ ಸರ್ ಈ ತರ.
ನಿಮ್ಮ ಇದ್ರ ಪ್ರಕಾರ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಪ್ರಕಾರ
ಇಲ್ಲ ಸಮಯ ಇದು ಇನ್ನು ನಮಗೆ 40 lakhs 71 lakhs ಬರ್ಬೇಕು ಸಮಯ ಇದರಲ್ಲಿ. ಅವರು 4 ಎಕರೆ 27 ಗುಂಟೆ ಇದೆ.
50% ಡೆಪಾಸಿಟ್ ಮಾಡಕ್ ಹೇಳಿರೋದು ಮಾಡಿದ್ದಾರೆ.
ಇಲ್ಲ ಸರ್ ಮಾಡಿಲ್ಲ ಸರ್. ಅವ್ರು 50% 10 lakhs.
ನೀವೇ ಹೇಳಿದ್ರಲ್ಲ
My lordship.
ಸಮಯ 50% 10 lakhs ಅಲ್ಲಿ
Actually, it is to
50%
be
ಆಗಿದೆ
10 lakhs. After remand, 10 lakhs award ಆಗಿತ್ತು ಸ್ವಾಮಿ. We challenge it.
By the
First we
SLA.
challenge the award, my lordship.
by the SLA.
Please, my. ಇಲ್ಲ reference court award.
Enhancement.
Enhancement 10 lakhs ಆಗಿತ್ತು. ಅದನ್ನ ನಾವು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀವಿ. ಅದು ರಿಮೈಂಡ್ ಆಯ್ತು. ರಿಮೈಂಡ್ ಆಯ್ತು ದಿಸ್ ಆನರಬಲ್ ಡೈರೆಕ್ಟೆಡ್ ದಟ್ ಯು ಡಿಪಾಸಿಟ್ 5 lakhs per acre ಅಂತ ಮಾಡಿದ್ರು. ಆಸ್ ಪರ್ 5 lakhs ಯು ಡಿಪಾಸಿಟೆಡ್. ಆಫ್ಟರ್ ರಿಮಾಂಡ್ ಇಟ್ ಇಸ್ ಟು ಬಿ 8 lakhs ಆಗಿದೆ ಇವಾಗ. ನಾವು ದಿಸ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್.
In next para. In all these matters, the learned counsel for the appellant is directed to file memo of calculation to show what was the award amount and enhanced award amount and what is the amount deposited by the appellants in terms of the directions issued by this court. Please file it, we will see.
In 10.8, stay as per the 10 mileage, stay may be granted.
ಅಮೌಂಟ್ ಆಯ್ತು ಸರ್.
Issue notice to 1 and 2 and government is 10.8.
10.8 ಅಲ್ಲಿ
Government is 3 and 4.
the government advocate takes notice for response number
3 and 4.
3 and 4.
1 and 2 notice one.
ಅದೇ 2 and 3. 2 and 3. Issue notice to respond number 1.
Please.
Serial number 10 ನಲ್ಲಿ
Granted.
ಏನ್ ಡೈರೆಕ್ಷನ್ಸ್ ಇಶ್ಯೂ ಮಾಡಿದೀವಿ ಟು ಡೆಪಾಸಿಟ್ 50%. ಅದನ್ನ ನೋಡ್ಕೊಂಡು ಅದನ್ನ ಮಾಡಿ.
My lord.
And serial number
10.8 ಮತ್ತೆ
10.9
10.9
and
ಮತ್ತೆ ಇದು
10.15 my lords. 10.15.
10.15
15 and 10.5 10.21.
ಅವ್ರಿಗೆ ಲಿಸ್ಟ್ ಕೊಟ್ಬಿಡಿ ಯಾವ್ಯಾವ್ದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋದು ನಾನು ಕೊಟ್ಬಿಟ್ಟು
Please.
ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ ಸರ್.
Please.
10.21 ಇಲ್ಲಿ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿಲ್ಲ ಸರ್.
ಇಲ್ವಂತೆ ನೋಡಿ. ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ ಅಂತಂದ್ರೆ ಒಂದು ಮಾಡಿಸ್ಕೊಟ್ಬಿಡಿ.
Please.
ಸಮಯ ನಾವು ಡೀಲಿಂಕ್ ಮಾಡ್ಬೇಕು. ಡೀಲಿಂಕ್ ಮಾಡ್ಬೇಕು ಸರ್ ನಮ್ಮ ಕೇಸ್. ಇವು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇವು ನನ್ನ ಹೆಸರಿದ್ದು ಸರ್ ವೈ ಅರುಂಧತಿ ನಮ್ಮ ಡೀಲಿಂಕ್ ಮಾಡ್ಬೇಕಂತ ತಿಳ್ಕೊತೀನಿ ಸರ್.
ಯಾಕೆ
ಇದರಲ್ಲಿ ಅವರು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿಲ್ಲ ಸರ್. ಇವು 50% ಆರ್ಡರ್ ಆಗಿತ್ತು ಹಿಂದೆ ಸ್ವಾಮಿ. ಈಗ ಅವರು 25% ಆರ್ಡರ್ ಆಗಿದೆ ಉಳಿದ ಕೇಸಲ್ಲಿ. ಇವ್ರು ಸಫರ್ ಆಗ್ತಾರ ಸರ್. ಪ್ಲೀಸ್ ಸರ್ ನಾವು ಡೀಲಿಂಗ್ ಮಾಡಕ್
submission.
whatever orders were passed in serial number 10, same orders will be passed in every matter.
My lord.
ಸರ್ ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ ಸರ್. ಇವ್ರು ಸಫರ್ ಆಗ್ತಾರೆ ಸರ್. ಬೇರೆ ನಾವು ಸಫರ್ ಆಗ್ತೀವಿ ಸರ್ ಅದರಲ್ಲಿ. ಈಗ ಎಲ್ಲ ಎಟ್ ಎ ಟೈಮ್ ಆರ್ಡರ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ. ಇದರಲ್ಲಿ 10 lakhs 6 lakh ಈ ತರ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕ್ಲಾರ್ದೆ ಅವ್ರು ಆರ್ಡರ್ ಆಗಿದೆ ಕೆಲವೊಂದು ಸ್ವಾಮಿ. ನಮ್ಮ ಏನದ ಡೀಲಿಂಗ್ ಮಾಡ್ಬೇಕಂತ
There is some our prakara what they have deposited is 50%. That is why we have directed them to file memo of calculation. We will see.
In serial number 10.23 and 10.32, my lord, I am appearing on behalf of in 10.23 respond number 1 to 7, my lord, and
10.23.
Please, my lord, and 10.32 SV Pareddi, my lord.
ಬಂದಿದೆಯಲ್ರಿ ಹೆಸರು?
ಬಂದಿದೆ ಸರ್. And my lord, the claimant here, the respondent number 1 and 1 to 7, they have also filed an appeal, my lord. Serious case are there, my lord. Kindly connect all this.
Subjections file ಮಾಡಿದಾರಾ?
ಇಲ್ರಿ MF
ಅವರೇ ಸೆಪರೇಟ್ ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಿದಾರಾ?
ಹೌದು ಸರ್.
ಕೊಡಿ. Learned counsel Shri SP Paraddi. submits. Several of the claimants have also filed MFAs and therefore it is submitted that those MFAs are also required to be clubbed and heard with these matters.
Some are from stages of compliance, my lord, and complaint.
Office is directed to list totally in these matters along with this. Relist these matters on 2nd of December.
Sure.
Yes.
Hearing on again, CL number 11, BM Geraldine.
Limits for enhancement in case of the death.
Huh?
2 cases are death cases. But all criminal has considered only for 36,000, 3,000 rupees. As per Lokada Schedule, 5,500.
List for Tokyo. Huh? Dismiss of it. ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದ್ದು ಕೊಟ್ಟಿನಿ. ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದು ಹಾಕಿದ್ದೀನಿ. ಅಕ್ಲಾಜ್ಮೆಂಟ್ ಆಗಿದ್ದೀನಿ. ಹೌದು ಸರ್, ಅದು ಇದು ಆಗಿದೆ. ಈಸ್ ಪ್ರೀವಿಯಸ್ ಅಡ್ವೊಕೇಟ್ ಗೌರ್ಮೆಂಟ್ ಎಂಪ್ಲಾಯ್ಡ್ ಆದ್ಮೇಲೆ ಅವರು ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಿಲ್ಲ. ಆಫ್ಟರ್ 10 years ಅಪ್ಡೇಟ್ ಹಂಗೆ ಬರ್ದೀವಿ ಸರ್.
Every application for condonation of delay.
My advocate appointment as a High Court government pleader during the interval of the appeal was instead of dismissal 23/10/2013
delay
on account of undead.
ಅದಕ್ಕೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿಲ್ವಾ? ಏನ್ರಿ ಆ ಮೈನ್ ಮ್ಯಾಟರ್ ಅಪೀಲ್ ಫೈಲ್ ಮಾಡುವಾಗ್ಲೂ ಡಿಲೇ ಅಂತಾರಲ್ಲ.
ನನಗೆ ಈಗ ಬಂದಿದೆ DNP ಆಗಿ ಆಗಿದ್ಮೇಲೆ ನಾನು ವಕಾಲತ್ ಆಫ್ಟರ್ DNP ಆದ್ಮೇಲೆ ನಾನು ಹಾಕಿದ್ದೆ. ಬಿಫೋರ್ ನನಗೆ ಪ್ರಿವಿಯಸ್ ಅಡ್ವೊಕೇಟ್ ಬೇರೆ ಇತ್ತು.
ನಾವು ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ, ಹಿಂಗೆಲ್ಲ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. ನೀವ್ ಯಾವಾಗ್ಲೂ ನಿಮ್ ಇಷ್ಟ ಬಂದಂಗೆ ಎದ್ದು ಆಯ್ತು ನಾವು ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬಿಟ್ರೆ ರೀಕಾಲ್ ಮಾಡ್ಬಿಡ್ತಾರೆ, ಹಂಗಲ್ಲ ಆಗೋದಿಲ್ಲ. ವಿಲ್ ಹ್ಯಾವ್ ಟು ಇಂಪೋಸ್ ಕಾಸ್ಟ್. ಇಷ್ಟೊಂದೆಲ್ಲ 4140 days ಡಿಲೇ.
ಪ್ರಾಬ್ಲಮ್ ಅದೇ ಅಡ್ವೊಕೇಟ್ ಆದ್ಮೇಲೆ ಅವ್ರಿಗೆ ಇವ್ರಿಗೆ ಕಾಂಟ್ಯಾಕ್ಟ್ ಅಪ್ಡೇಟ್ ಆ ಟರ್ನ್ ಹಾಕಿದ್ವಿ.
ನೀವು ಕಟ್ಟಾಗಿದ್ರೆ ನೀವೇ ಕಟ್ಟಿ ಕೈಯಲ್ಲಿ. ಯು ಹ್ಯಾವ್ ನೌ ಟೇಕನ್ ಅಪ್ ದಿ ಮ್ಯಾಟರ್ ಆಸ್ ಇಫ್ ಇಟ್ ಇಸ್ ಎ ಈಸಿ ಕೇಸ್, ಕಂಡೋನ್ ಮಾಡಿಸ್ಬಿಡ್ತೀನಿ ಡಿಲೇ ಅನ್ಬಿಟ್ಟು. Who is going to accept this kind of a explanation? You pay cost then. ಅಲ್ಲಪ್ಪ ಇದ್ರದ್ದು ಈ ಅಪ್ಲಿಕೇಶನ್ ಜೊತೆಗೆ ಕಂಡೋನೇಷನ್ ಆಫ್ ಡಿಲೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿಲ್ವಾ ನೀವು?
ನಾವು ಹಾಕಿದ್ವಿ, ರೀಸೆಂಟ್ಲಿ ನಾವು ಹಾಕಿದ್ವಿ, ಬಟ್ ಮೇನ್ ಅಪೀಲ್ ಹಾಕಿಲ್ಲ ನಾನು.
Order on IA number 1 and 2 of 2024. These applications are filed by the appellant seeking to recall order dated 23/1/2013, whereby the appeal was dismissed for
not taking steps.
Office
objection ಮಾಡಿಲ್ಲ,
non-compliance of office objections. Stop. And seeking condonation of delay of 4140 days in filing the application. Full stop. It is stated in the affidavit accompanying the application for condonation of delay that the learned counsel on record was appointed as High Court government pleader, and he was not aware of the fact that the appeal was dismissed for non-compliance of office objections. Full stop. Unfortunately, the appellant had also changed the mobile cell phone number, and therefore the learned counsel was not able to contact the appellant. Full stop. It is stated that the appellant has a good case on merit, and after the death of the appellant's father, the appellant is suffering, both financially and for non-financial reasons. Full stop. Learned counsel submits that for no fault of the appellant, the appellant should be punished. Full stop. Next para. Although we are not satisfied with the explanation offered having regard to the huge delay of 4140 days, nevertheless, we are of the considered opinion that the delay is required to be condoned while imposing costs. Full stop. Accordingly, we proceed to allow the applications while condoning the delay by imposing cost of rupees 2,000 on the appellant payable at the payable to the High Court Legal Services Committee, Kalaburagi bench, within a period of 1 week from today. Full stop. The order dated so-and-so is recalled while restoring the appeal to its original file. Full stop. Next para. We see that one of the office objections raised when the appeal was filed was that no application for condonation of delay of 110 days was filed. Raise ಮಾಡಿಲ್ವಲ್ರಿ? One nimsha. Full stop. Therefore, we grant 2 weeks time to the appellant to file necessary application and comply all the other office objections.
Talu same. Same. Talu same.
Same. 3750 days. Order dated 17/2/2014.
Yes.
All right.
Seal number 13, Santosh Kumar Maradi.
Yes.
Item number 13, my lord.
Yes.
This your lordship had heard last week, a couple of days back. Your lordship had directed me to file an memo and produce the notification as well as the objections filed by the National Highway Authority before the reference court. This is an accusation under the Land Acquisition Act, where a reference was made by the claimant. And my lord, pending the reference, the National Highway Authority was impleted on the ground that the state highway was upgraded as a national highway, and thereafter, my lord, it was entrusted by the central government under the National Highways Act to the National Highways Authorities Act.
Yes, yes.
Our contention, my lord, has always been that we are not liable to pay because it's an acquisition that has been done by the state government under the Land Acquisition Act. Awards were complied with.
Yes.
Yes, therefore, my lord, the notifications I have produced by virtue of a memo. My lord, the written statement I have annexed. My lord, in page number, my lord, it is at page number 6 of my memo. I hope the memo is with your lordships. My friend, my lord, my colleague is there in the court. He has handed over.
14 ಫೈಲ್ ಮಾಡಿದ್ರು 13 ಫೈಲ್ ಮಾಡಿದ್ರು
13 ಅಲ್ಲೂ ಮಾಡಿದ್ದೀನಿ
13 ಅಲ್ಲಿ ಇಲ್ಲ
ಮಾಡಿದ್ದೀನಿ 15ನೇ ತಾರೀಕು ಮಾಡಿದ್ದೀನಿ
ಹೋಗೋ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಕಾಪಿ ಕೊಡಿ
ಅದಲ್ಲ ಇದು ಕಂಪ್ಲೇಂಟ್ ಇದ್ರದ್ದು ಡೆಪಾಸಿಟ್ ಸ್ಟಾಪ್ ಆಗಿಲ್ವಾ?
ಡಿಪಾಸಿಟ್ ಹಾಕಿಲ್ಲ
ಸ್ಟಾಪ್ ಆಗಿಲ್ಲ. ಯಾವಾಗ ಫೈಲ್ ಮಾಡಿದ್ರಿ?
15ನೇ ತಾರೀಕು 15ನೇ ತಾರೀಕು
15
13 sign, the 201025.
20102, my lord, 28. I'm.
Serial number 14.
Yes, my lord.
Serial number 14, my lord, file.
But we have filed a memo. I am a little confused regarding the numbers. 201028 of 2019. My lord, we have filed the memo. There your lordship had passed an order directing us to produce certain documents. That is one, the objections filed by us before the reference court, and also the notification whereby the central government had conferred, my lord, given the property for the highway, sorry, highway for management to the National Highway Authority, my lord. Those two notification as well as the written statement has been produced in the memo. Lord, I have also produced, my lord, the reference, that is a petition filed by the claimant before the reference court. Your lordship will get my written statement at page number 6 of the memo, my lord. Did your lordship get it, my lord?
Yes.
May I read, my lord, paragraph 1 onwards? At the outset, this defendant submits that the present suit claiming enhanced compensation pertains to the lands acquired from the plaintiff situated in so-and-so, situated in Sindagi village for laying highway between so-and-so, passing through so-and-so. As per submission of the plaintiff, the award in question for the land acquisition was passed on 23/7/2006. The plaintiff has claimed that compensation awarded is too low and not commensurate with the market value of the land. Acquisition officer has not valued the property properly. In this contention, the plaintiff that the land consists of rich, that is regarding the my lord, the merits we are submitting. My lord, 4 is important, my lord. The submission of the plaintiff is misconceived and liable to be dismissed as against defendants number 1, as no land has been acquired by National Highways Authority of India for laying highway between so-and-so, passing through so-and-so. The acquisition of land was done by the Assistant Commissioner and LAO-ND, coming under the state government for construction of a ring road for state highway. The state highway has been renamed as National Highway 218, new 50, possession of which is handed over to the defendant only in the year 2013-14. Hence, this suit against defendant number 1 is misconceived and not maintainable and liable to be dismissed with cause. Lord, this was our contention before the reference court. Lord, no consideration of this contention. My lord, nothing is discussed. The learned judge says that he's considered the merits of the matter and then said that enhanced compensation is payable by the defendants. That is the order. But my lord, according to us, we are not liable to pay for various reasons, my lord. Because first of all, this is an acquisition. Your lordship will appreciate, my lord. This is an acquisition which was done for which preliminary notification under Section 4(1) of the Land Acquisition Act was made in 2010-2003. 2010-2003, and in my lord, in 26/5/2004, this Section 6 notification was issued. My lord, general award, my lord, was passed on 10/5/2005. And 24/6/2005, my lord, award notice to the respondents and claimants. Therefore, my lord, the award was complied with by the state government. My lord, 12/9/2005, my lord, claimants filed a reference under Section 18. My lord, thereafter, my lord, somewhere in 2000s, then, my lord, we were impleaded. In the month of August 2008, we were impleaded. We filed our objections stroke written statement against the claim. My lord, the order was passed on 12/3/2009. My lord, various awards were challenged and then various orders were passed. But in this, my lord, in this appeal, 12/3/2019, the award was passed. My lord, when the reference was made, my lord, we were not made parties to the reference. Only when the notification came, my lord, that notification your lordship will get, my lord, at page number 25-26, my lord, that is. The notification was published on 31/3/2015 under Section 11 of the National Highways Act. Lordship will get the English translation, my lord, on page number 27.
Order in that other matter.
14.3, my lord.
14.3.
Order is already passed on 14.3 matter. 202-158.
They have not objected. Government has not objected.
One submission, my lord, in this matter, my lord. He has not appeared before the, my lord, reference court, appeared but not adduced the evidence and not produced any document. Now, my lord, is producing along with the memo. But if he is produced along with the IA, my lord, if it is produced along with the IA, my lord,
Written statement was filed.
written statement is filed, my lord, he has to produce the document to show that, my lord, when it is handed over, that is.
What was your stand, sir?
That's why, if he is produced, my lord,
ಏನಾಗಿದೆ ಅಪೆಲೆಂಟ್ಸ್ ಕ್ಲೈಮೆಂಟ್ಸ್ ಅವ್ರ ಪಾಡಿಗೆ ಅವ್ರು ಹಾಕೊಂಡಿದ್ದಾರೆ. ನೀವು ಯು ಆರ್ ನಾಟ್ ರೈಸ್ಡ್ ಎನಿ ಅಬ್ಜೆಕ್ಷನ್ ಸ್ಟೇಟಿಂಗ್ ನೋ ವಿ ಆರ್ ನಾಟ್ ಲಯಬಲ್, ಇಟ್ ಇಸ್ ದಿ ನ್ಯಾಷನಲ್ ಹೈವೇಸ್ ಅಥಾರಿಟಿ ಅಂತ ನೀವು ಏನ್ ಸ್ಟ್ಯಾಂಡ್ ತಗೊಂಡಿಲ್ಲ.
ನಮ್ದು ಅಬ್ಜೆಕ್ಷನ್
ಫಸ್ಟ್ ಟೈಮ್ ಯು ಆರ್ ಆಲ್ಸೋ ಮೇಕಿಂಗ್ ಸಮ್ ಸಬ್ಮಿಷನ್ಸ್ ಹಿಯರ್.
If it is so, my lord, definitely we are going to challenge that order, my lord, that reference court award. Now, my lord, time is already, my lord, lapsed. This is, my lord, passed long back, my lord, order. But because they filed the appeal, my lord, we kept quiet.
No, our appeal, my lord, my friend will appreciate, my lord, my appeal is not on quantum. My appeal is on my liability. My liability, my lord, when I say I am not liable, should they not challenge the quantum, my lord? The award has been satisfied by them.
19/11/2018, my lord, order, reference order, my lord, award is passed.
Lord, it's too late in the day for the state to say that we should not have, we should have produced it before the reference court, because there was no issue regarding the notification. The state didn't raise any objections. State didn't say anything. State only challenged the quantum. And as I understand it, my lord, they are only entitled to challenge the quantum. They cannot challenge the liability. And if they wanted to challenge the liability, they should have made a plea that they are challenging the liability in view of the transfer, the declaration of this highway as national highway. And they should have claimed it, my lord, first from the central government before it was entrusted to us.
ಫೈಲ್ ಕೊಡ್ರಿ MFA 202158.
And the provisions of the CPC will apply, my lord. I am entitled to produce a document under Order 41, Rule 27 before the appellate court, if it is a material document which I did not produce before the trial court.
Now you please see the award.
Please.
Is there any specific direction that National Highways Authority are doing?
Respondents, my lord, respondents is directed. Respondents,
correct. How did you shirk your responsibility, sir?
But that is true, my lord. Our understanding that, my lord,
how can you now pass on the blame to them?
That's why, but
how did you take it for granted that they are responsible?
That's why, I am requesting lordship, my lord, remind this matter to the reference court to decide this issue, whether, my lord, they are liable or not.
My lord, after all these years, they have not challenged, they have not filed an appeal.
Even I also produced the document to show that, my lord, it is handed over to them also.
Correct.
But even opportunity will be given to us also, my lord, before the reference court, but defend that our case also. Now, my lord, if we,
Where have you taken that stand, sir? In your statement of objections or written statement?
but that's,
Have
I,
you stated not, we are not liable, they are to pay the new, where have you taken the, when that stand? Let us see.
records,
Idin records ಇದೆಯೇನ್ರಿ?
records,
Records ಬಂದಿದೆ sir.
ಇದೆ. ಅವ್ರದ್ದು ಇತ್ತಾಗಿರಿ. ಅವರು SLAO ಸ್ಟೇಟ್ ದ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಯಾರಾದ್ರು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ರೆ ತೆಗೀರಿ.
The objection statement.
1, 3 and 4.
ಮಾಡಿ. ಅದೇ they have specifically taken that stand. ತೋರಿಸಿ ಅವ್ರಿಗೆ.
they taken that, my lord, our objection, my lord, that,
ನಿಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್
ಅಲ್ಲ, ನಮ್ಮ objection.
ಅಲ್ಲಿದೆ ತೋರಿಸ್ಕೊಡ್ರಿ ಅವ್ರಿಗೆ. ಸೈಕ್ಲೋ ಸ್ಟೈಲ್ ಕಾಪಿ ಅಷ್ಟೇ, ಏನು ಇಲ್ಲ ಅದ್ರಲ್ಲಿ.
Even evidence.
When they have taken that stand specifically, it was your duty to say no, or it was for you to place material. ಏನು ಇಲ್ಲ ಬಿಡಿ ಅದ್ರಲ್ಲಿ, ಇದ್ರ ಬಗ್ಗೆ ಏನು ಇಲ್ಲ, nothing is there.
Now, my lord, I will lose the, my lord, that definitely delay will come in our way.
How did you
Regarding
take it for
quantum
granted?
also, my lord, even quantum also, we have to challenge this reference order, my lord. Award also we have to challenge. Now, my lord, any of the, my lord, National Highway filed this appeal, we kept quiet.
But it will be too harsh on the appellant to say that they want to file
No,
an
no.
appeal. Yes.
Since nothing has been said in respect of the stand taken by you in your written statement.
Yes.
By the reference court.
Correct, my lord.
The learned government advocate is saying remand the matter, let them
My lord,
reconsider.
my lord, then may I argue on pure question of law, my lord? It is a land acquisition.
Yes.
Now, under a land acquisition, my lord, whose duty it is to pay the amount? The acquisitioning authority. Who is the acquisitioning authority here, my lord? The state government is the acquisitioning authority. The state government, the deputy commissioner is liable under 31 to pay the compensation. My lord, that has been held by the Honorable Supreme Court in Hisar Development Trust. Therefore, my lord, my liability doesn't come at all.
There are
That
many
is a
other
legal
judgments of the
question.
Supreme Court which has been placed into service in other matters.
Yes.
KNNL, Kaveri Niravari Nigam Limited,
Yes, yes, my lord, yes.
has taken a stand that we are responsible, but we were not given an opportunity.
My lord, then, my lord, the first
Totally
opportunity
different
comes.
stand, taken there.
My lord, the first opportunity comes to file an appeal.
They have filed application. On this basis, he was repeated. Order on 210 filed by state government.
ಅಲ್ಲೂ ಹಂಗೆ ಆಗಿದ್ದಾರೆ.
Was not the
Initially,
party.
they were not made a party.
They are impleading.
In impleading application,
Pleading
when
ಹಾಕಿರೋದು.
the government pleader,
Same pattern, my lord. There has to be a consistent view. Either, my lord, they are liable, my lord, in both the cases, or, my lord, they are not liable.
No. It depends on facts, sir. How can you say in everything it should be?
ಯಾಕಂದ್ರೆ ಅದರಲ್ಲೂ ಇನ್ಕ್ಲೂಡಿಂಗ್
The stand taken by KNNL is totally different from what stand is taken by the National Highways Authority of India. You can't,
no,
There is no issue,
can't
my lord.
equate the
Yes,
same.
no, my lord, on this,
You
my
can't
lord,
equate the two.
yes, my lord, on this, my lord, issue, my lord, my, my lord, understanding is, my lord, the liability of the National Highway Authority is not contractual, it's, my lord, statutory. My lord, 1988 Act, if your lordship sees, my lord, they have produced a notification saying that we were entrusted with the National Highway. This,
In terms of
this,
section 11.
this section, my lord, by virtue of section 11. Lordship, may see, my lord, what is the consequence of entrustment under section 11 that is mentioned in section 12?
Transfer of assets and liabilities.
Yes, in that, my lord, Section, my lord, section 12, my lord, subsection 1, clause D would be, my lord, relevant. The consequences of such entrustment is, my lord, all suits and other legal proceedings instituted or which could have been instituted by or against the central government.
You please see section 11 carefully.
Yes. Power of the
We have
central.
considered this one. We
Well,
have passed
my
order.
lord, that's the difficulty, my lord. It's all-
ಏನಾಗಿದೆ ಇಲ್ಲಿ? No. Please read that. It says central government will transfer.
How?
Central government will issue a notification.
How?
How central government will get powers in respect of this property? Therefore, it is very clear that would happen only in cases where the central government has issued notification.
Look, here it is issued.
Central government notification for acquisition.
No, that is not notification.
Please read section 11.
Yes, I'll again, my lord.
Yes.
Power of central government to vest or entrust.
From where will the central government get this
I'll
power?
just read this, my lord. Power of the central government to vest or entrust any national highway in the authority.
Correct.
The central government may, from time to time, by notification in official gazette, vest in or entrust to the authority such national highway or any stretch thereof as may be specified in such notification. This is not notification of acquisition. This is a notification of entrustment or.
Correct.
So, my lord, now this
is such notification.
Yes, this is a case where, my lord, there is entrustment.
Where the land is acquired by state government. From where will the central government get that power to entrust it? So it necessarily pertains to lands which belong to the central government. Section 12 also. Transfer. Notifications here have been issued under section 11 first.
Look,
So our question to you is,
yes,
we have considered this, that is why we are asking you.
No, that's.
From where will the central government get the power in respect of land belonging to the central state government?
No, that is for the central government to answer, my lord, but the notification
Not
is
to
issued.
answer, sir, it is very clear. This is flowing from this provision. Central government can do it because it is only in respect of the property belonging to the central government. From basically, how is it that the central government can issue notification in respect of a land belonging to the central government, state government?
Your lordships, my lord, mean to say that central government in this situation could not have issued section 11 notification.
No. Don't misstate us.
Sorry,
Or misquote us.
no,
What
no,
we are
I'm not-
saying is, this provision would enable the central government to issue notification in respect of lands belonging to the central government, notified by the central government,
Yes.
to be entrusted to the national highways for maintenance.
Yes, your lordship, kindly turn to, my lord, page 23 of their memo dated, my lord, 15/11/2024. Lord, I'm referring to, my
The
lord,
notification issued under section 11.
ಹೌದು ಇದರಲ್ಲಿ this very stretch, my lord, is entrusted.
Correct, sir. Our question therefore to you is, we have considered this section 11, that is why that would be entrustment by the central government for maintenance. Here, the question is,
Lord, may I put it this way, my lord? My lord, what is the consequence of entrustment is one part. Whether it is entrusted rightly or wrongly, that's another part. Whether entrustment has taken place or not is another part. The last of the criteria, my lord, is met. Entrustment has taken place. Whether it is done rightly or wrongly, my lord, it is between the central government.
no, rightly or wrongly,
If
we
it is-
cannot go into all those questions.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಯಾಕಂದ್ರೆ
It's a
once
notification issued by the central government under section 11.
Yes.
Aita? From where did the central government get this property?
from the
How?
state,
How?
yes.
That is why we are asking the state.
ಅಲ್ಲ, ನಾನು ಒಪ್ಪದೆ ಸ್ವಾಮಿ, but my concern is, my lord, I'm
You
on.
have no difficulty, sir. You have the right to make any claim as against the state government. You will not be prejudiced. Yes.
But kindly say, my lord, even, my lord, after filing their return statement before the reference court.
ನೀವೇ ಅಪ್ಲಿಕೇಶನ್ ಮಾಡಿ ಇಂಪ್ಲೀಟ್ ಮಾಡಿಸ್ಕೊಂಡು ಆಮೇಲೆ once they have filed that return statement and taken that stand, what did you do?
Even reference
You
court
did
also
nothing.
not, reference court also not frame the issue, my lord,
Correct.
regarding that liability.
So you should have pressed for it.
If there is a pleading, my lord, by the National Highway, my lord, there is a pleading by the
Yeah.
National Highway. But reference court has to make the, my lord, issue, that one of the issue frame ಮಾಡ್ಬೇಕು. But there is a reason, if the.
ನಮ್ಗೇನು ತೊಂದ್ರೆ ಇಲ್ಲ, we will remand the
Because, my
matter.
lord,
But
by
you will
exactly-
not be, you will not be permitted to escape the liability.
But that's true, my lord.
Because
How, my lord?
including payment of interest.
Opportunity will be given to us also, my lord, to produce the document
No,
before the reference court.
ಏನ್ document produce?
No, when it is entrusted to them, that and all we have to take it into account.
Then section 11.
No, how we put to that one? I have to get the all the documents by the, unless. my
Along
lord,
with your impleading application, you should have filed it.
That's why, my lord, I'll get the all the
ಏನಿಲ್ಲ.
records, my lord. May I request you,
There
lordship,
we
to
have difficulty, my lord, if
remand
it is
this matter to
remanded
the
back.
reference
My lord, our awards are disturbed, my lord, for nothing. ಈಗ ಅವ್ರವ್ರದ್ದು ಇದ್ರಲ್ಲಿ, my lord, unnecessary, we are without
No.
any payment.
No. We are not going to set aside the enhanced amount.
Yes, yes.
It is
So-
only regarding the.
Only
license.
insofar as National Highway, my lord, the award
ಅಷ್ಟೇ,
can be
ಅಷ್ಟೇ.
set aside, so
ಅಷ್ಟೇ.
we can proceed against.
ಅಷ್ಟೇ. That is only that we can do. We can't, because we are not considered the merits of the matter.
Yes.
All right, we'll do that.
Yes.
We are not going to touch the enhanced portion of the
Correct.
award.
Correct, my
It
lord.
is only for deciding this question as
Yes.
between you and the state government.
Yes, my lord. Then lordship may keep all options open, my lord, so that,
Perfect.
yes. We have not challenged quantum, my lord. We have not challenged.
Yes. The original respond number 2 shall be deleted.
The only difficulty is the claimant's advocate arguing against us is cost him dearly. He'll have to wait
No,
for again
they are
couple of years.
constrained to argue because in another matter, as I told you,
Yes, my lord.
in that KNNL, a totally different stand is taken. There they are insisting that no, we are the necessary parties because we are paying the compensation. We should have been made a party. And
That is-
this order, the award has been enhanced without asking us, without giving us an opportunity.
I'm losing on
That's
both
a very
sides.
opportunistic thing to do, my lord.
ಆ ತರ, my lord, the claimants are out of the, my lord, relief, and my lord, here, my lord, this way they are, my lord, denied.
ಅದೆಲ್ಲಿ ವೇರ್ ದಟ್
But one more difficulty that may arise, my lord.
ಇನ್ನೊಂದು ಇದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿ.
My lord, some portion of the award amount is already deposited and dispersed to the claimants. That portion, my lord, they may recover it from the state, my lord. Otherwise, it will create, my lord, substantial anomaly, my lord. Idರಲ್ಲಿ part of the amount earlier, my lord, there was an order, my lord, subject to deposit. And
How much have you deposited? 25%.
Yes, my lord. We have deposited 25%, my lord.
They can recover.
There
it
is a
from the
difficulty, my lord,
state.
insofar as we
Rest,
are
my lord,
concerned.
They will be
Lord,
absorbed.
first of all, our difficulty is this. My lord, if the amounts are paid to them, it is very difficult for us to recover.
It can be done from the state, my lord.
Yes, it can be done from the state. We have no difficulty, my lord. If the state is paying, we have no difficulty.
Now, what he is saying is, you give it to us, ask them to recover it from the state.
No, how can we, my lord? We can't recover it from the state.
No, my lord, my argument is.
My lord,
let
my
them not
lord,
press recovery
sorry.
against us, my lord. That will, let them not press recovery against us.
ತಗೊಂಡ್ಬಿಟ್ಟಿದಾರಾ?
ತಗೊಂಡ್ಬಿಟ್ಟಿದೀವಿ ಸ್ವಾಮಿ. ಅಲ್ಲಿ ಕಷ್ಟ ಆಗುತ್ತೆ.
Got the amount released.
My lord, with condition that indemnity bond ಬರ್ಕೊಂಡು
ಅದು ಕಷ್ಟ
condition
ಆಗುತ್ತೆ.
ಹಾಕಿ release
ನಮ್ಮ ಹತ್ರ ಡಿಗ್ರಿ ಇದೆ, ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇದ್ರೂ ಕೂಡ it will be a big burden for them.
ಹೌದು. ಈ ಡಿಗ್ರಿ ಇವ್ರು ದುಡ್ಡು ಕೊಡಲ್ಲ, ಅವ್ರು ದುಡ್ಡು ವಾಪಸ್ ಕೊಡು ಅಂತಂದ್ರೆ ಕಷ್ಟ
My
ಆಗುತ್ತೆ.
lord, there is
no objection
some
for
latches
recovery
on the part of the claimant also. May I say this? There is a lot of latches on the part of the claimant also. My lord, there is an award.
He is at liberty to recover it from.
Yeah, no. You have deposited 25%, isn't it?
Yes, my lord, we have deposited 25%.
We will direct the state government to immediately deposit 25% before the reference court.
Yes.
Only with that condition, we will remand the matter.
My lord, once.
That 25% amount, if it is already deposited by them, and you have taken the release, this amount that is going to be deposited may be released to the central, the national highways. With the, on the same terms, the indemnity bond given by you will hold good as against the state government.
ಅಲ್ಲ ಅದರದ್ದು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಬರದೇ ಇಲ್ಲ. That was for subject to.
ಅಲ್ಲಲ್ಲ. If now they press on recovery, we will say there is no need to for them to seek recovery at the hands of the claimants.
The state is
The amount
direct.
that is going to be deposited by state government can be released to them. ಅಲ್ಲಿಗೆ ಸರೋಗುತ್ತಲ್ಲ?
ಹಾ ಸರಿ.
ಅದಲ್ಲ, ಓನ್ಲಿ ದಿಸ್ the 25% they have deposited. ಅಲ್ಲ ಇವ್ರಾಗ್ಲೇ ರಿಲೀಸ್ ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. So therefore we will now direct the state government to deposit 25%. So now that will be in deposit. Now that will be in deposit. That will be we will permit the national highways to take it, subject to the condition that the amount which is released to you, which was deposited by them, would now belong to the state government. And if there is any order that goes against you, you are required to redeposit it. It will only be for the sake of the state government.
There cannot be any order which can go against me because this order is closed. There is no Milord pending appeals as of now, for which Milord indemnity will come into Milord picture.
They also want to file appeals. ಅವ್ರ ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಿದ್ದಕ್ಕೆ ನಾವು ಮಾಡ್ಲಿಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳ್ತಿದ್ದಾರೆ.
ಅಲ್ಲ ಅದರಲ್ಲಿ
ಏನಾಗ್ಲಿ
ಅವರು ಇದನ್ನ
ಎನಿವೇ ಇಟ್ ಕೆನಾಟ್ ಗೋ ಲೆಸ್ ದನ್ 25%.
ಅಲ್ಲ ದಟ್ ಇಸ್ ದೇರ್.
ಅದಿದೆ ಇದೆ. ಸೊ ಯುವರ್ ಇಂಟ್ರೆಸ್ಟ್ ಆಲ್ಸೋ ವಿಲ್ ಬಿ ಪ್ರೊಟೆಕ್ಟೆಡ್. ಸೊ ದೇರ್ ವಿಲ್ ನಾಟ್ ಬಿ ಎನಿ ನೀಡ್ ಫಾರ್ ರಿಕವರಿಂಗ್ ದಟ್ ಅಮೌಂಟ್ ಫ್ರಮ್ ಯು. ಬಟ್ ದಟ್ ಅಮೌಂಟ್ ವುಡ್ ನೌ ಬಿಲಾಂಗ್ ಟು ದಿ ಸ್ಟೇಟ್ ಗವರ್ಮೆಂಟ್.
ಅಲ್ಲ ಮಾಡೋ ಕೈಲೇ ಒಂದು 50% ಡಿಪಾಸಿಟ್ ಮಾಡಿಸಿದ್ರೆ ಅದು at least Milord we are without Milord you will also understand the plight of the claimants as well.
Again we have to go.
ನಮ್ದು ಏನು ಮಿಸ್ಟೇಕ್ ಇಲ್ಲ ಇದರಲ್ಲಿ. ಅವ್ರವ್ರದ್ದು and Milord these notifications, Milord these intricacies are between them. ನಮ್ಮ ಹತ್ರ ನಮ್ಗೆ ಆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ accessibility ಇರೋದಿಲ್ಲ.
ಎಷ್ಟು ಅಮೌಂಟ್ ಇಷ್ಟ ಅವಾರ್ಡ್ ಆಗಿರೋದು ಎಷ್ಟು?
ಇದು ರಿಂಗ್ ರೋಡ್ ಬೈಪಾಸ್ ರಿಂಗ್ ರೋಡ್ 20 lakhs per acre 20 lakhs 21,000.
20 lakhs.
ಹೌದು. 10 ಲಕ್ಷ Milord, it's a taluka headquarter for which Milord ring road is made, potential lands based on Milord earlier judgment. On 50% or deposit.
Milord, may I just point out the latches on the part of the claimant, Milord? Just they are claiming equity and they are claiming all difficulties. Milord, nothing prevented them from executing the order against the state because there was no stay order against the state. The state was equally liable and the state is not impecunious to pay these amounts. Therefore, Milord, now they all along they thought it was easier to get it from me, and then they thought that the state government, they did not worry the state government much. And I don't know what understanding they had with the state, whatever. Milord, now the difficulty is this, Milord. They could have filed an execution petition and got it executed. What prevented them?
There are orders of stay passed in these.
No, only against me, Milord. Only against me. Yes, only against me that it cannot be recovered. I filed the appeal. I prayed for recovery against me. There is no recovery stay against recovery against this government. Government has not filed an appeal. Only against the national highway, Milord, there is a stay. There is no blanket stay against the award. Our interim application was only stay as against us, execution as against us.
Huh?
Yes.
No.
Yes, Milord, our application was allowed on deposit of 25%. There is no stay against the government because it was our application, our appeal. Subject to the appellant depositing 20%. Therefore, Milord, it's only against me. If I deposit 25%, then it cannot be executed against me. Against the state, it can be executed. There is no appeal by them, no application by them, nothing by them.
No, sir. please see your application for stay. You have not said that only against you.
Correct, my lord.
The order is,
That- No,
stay.
it's presumed, because I'll tell you lordship why it is presumed, because we are the appellants. Only in the
Whatever
appeal, my lord.
has happened.
Our ವಿರುದ್ಧ stay ಆದ್ರು we are not in a position to my lord execute.
Why?
Execution court my
That
lord will not.
submission cannot be accepted.
They can execute, my lord. There is nothing, my lord. It is our appeal, our application. They have not challenged the award. My lord, a
No,
person who has not challenged the
can't
award
say-
cannot say that it cannot be executed
say
against them.
It is open for the claimants to proceed against the state government. That
Yes,
submission may
it
not
is
be
open to
required.
them to challenge against state government.
Anyway,
They did
your
not.
interest is now protected. You can go before the.
Yes,
judges
I have no, I am just pointing out, my lord, all things said about me, I am just pointing out that there are latches on the part of everybody.
In these appeals.
Lords, one small submission. Serial number 14, first matter ಅಲ್ಲಿ, I am appearing for respondent lords claimant. In that amount, lords, the appellant has deposited 25%, but however, lords, the same has not been released. Since my lords are already lords remanding the matter with a direction to deposit the 25% of the award by the state, lords, I may be permitted to withdraw the amount before the lords reference court. Adu one lords may make clarify.
Fair enough, my
Yes.
lord, fair enough. I have no difficulty. Fair enough.
ಯಾವ್ದ್ರಲ್ಲಿ?
14.
Number 14. 201028.
Seeking to implead.
That that application may be disposed of. We'll make another application before the reference court to bring the alerts of the deceased respondent. The same application will make.
My lord, on that matter, respondent number one is died. Legal heirs
As between the claimants.
ಅವರು ಪಾರ್ಟಿಷನ್ ಆಗಿದ್ದೇವೆ, ಅದು ಪೋರ್ಷನ್ ಆಫ್ ದಿ ಅಕ್ವೈರ್ಡ್ ಲ್ಯಾಂಡ್ ನಮಗ್ ಬಂದಿದೆ, ಅದಕ್ಕೆ ನಾವು ಗಿಫ್ಟ್ ಡೀಡ್ ಪ್ರಕಾರ ವಿ ಆರ್ ದಿ ಲಯಬಲ್ ಟು ಕ್ಲೇಮ್ ದಿ ಕಂಪನ್ಸೇಷನ್ ಅಮೌಂಟ್ ಅಂಡ್ ಇಂಪ್ಲೀಡ್ ಅಂತ ಹಾಕಿದ್ದಾರೆ. ಅದಕ್ಕೆ ಆನರಬಲ್ ಕೋರ್ಟ್ ಲಾಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಏನ್ ಹೇಳಿದ್ರಿ, ನೀವು ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೇ ರಿಮಾಂಡ್ ಬ್ಯಾಕ್ ಮಾಡ್ತೀವಿ, ಅಲ್ಲಿ ಹೋಗಿ ಕನ್ಸಿಡರ್ ಮಾಡ್ರಿ ಅಂತ ಹೇಳಿ.
ಅದನ್ನೇ ಮಾಡಿ, ಅಲ್ಲೇ ಅಪ್ಲಿಕೇಶನ್ ಮಾಡಿ.
He passed away during the pendency of this appeal.
Yes, yes, Lord.
The project director and deputy general manager bracket T of the National Highways Authority of India, Kalaburagi. The main contention of the appellants is that the reference court could not have directed the national and the appellants to deposit the compensation along with all statutory benefits in respect of the acquisition of lands at the hands of the state government. Stop. Next para. Learned counsel for the appellants would submit that initially when the reference applications were filed by the claimants seeking enhancement of compensation, admittedly, the National Highways Authority of India was not a party. Full stop. However, an impleading application was filed by the learned government pleader, at the instance of the Special Land Acquisition Officer and the state government, to implead the appellants herein
ಆರ್ಡರ್ ಒಂದು ರೂಲ್ಟೇನ್ ಇದ್ರಲ್ಲಿ ಹಾಕಿರಿ ಇಲ್ಲಿ Section 18 reference publication.
on the ground that the appellant herein is a necessary party to the proceeding.
Exhibit
and by oversight, the appellant was not made a respondent in the proceedings.
Even
ಇದು ರೆಕಾರ್ಡ್ಸ್ ಇದೆಯಲ್ಲ, ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇದ್ರ ಮೇಲೆ ನಾನು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದಾರೆ ಅನ್ಬಿಟ್ಟು ಮಾಡಿದ್ದಾರೆ
ಸುಮ್ಮನೆ ಅಲೋಡ್ ಅಂತ ಇಲ್ಲಿದೆ.
The learned senior civil judge and JMFC, Sindhigi has simply allowed the application without assigning any reason. Stop. In fact, no notice was issued to the proposed impleading respondent and therefore there was no occasion for the appellants to contest the application. Full stop. Further, the appellants filed a written statement clearly taking a stand that that the appellants were interested with the widening and development of NH-218, that is Bijapur, Gulbarga, Humnabad section, which passes through Sindhigi village. Full stop. It was contended that the appellant was early it was contended that the highway was earlier maintained and developed by the state government, and the highway was handed over to the appellants only for maintenance and further development. In the year 2013-14, full stop, it was contended that the acquisition of the lands were made in the year 2006 for laying state highway number 12 between Jevargi to Chikkodi, for which notification was issued as per the State Highways Act, 1964. Full stop. It was therefore contended that the appellants herein were in no way connected either with the land acquisition or laying of the state highway between Jevargi to Chikkodi, and therefore they cannot be made a party respondent to the reference application. Full stop. It was also contended that at no point of time they have paid the compensation to any of the claimants, or did they deposit any amount with the state government for the acquisition. Full stop. Nevertheless, even after such stand was taken by filing a written statement, the reference court has not framed any issue in that regard and has simply proceeded to pass the impugned award enhancing the compensation, while directing that the respondents shall deposit the compensation with all statutory benefits. Full stop. Next para. For contra, learned counsel for the respondent claimants would submit that
there is no right, but one of the amendment carried the age, but there is no record.
Submission. In this case, state also has preferred an appeal by private, through private counsel, my lord, senior counsel. There are appeals pending. Appeals pending. Private advocate through private, by issuing a GO, it has been given to a special, this is regarding Sindhigi Ring Road.
So, to that extent,
31
since
cases.
you have also filed an appeal, you
We are
need
not
not,
aware of We are not aware, my lord. Private, that is GO is issued in favor of the private advocate.
Notices have been issued in that case, my lord, and we will also serve the copy on NH, National Highway Authority also, my lord.
ಅವ್ರಿಗೆ ಗೊತ್ತಿದ್ರೆ ಹೇಳ್ಬೇಕು.
ಇಲ್ಲ, ಈಗ check.
ಹೌದು.
Appeal number ಕೊಡಿ. I'll provide, my lord. Total 31 cases are there, my lord.
that will continue. We need not remand those appeals, because legitimately it is the state government which has to challenge it, and they have challenged it.
Or enhancement.
Insofar,
In
insofar
respect
as
of
the
quantum.
enhancement
Your enhancement ಮೇಲೆ ಬಂದಿರೋದು ನೀವು.
ಅದೇ.
ಅದೇ quantum
ಅದೇ,
challenge ಮಾಡ್ತಾರೆ.
this enhancement, this order passed by the reference court.
Yes.
ಇದು liability ಮೇಲೆ ಬಂದಿರೋದು.
ಅದೇನೆ.
You are filed the appeal for enhancement.
On behalf of the state government.
On behalf of the state government, my lord.
ಅದೇ questioning enhancement of.
Enhancement.
ಅದ್ರಲ್ಲೂ if you have not taken the stand, ಯಾವ್ದು ಕೊಡ್ರಿ ಅದು?
ಅದು ಜೊತೆಗೆ ಮಾಡಿದ್ರೆ ಒಳ್ಳೆ ಸರ್ ಎಲ್ಲ.
That will become, ನೀವು ಅದ್ರಲ್ಲೂ ಕೂಡ if you have not raised this ground.
ಅಲ್ಲ ಅವರೇ ಹಾಕಿದ್ದಾರೆ ನಮ್ ಪರವಾಗಿ.
ಅಲ್ಲ, see, it is the state government which has filed. We are not concerned whether it is filed by the government advocate or by a private advocate. That is how it is left to the discretion of the state government. ಅಲ್ಲೂ ಕೂಡ ನೀವು ಆ ಸ್ಟ್ಯಾಂಡ್ ತಗೊಂಡಿಲ್ಲ ಅಂತಂದ್ರೆ, I don't think there is no need to remand also.
Notification, general award.
Quantum ಮೇಲೆ ಡಿಸೈಡ್.
18/7/2006.
Quantum has to be decided. Quantum.
ಅದೇ, you can continue with that appeals.
28,000.
ಅದ್ರಲ್ಲೂ ಡೆಪಾಸಿಟ್ ಮಾಡಿದೀರ ಹಂಗಾರೆ ಅಮೌಂಟ್ ನೀವು?
No, my lord, only notice has been issued as there is a delay in filing the appeals. Only notice has been issued, my lord.
ಕೊಡಿ numbers ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ?
ಇಲ್ಲ tomorrow afternoon I will provide my lord. There is the total
Okay.
30
All
more.
right. We'll
Milord,
complete
may
the
I say
litigation.
something,
Please.
Milord,
We will
in
not
this
close
regard?
it.
Please.
We will have the matters tomorrow. You please give
Yes.
the numbers.
Please.
We'll
Yes.
get those files also, and finally we'll dispose it
Yes,
also.
Milord,
Please.
yes. I am
Yes.
grateful. Then we'll have to say something on their appeal also, Milord. If they
Yes,
have
yes.
not taken
No,
this ground that they are not
in their
liable.
appeal, if they have not taken that stand,
Yes, then that's over.
that's the
That's
end of the
concluded.
matter.
Yes.
Yes.
National Highway is also part in that.
ಆಗ್ಲಿ ತೊಂದ್ರೆ ಇಲ್ಲ.
Based on 213 to 14 judgment ಮೇಲೆ ಇದು ಮಾಡಿ.
Would submit that ನೀವು ಏನಾದ್ರು ಹಾಕಿದಿರೇನ್ರಿ? ಕ್ಲೈಮೆಂಟ್ಸ್ ಏನಾದ್ರು ಫೈಲ್ ಮಾಡಿದಾರ?
Cross objections ಇದೆ sir. That will not be maintainable independent. The cross objections are filed. If not the main appeal goes, still my appeals for enhancement they can be taken up with the states.
Along with those matters filed by the state.
ಇದರಲ್ಲಿ ತಗೊಂಡ he has the appeal memo, my lord, but the contention that we are not liable, it is only the NHAI is liable is not agitated. They're all on, Lord, the grounds are on enhancement, redetermined.
ಈ ನಂಬರ್ ಇದೆಯಾ? ನಂಬರ್ ಇಲ್ಲ.
Numbers ಕೊಡ್ತೀನಿ. I'll just.
Submit that the claimants are being taken for a ride by such contradictory stands taken by the state government and the National Highways Authority of India. Full stop. It is submitted that in many other cases, entities like the Kaveri Neeravari Nigam Limited, Karnataka Neeravari Nigam Limited, ಇನ್ನೊಂದು ಯಾವ್ದ್ರಿ?
KBJNL, ಕರ್ನಾಟಕ ಜಲ ನಿಗಮ್,
ಕೃಷ್ಣ ಭಾಗ್ಯ ಜಲ ನಿಗಮ್ ಲಿಮಿಟೆಡ್ are taking a stand that they were necessary parties, but the claimants have filed reference applications without including them, and awards are enhanced without hearing the necessary parties. Full stop. On that ground, matters are sought to be contended at the hands of the state government, that without making such necessary parties, parties to the reference application, and without giving an opportunity of hearing to them, the compensation could not be enhanced. Full stop. On the other hand, in these cases, a totally different stand is being taken by the National Highways Authority of India. Although notifications are issued by the central government handing over the highway to the appellant sharing. Full stop. It is also submitted that while interim orders were passed by this court, the appellants have deposited 25% of the award amount, and the claimants have got released those amounts.
Some of the cases.
Some of the claimants have got released such amounts before the reference court.
Before this court.
Have got released those amounts. Full stop. Next para. At this juncture, learned the government advocate, on the other hand, contended that no evidence has been led by the appellants herein to show that they are not liable to pay any part of the compensation. Stop. Merely by filing a written statement, it would not be sufficient for the appellants to contend that they are not liable for payment of compensation. Full stop.
Sorry to interrupt, my lord. One additional ground, my lord. 12(1)(d) of, my lord, this 1988 Act provides, my lord, statutory liability after, my lord, entrustment to the National Highway.
But that is only with regard to the central government's liability, not our liability, not anyone else's liability. If the central government is liable, we are liable. Here, where is the liability cast on the central government, my lord? The central government is not made liable. Lord, that provision attracts only if the central government is made liable, and if there is a case against the central government for compensation, then if it is transferred to us, we have to conduct the suit or any proceeding for recovery or any other proceeding, suits or whatever. Lord, it is, where is the case here that the central government is liable to pay?
Yes, you have understood. Stop. It is submitted that after filing written statement, the appellants have also kept quiet without insisting on issue to be framed in that regard. Full stop. The learned government advocate would therefore submit that the matter may be remanded back to the reference court to reconsider this issue as to whether the appellants are liable for payment of compensation. Full stop. Next para. At this juncture, learned counsel Sri Kripa Sagar Patil, who is present in the court, mentions that appeals have been filed on behalf of the respondent SLAO and the state government in MFA so and so, challenging the impugned judgment and award. Full stop. Next para. Having heard the learned counsels for the appellants, the respondents, claimants, the learned government advocate, and on perusing the appeal papers, this court finds that in another set of appeals filed at the hands of a claimant, an impleading application was filed before this court in MFA number 31872 of 2012, seeking to implead the appellant herein as a party respondent to the appeals. Full stop. The appellants herein filed objections to the application, and by order dated 23/11/2023, this court considered similar such contentions. Full stop. This court noticed the fact that 4-1 notification was issued under the Land Acquisition Act on 10/11/2020, and 6-1 notification was issued on 16/1/2002, and award was passed on 30/12/2002. Full stop. It was noticed that the appellants had not deposited any amount with the SLAO, since the lands were never acquired for the benefit of the appellants dash National Highway Authority of India. Full stop. It was noticed that similar notifications were issued under Section 11 of the National Highway Authority Act, which empowers the central government to issue notification in the official gazette, to vest or entrust to the authority such national highway or any stretch thereof to vest in or entrust to the authority, A capital, such national highway or any stretch thereof as may be specified in such notification. Full stop. This court therefore held that it was clear that it was never the case of the state government or the SLAO that the National Highways Authority of India was the beneficiary of the acquisition proceedings. Full stop. It was noticed in that case that the state government or the SLAO never raised any objection before the reference court that without impleading the beneficiary, the reference court would not hear the reference for enhancement of compensation. Full stop. But in the present case, such application, impleading application was filed before the reference court, and nothing more was done. Full stop. Next para. We also find from the appeals filed at the hands of the SLAO and the state government in MFA.
I brought the MFA numbers, my lord. Now I got the FR numbers. I'll provide the MFA numbers.
MFA numbers kodi. ಕೊಡ್ತಾರ ಅದನ್ನ ಬರ್ಕೊಂಡು ಎಲ್ಲ ಬರೆಯೋದು ಬೇಕಿಲ್ಲ. MF number so and so ಅಂತ ಬರ್ಕೊಂಡು and 30 other appeals. ಅದೇ ಅದು ಅದನ್ನ ಸೇರಿಸಿದ್ರೆ 32 ಇದೆಯಾ ಆಯ್ತು. And 31 other appeals filed by the state and the SLAO, no such stand is taken that the national highways, that the acquisition was made for the benefit of the National Highways Authority of India, and that they are liable to pay compensation. In that view of the matter, we accept the submission made on behalf of the appellants. Full stop.
My lord, in same cause list, today's matter, serial number 40 is also connected matters, my lord. Kindly connect with serial number 40.
ನೀವ್ ಹಾಕಿರೋದಾ?
ನಾವು ಹಾಕಿದ್ದೇವೆ.
ನೀವ್ ಹಾಕಿರೋದು ಸೇರ್ಸ್ಕೊಳ್ಳೋದು.
Serial number 40 is also listed.
Next para. Consequently, we allow the appeals. Full stop. However, since 25% of the award amount was deposited by the appellants in terms of the directions issued by this court while granting interim orders, and in many cases the claimants have withdrawn the said amount, we hereby direct the respondent state to deposit 25% of the award amount within a period of 6 weeks. Full stop. As and when the amount is deposited by the respondent state, the appellants are permitted to withdraw the same. Full stop. The amounts, if any, withdrawn by the claimants will be taken as the amounts deposited at the hands of the state government, and the indemnity bonds given by the claimants shall stand good regarding the same amount deposited at the hands of the, that will be deposited at the hands of the state government. Full stop. Further, if the state and the claimants are able to identify the appeals preferred by the state government already, and if such deposits have not been made in those cases, the deposit that will be made by the state government will be taken as deposit made in that particular case. ಈಗಾಗಲೇ ಹಾಕಿದಿರಲ್ಲ.
What can? May I submit, my lord, one thing. What can be done is, my lord, lordships may say that, my lord, the state is supposed to pay back the amount which is already released in favor of the claimant to the NHAI. And, my lord, all rights accrued in the, my lord, indemnity bond shall, my lord, stand to the benefit of the state. That would, my lord, resolve, my lord.
ಇಷ್ಟುವರೆಗೂ ಅದಾಯ್ತದು.
Yes.
ಈಗ ಅಲ್ಲಿ ಅಪೀಲ್ಸ್ ಫೈಲ್ ಮಾಡಿದಾರಲ್ಲ,
ಹೌದು,
ಅಲ್ಲೂ there are no orders directing them to deposit anything.
Notice have been issued.
So it can be as well taken that the deposit is made in those cases and you have taken you have reclaimed this.
The release is from the state and
only to that extent.
50% ಮಾಡಿದರೆ 50%.
ಅಲ್ಲ, ಅದರಲ್ಲಿ you can mention in those matters. We are disposing of these matters and we are ensuring that the amount deposited by them is returned to them. ಅಷ್ಟೇ. Further orders if you want you can ask in those places. ಅಷ್ಟೇ ತಾನೇ?
The appeal may be allowed insofar as, my lord, the NHA award is set aside only insofar as, my lord, respondent.
Appeal is allowed ಅಂತ ಬಂತಲ್ಲ, insofar as the appellants are concerned as against the impugned judgment and awards.
The award is set aside only against, my lord, the appellant. Insofar as others,
as regards the liability of the respondent state and the SLAO, no orders are passed on the merits of the matter. Full stop. The liability will continue on the state and the SLAO.
With my lordship's kindly, lords.
Yes.
First matter, lords, liberty to make application before the reference court to withdraw the amount. ಅದರಲ್ಲಿ ನಾನು ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡಿಲ್ಲ. It is still in deposit before the reference court.
ಅಲ್ಲಿ ಅವರು ಅಪೀಲ್ಸ್ ಫೈಲ್ ಮಾಡಿದಾರಂತೆ, ಹೋಗಿ ಅಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಳ್ಳಿ.
ಇಲ್ಲ, ಈ ಅಪೀಲ್ ಅಲ್ಲಿ ಡಿಪಾಸಿಟ್ ಮಾಡಿದಾರೆ ಸ್ವಾಮಿ, ನ್ಯಾಷನಲ್ ಹೈವೇದವರು.
ಅದೇ ರೀ, ರಿಲೀಸ್ ಆಗದೆ ಇದ್ರೆ ಇವಾಗ ಮತ್ತೆ ರಿಲೀಸ್ ಮಾಡೋ ಪ್ರಶ್ನೆ ಬರೋದಿಲ್ಲ. ಅವ್ರಿಗೆ we are giving it back to them. So if you want, you will have to ask in those appeals filed by the state. You will have to file similar applications there.
Yes.
All other pending IAS stand disposed of. View of the disposal of the appeals.
Serial number 40 may be also connected same.
Sir, connect.
13, 14 and, my lord, 40.
My lord, some of the matters the deposited by the NHI amount is not released. Those matters may be refund ಮಾಡಕಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ. Some matters claimants favor not released the amount deposited by the NHI. Those amount may be released in favor of NHI ಅಂತ ಒಂದು ವರ್ಡ್ಸ್ ಹೇಳಿದ್ರೆ ಅನುಕೂಲ ಆಗುತ್ತೆ. ಮತ್ತೆ ಓನ್ಲಿ ಡಿಸ್ಪೋಸ್ಡ್ ಅಂತ ರಿಲೀಸ್ ಆಗಿದ್ದು ಅಷ್ಟೇ ಅಂತ ಆಗುತ್ತೆ.
ಇದು all other amounts deposited by the appellants before this court where the claimants have not withdrawn such amount will also be released to the appellants forthwith.
Yes, the cross objections may be disconnected and they may be heard, my lord, separated. The claimants, my lord, appeals which are connected to, my lord, serial number 40 LE, they may be, my lord, heard independently.
Heard along with those matters.
Yes, but illi bare adanna they will be they are to be heard independently.
All cross objections filed at the hands of the claimants are dealing, starting alle ಮಾಡ್ಕೊಂಡು are dealing from these matters.
Great.
Yeah. ಅದೇನದು ಎಷ್ಟು?
51 days.
ಆಯ್ತು. ಸೀರಿಯಲ್ ನಂಬರ್
40.1.
ಆ ಬ್ಯಾಚ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ 40.1 ನಲ್ಲಿ ಡಿಲೇ ಆಫ್ 51 days is condoned. ಇದರಲ್ಲೂ ಅಷ್ಟೇ 40.2 ಅಲ್ಲೂ ಅಷ್ಟೇ 51 days. ಆ 40.6 ಅಲ್ಲಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಆರ್ ಓವರ್ ರೂಲ್ಡ್. ಅದು IA ಮೇಲೆ Huh? Huh? ಎಲ್ಲೆಲ್ಲಿ ನೋಡಿ ಅವ್ರಿಗೆ ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲೆಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ಅಲ್ಲಿ ಡಿಲೇಸ್ ಆರ್ ಕಂಡು ಉಂಟು. ಸೇಮ್ ಇದೆ ಆರ್ಡ್ರೆ ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲೇ ಕನೆಕ್ಟ್ ಮಾಡ್ಬಿಡಿ, ಡಿಲಿಂಕ್ ಮಾಡೋದನ್ನ ಡಿಲಿಂಕ್ ಮಾಡ್ಬಿಡಿ. ಹಾ we will get them listed tomorrow. We will see. Huh? You also paid court fee.
Yes, my lord,
Court
we have
fees is
paid.
paid.
Huh?
Paid. All appeals court fees is paid, man.
ಅದು ಇದರಲ್ಲಿ ಇನ್ನೊಂದು ಸೆಂಟೆನ್ಸ್ ಸೇರಿಸ್ಕೊಂಡು, since the appeals are allowed and it is found that the appellants are not liable to pay compensation, the court fee deposited by the appellants shall also be returned in accordance with law. Yes.
Grateful, my lord.
ಇರವೇ ಹಾಕ್ಯಾರ ನಮ್ಮಲ್ಲಿ ಇದಾವ
ಸರಿ
ಪ್ಲಸ್ ಅದೇನೋ ಎಕ್ಸಿಸ್ಟೆನ್ಸ್ ದೇ ಆರ್ ಆಲ್ರೆಡಿ
ಅದೇ ಇದೆ ಬೇಡ ಬಿಡಿ,
ದೇ ಆರ್ ಆಲ್ರೆಡಿ ಆನ್ ರೆಕಾರ್ಡ್.
Yes. Yes.
Serial number 15, additional government advocate.
Is that issue?
Advocate General's law. We'll be arguing this matter with regard to depositing of 25% of the
last
enhanced
time-
compensation. Your Lordship.
Yes, yes.
In fact, my lordship, we are pleased to adjourn this matter on the last occasion.
Other, the one
Only,
230 minutes.
ಅದಲ್ಲ
That
sir,
is
ಇದು
different.
it is a matter where my lord justice
The
Lord
Dixit's
yes.
division bench of this
Not-
court. has
that
applied
50%
Ah.
should not.
similar
had,
question, in this also, my lord, KBGNL is a proper and necessary party, like, my lord, they have not made a party independent of that, my lord, so I won't go into that because here we have to deposit some money, my lord, either us or KBGNL. The only question is, my lord, here the award was for 88,000 and it is increased nearly 7 times to 6,34,000, my lord. The same principle will apply. There from lakhs to crores, here from thousands to lakhs, my lord. The proportionate of increase is similar.
ಗೊತ್ತಾಯ್ತು, but the burden is not so much.
But my
They
lord, question,
found the burden is too much. That is why
Not
they
the-
passed such orders.
not the question of
Otherwise,
burden.
normally we are directing that 50% of the amount has to be deposited.
It's question of entitlement in law, my lord. What has happened in this case, my lord? Just giving an example, an agreement to sale of a converted property of a company is taken for the purpose of giving a compensation to all agricultural lands. In all these cases.
ಅರ್ಥ ಆಗ್ಲಿಲ್ಲ ನನಗೆ.
I'm sorry, my lord, I'll go slow, my lord. My apologies, my lord. Agreement to sell of a converted land is the basis for awarding enhanced compensation, my lord. Whereas this nature of land is an agricultural land. That is a converted land and an agreement to sell, not a sale deed. So it is uncomparable, my lord.
The basis, that cannot be a basis.
That could not have been the basis, is my only point, my lord. So therefore, my lord, your lordship may permit us to deposit 25%, so subject to give them liberty, my lords, to modify, so that, my lords, at least let's comply with some of it, my lords, then matter can be heard and disposed of, my lords. If they want to seek modification, let them come back, my lords, with that, my lords, to show why the 50% should be awarded.
already, my lord, hundreds of cases, my lord, 50% is awarded, deposited, some of them are released. Not this discrimination, my lord, will cause, my lord, heartburn. 6 lakhs and odd, my lord, for a notification, my lord, as recent as this. It is not a heavy amount, my lord, and
Financial implication is huge, my lords, insofar as financial implication is huge because there are thousands of cases, my lords. If it's not one case where your lordships are saying, my lords, this will be the same order for all the cases also, my lords.
How many
And
cases?
one more thing is KBJNL is not a party to this, my lords.
ಇವಾಗ ಅವಾರ್ಡ್ ಆಗೋವರೆಗೂ ಸುಮ್ ಕೊಡ್ತಾರೆ ಆಮೇಲೆ they will set up, my lord, KBJNL. My lord, be that as it
No,
may,
no.
but the order, my lord, of the division bench, my lord, in Dharwad, it appears to be a consensual order, my lord, because they say that the preceding directions at your lordships, my lord, last
Yes, yes,
occasion
yes.
I had given, my lord.
Dharwad bench, the order.
That is 19th August 24. No, sorry, 23rd September 24.
On the second page, my lord, Roman 4. The preceding directions 1, 2, and 3 shall apply to all appeals, whether any interim order is granted or not, in as much as that has been a broad understanding between the parties and the court. My lord, it's a consensual, my lord, this thing, where they considered. And my lord, what will be the award of, my lord, this interim order of 25% in that, my lord, matter as a consequence would result in, my lord, about 50 lakhs and odd per acre. That will be the interim order. There the award of amount
Lord,
is
in-
5,000.
My lord, given 15 days, my lord, we'll comply with we'll be ready for the main argument. In fact, in that also we are ready, my lord. In this also very short point, evidence is also on very short point, my lord. We'll be ready in not 15, 1 month. I'll be practical, my lord. 1 month in all these matters will.
5,275 per square meter is the award, my lord, on the last second page, second paragraph, operative portion, which would work out to, my lord, 2,13,45,589. That will be, my lord, 1/200, or, my lord.
My lord, this has an implication on 2,000 cases, my lords.
Lord, that's
What
not
do-
a ground, my lord. My lord, this is repeatedly submitted. I take, my lord, strong objections to this. Lord, they are supposed to pay, my lord, when they are acquiring, my lord, that extent they are supposed to pay. Their implication, my lord, is their headache. My lord, this court has.
Then
my lord,
go on
having-
merits.
Yes, yes. Then they don't insist for, my lord, stay. We will be ready by, my lord, tomorrow or day after for on merits, my lord, if that is the, my lord. Because I'm told, my lord, these, my lord, some of the matters are already, some of them are satisfied, where, my lord, these awards are made. But that, my lord, is not, my lord, this pick and choose, my lord, is the difficulty. And in fact, my lord, in this case, the very case, your lordships have granted, my lord, in respect of the matter arising from the very same common judgment of reference court, 50% is, my lord.
No, that was the standard earlier.
Illa, that's the standard, my lord, not earlier, my lord. This is a consistent stand of this court.
That was the consistent.
ಯಾವುದೋ ಒಂದು exceptional cases ಅಲ್ಲಿ.
This is the only exception ಇವಾಗ.
ಹೌದು, ಹೌದು.
This is an exception.
That is how it has to be, my lord.
That is why we asked the learned AG whether this can be now taken as a
Yes, yes.
benchmark in
It
all
cannot-
cases.
Yes, yes. Your
I'm
lordship.
My lord, Angela, my lord, what I'm saying is, my lord, if they're asking for 50% or 75%, whatever, they have to make out a case on what basis, at least on my case is, my lord, the whole judgment is passed only on this point, an agreement to sale of a converted land.
No, but learned AG, the provision itself it says even an agreement can be taken for consideration
Of
anta.
Of a converted land, my lords.
Agli, whatever it is.
But this is an agricultural land.
Even an agreement can be a basis. The provision itself says so.
Of an agricultural land, I appreciate, my lord, not of a converted land. And the location. These are the two things your lordship may have to take into account, my lord. I understand, man, an agreement to sale of an agricultural.
This is the short ground and you want to argue the matter, we will take it up. We will take up the matter and we'll dispose it of.
Then your lordship may have, my lord, will point this out and will.
Alva. If this is the short point, we will consider.
Yes, that can be done, my lord. The difficulty, my lord, will be that the n number of matters are there. If they are ready, my lord, in each and every case, my lord, we will come up and prepared on each case, my lord.
ಅಲ್ಲ ಎಲ್ಲಾದ್ರಲ್ಲೂ ಇದೇ ಗ್ರೌಂಡ್
ಇಲ್ಲ ಎಲ್ಲದರಲ್ಲಿ ಬೇರೆ ಬೇರೆ ಇದೆ, ಬಟ್ ದೇ ಆರ್ ಆಲ್ ಇನ್ ದಿ ರೇಂಜ್ ಆಫ್ my lord 6 lakh, 7 lakh, 8 lakh, 10 lakh. ಆ ತರ award ಆಗಿದೆ.
The question is not 6 lakh, 7 lakh. The question is
ಹೌದು, ಆಯ್ತು.
if the basis is same,
all cases not same basis is not there. The basis are different exhibits in different cases based on lot the evidences that is let in.
ಏನ್ ಮಾಡ್ತೀರಾ?
If they want my lord
You want to argue
blanket,
the
my lord,
matter?
my lord, your lordship may have it after 2 weeks, my lord. We'll prepare it, make the thing, come back to your lordships, my lords.
Sorry,
We'll make a convenient compilation and come back.
You will direct them to deposit 25% immediately. With a rider that this is the contention of the claimants, that normally 50% is required to be deposited.
Lord, that will be a deviation, Lord. I have, Lord, this reservation because of this, Lord. This will become, Lord, precedent for the next thing. That's the difficulty, Lord. Lordship may take a call on, Lord, this, Lord, award and correctness of the award. Prati one case or ಮಾಡ್ತಿದ್ರೆ ನಾವು ready ಆಗಿ ಬರ್ತೀವಿ, ತೊಂದರೆ ಇಲ್ಲ. If they want stay, Lord, it has to be, Lord, on the basis of, Lord, the case. The question is whether I have made out a case. I have made out a case. That is why I am awarded. Now he will have to make out a case that it is erroneously awarded. For consideration of that, Lord.
Then your lordship may simpliciter, my learned friend feeling is if there's a stay, it'll be difficult. Simpliciter on 3rd or 4th of December, my lords, we'll try and get ready in the, make a list of all this, try and get ready with the matter itself, my lords.
Learned Advocate General submits on behalf of the appellant that if this court is not inclined to take the similar view as was done by this court at Dharwad bench in MFA 100865 of
Can I make one request, my lords? Can I make one request, my lords? The lordship may, after hearing, pass a considered interim order after 1 week or 10 days. What should be the interim relief, my lords? Therefore, my lords, on that basis, that your lordship may not rely upon this interim order, my lords. Insofar as these cases.
ಇದು ಒಂದು ಬಿಟ್ರೆ ಎಲ್ಲದರಲ್ಲೂ 50%.
Allah, based on the merits of each case, my lords, it's not the question of whether we have to pay 50 or 25. Your lordship may go into
How can we go into merits of each matter and say how much?
Yakandre, for example, if the basis itself in each, Allah, we'll make a, because the judgments are not lengthy, my lords, reasons are just 1 or 2. If it appeals to your lordship,
We will dispose of the appeals itself.
Okay, then
as you have requested, we'll have it on 3rd or 4th of December. We'll decide the matter.
Please, my lord, just simplicity adjourn the matter, my lords. Can your lordship?
Yes.
We'll make a gist of what are the reasons given in each of the orders so that it will be convenient for your.
You prepare and come. We will dispose of the appeals.
Please, Lord.
Yes.
Second kit ಅದು
ಅದೊಂದು ಇದೆಯಲ್ಲ, ಇದರಲ್ಲಿ ಡಿಲೇ ಇದೆ. ಇದು this delay cannot be condoned. Some of the delay, I think most of it is beyond the permissible 120 days.
In this 108 days, first year the 18 and 108 days is there, my lord.
108 days andre delay can be only 60 days.
Yeah,
60 days is the
beyond that.
limitation. Another 60 days.
Ade, so
61 days, my lord, it cannot be condoned. 61, if the delay is 61 days, it cannot be condoned. As of, my lord, the position that exists.
It is 60 plus 60, my lord.
60 ದಿವಸ appeal file ಮಾಡಿ
120 ಅಲ್ವಾ?
First 60 days, my lord. Second is
60 days.
we had 120 days.
ಇದು more than 60 days. Exam ಮಾಡಿ
60 is to be expected. Then also there's a delay.
60 plus 60.
ಎಲ್ಲದರಲ್ಲೂ ಡಿಲೇ ಇದೆ.
In all the cases there's delay.
ಎಲ್ಲಾ appeal ನಲ್ಲೂ ಡಿಲೇ ಇದೆ.
ಎಲ್ಲ almost very few.
That is one of the point.
That is
below 60 days, the only my lords condonable. Otherwise, no.
Technically, my lord, their appeal is not a appeal duly constituted as of now, my lord.
It falls within the further period of 60 days.
Just one.
ಇಲ್ಲ ಸ್ವಾಮಿ.
60 plus
ಇಲ್ಲಿ
60 plus.
108 days ಇದೆ.
Total 120 days.
60 days is the limitation.
Hmm.
So thereafter 108 days.
8 days, after 60 days.
After 60 days, another 108 days. ಅದು ಆದ್ಮೇಲೆ 108 ದಿವಸ ತಡ ಆಗಿದೆ ಅವರಿಗೆ.
Therefore, it is beyond 120 days.
Beyond 120.
That is what I said.
So it will be about 168 the day, my lord, they have.
ಅದೊಂದು ಪ್ರಾಬ್ಲಮ್ ಇದೆ. In all these appeals, the delay is
I'll just check that. I thought it was total 108.
108 is after 60 days.
Manoj, if it is beyond 60 plus,
That issue is again to be decided. We do
I'll
not
just
know.
check that up.
That matter is
Pack it
pending
together.
before the Supreme Court. So if you are not able to decide on the
In
merits,
fact-
then you have to deposit the amount.
Quite a few.
Wherever there is, my lord, exorbitant awards, 4,500 square meter.
That is why we said, see, the normal standard is 50%. It is only this exceptional case
Yes.
where the court has
Taken a
said, all right, we will take only 25%. So this court is required to now find out whether this can be taken as a benchmark in all cases. And I don't think that is the tenor of the order.
No. It doesn't, my lord, say that it has to be done, my lord, that way. It confines only to, my lord, that case.
Manoj, then we don't see.
So you please make your submissions on this
Some-
only. Whether
Manoj,
this should be
notice
taken
go,
as the
Manoj, that's all. We file our
benchmark.
report. Manoj, we don't insist on any interim order to be passed. We don't insist on any interim order as of now, Manoj, in this
Under
matter.
they can proceed to file execution case then. They will proceed to file execution cases then.
Let them proceed. Manoj.
ಪರಿಸ್ಥಿತಿ ಹೆಂಗ್ ಬಂದಿದೆ ಅಂದ್ರೆ we must insist that let them take some interim order.
ಅದೇ.
ಏನಾದ್ರೂ
Manoj,
2006 is the, my lord, notification. We are almost.
ಅಲ್ಲ ಏನಂತ ಅಂದ್ರೆ they have filed cases after 3, Manoj, cases are filed after delay of couple of years
ತಮ್ದು delay.
in appeal, Manoj. Not, for example,
Provision
raising
is same, whether it
couple
is
of
for
years.
you,
Yeah.
whether it is for you or for them.
We
Now
also
the
will lose.
question of delay, provision is same now.
Lord, we have
ಈಗ
also.
No,
if they have
I'm-
filed
what I'm
appeal
talking
beyond 120 days, same thing.
We have missed, my lord, in so many cases.
That appeal also can
Not
be
that-
made.
ನಮ್ದು ಎನೌನ್ಸ್ಮೆಂಟ್ ಅಪೀಲ್ಸ್ ಹೋಗ್ಬಿಟ್ಟಿದೆ ಎಷ್ಟು. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್, we feel 6 lakhs.
No,
is less,
not,
but we-
not that, Manoj. After the award was passed. The Lordship may kindly see the date of award and the date of file.
No, office objections have been raised on.
Date of
these
award is
matters.
2016.
Office objections have been raised that it is beyond 120 days. Adana, those questions we have kept it open.
Yes.
We
No,
have
that
not,
Manoj,
we have
Lordship may-
only issued notice.
Keeping
The
open
Lordship may
question
kindly
of
see the
delay.
award dated is 18th February 2016.
Matter is all.
And the petition is filed, Manoj, in the year 2018, Manoj.
ಆಯ್ತು, in time it is.
No, see, office has calculated the question of delay. In all these matters, they have said it is beyond this 120 days.
I'll just check that up and get back, Manoj.
Total 168 days agutte.
168.
I'll just verify that and get back, Manoj.
Therefore, we will not be able to decide the appeal now. ಹೌದು, ಅದೇ ಅದನ್ನೆಲ್ಲ ತಗೊಂಡು ಲೆಕ್ಕಕ್ಕೆ ತಗೊಂಡು ಆಮೇಲೆ they have said it is.
In similar matter, the Dharwad High Court, Manoj, they dismissed most of the cases beyond 120 days, Manoj.
I'm told, my lord, about 500-600 matters are already dismissed.
Have all been dismissed, Manoj.
We are going.
ನೀವು ಅಪೀಲ್ ಹೋಗ್ಬಿಡುತ್ತಾಗ.
ಅದಕ್ಕೆ all those 500 cases are being taken to Supreme Court to decide this issue, my lord.
So now that is why we said, okay, let the Supreme Court decide that one. So we will keep this pending, but you will have to, in the meanwhile, deposit the amount.
I'll get instructions and get back, my lord.
ನರೇಂದ್ರ ಪ್ರಸಾದ್ ಅವರು ಅದು ಒಂದು
ಯಾವಾಗ?
Any day, my lord.
Next Monday?
Next Monday, my lord.
ಅದೆಲ್ಲ ತೆಗ್ಬಿಡಿ at the request of the learned.
No, not 25th, 20, can I request for either 22nd
ಆದ್ಮೇಲೆ ನರೇಂದ್ರ ಪ್ರಸಾದ್
or 27th?
22nd is all right?
Alla, 22nd I'm not.
27th?
Or 20.
ನರೇಂದ್ರ
27th?
ಡಿವಿಷನ್ ಬೆಂಚ್
20
9
or 27th, my lord, it will be easier, my lord.
ಆಯ್ತು. Release these matters on 27th of November. ಅದು ಇನ್ನೊಂದು ಬ್ಯಾಚ್ ಮ್ಯಾಟರ್ಸ್ ಅವತ್ತೇ ಇದೆಯಂತೆ 27th. So we will have it on 27th.
27th, please, my lord.
19, 22 and 28.
Well, it's serial number
19,
15,
22 and
18, 19, 22, similar matters, your lordships. 27 and 28.
19 and 28.
19,
22 and 28.
22.
18 ಇಲ್ವಾ?
18.
18, 19.
18, 19,
22,
22,
27, 28.
27,
28.
28.
Please.
ಎಲ್ಲಾದ್ರಲ್ಲೂ ಸೇಮ್ ಮಾಡು.
Number 17, Mahantesh Patil.
Appear for impleading respondent. As I have mentioned in the morning itself, this in view of order passed by grievance cell, this writ petition itself becomes infractuous.
Yes, Mr.
Number
Mahantesh Patil.
97, page number 97, they themselves have produced the copy, my lord.
Then no, writ petition has to be not allowed.
Huh?
Writ petition is required to be allowed then. There is an order at annexure V, I have challenged notes.
Writ petition.
In the writ petition, I have challenged the order at annexure V. Lord, my submission is along with impleading application, may I request lordship to peruse. My lord, filing, apart from filing writ petition, parallelly he was maintaining, my lord, appeal before authority, my lord, that is grievance, consumer grievance cell at Raichur, my lord. With the very similar relief, yes.
Same issue.
Yes, same issue. That appeal filed by my lord appellant is allowed. So therefore, my lord, writ petition. In short, I will mention that. So now the impleading respondent, he made a complaint before the authorities, the JESCOM, saying that
you are a water
purifier plant. I am running a water purifier plant. The respondent proposed impleading respondent made a complaint saying that, my lords, I am not, my trade license from the municipality is not renewed. Therefore, the electricity has to be, my lords, shut down. Based on that, my lords, they have passed an order. Then I approached this honorable court. This honorable court remitted the matter in the earlier proceedings. Again, they passed an order at annexure V, my lords, wherein they have directly passed a final order, at 83, my lords, page number 83. Last 3 lines, my lords. ಆದ್ದರಿಂದ ಶ್ರೀಮತಿ ಸುರೇಖಾ ಗಂಡ ಉಮೇಶ್ ಮ್ಯಾರಿಡ್ ಸುಜಾಲ ಅಕ್ವಾ ವಾಟರ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಪ್ಲಾಂಟ್ ವಾರ್ಡ್ ನಂಬರ್ 30 ಒಳಬಳ್ಳಾರಿ ರಸ್ತೆ ಸಿಂಧನೂರು 28 ವಿದ್ಯುತ್ ಸಂಪರ್ಕವನ್ನು 3 ದಿನದೊಳಗೆ ಕಡಿತಗೊಳಿಸಿ ಸದರಿ ಸ್ಥಾವರದ ಮೀಟರ್ ಅಂತಿಮ ರೀಡಿಂಗ್ ಅನ್ನು ಈ ಕಚೇರಿಗೆ ಸಲ್ಲಿಸಲು ಸೂಚಿಸಲಾಗಿದೆ. This order was came to be challenged by before the learned single judge. The learned single judge, my lords, has treated this is the not the final order. This is only a notice. Therefore, I am required to give a reply. This is what they observed, and the writ petition has been dismissed as premature. Therefore, then I filed a writ appeal. Since the order itself is not in the nature of final order, Therefore, the writ petition ought not to have been dismissed on the ground that it's a premature. In the meanwhile, what happened, my lords, there was an amendment was carried, which was not, we are not aware about the amendment. I have produced along with, my lords, my additional documents. At page number 101, my lords. 102 is the relevant. Amendment to the Act of Municipalities Act. There was a proviso was added, provided further that all micro, small and medium enterprises registered under the micro so-and-so is concerned, district industry center and large industries who have filed industrial entrepreneurs memorandum or industrial license with the Secretary of Industrial Assistance Department
are exempted from obtaining trade license.
Then, my lords, the authorities, the KPTCL concerned, Karnataka Electricity Regulatory Commission, at page number 103, as my lords passed the order on relevant portion is 104. Otherly class C, my lords, in the column 3, class C, license to carry on any trade, business or profession provided under any law. Note and there is no necessity of production of license specified in class C above. Otherly class 2, months, where the power supply is required for
MSME.
Then, my lords, therefore, by virtue of these orders, then the authority at concerned months at page number 97 has passed the order on 9/3/2023. Months.
That is in the backdrop of a very
Page
same
number 99.
provision.
Considering all this order has been.
Yes. Page 2, first para.
ಇಲ್ಲಿ ಅದೇ ಪ್ರಾವಿಸೋ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಪರವಾನಗಿ ಪತ್ರ ನವೀಕರಣಕ್ಕಾಗಿ ಗ್ರಾಹಕರಿಗೆ ನೋಟಿಸ್ ನೀಡಬಾರದು ಹಾಗೂ ವಿದ್ಯುತ್ ಸಂಪರ್ಕ ಕಡಿತಗೊಳಿಸಬಾರದು ಎಂದು ಆದೇಶಿಸಲಾಗಿದೆ. By virtue of this, now the order has to be set aside. This is only the matter.
Any which way.
Otherwise, the order will remain in force.
That notice has been considered. 15/11/2022 order has been considered by the grievance cell, page 98.
Like if the Lord Juscom, they are appearing, if they don't want to, my lords, execute that order, annexure V, which the order has been directed.
In this order, they have taken note of that notice.
Yes. 15/11/2022 ಜಾರಿ ಮಾಡಿರುತ್ತಾರೆ. Page 2, my lord.
Beginning pair.
ಹೇಳಿಕೆ. That has been taken note.
Yes, it has been taken note.
All the notices, dates of all the notices are referred. And assailing this order, my lord, I preferred writ petition which is pending, my lord. Because of this writ appeal, I could not press the matter before learned single. Challenging this, my lord, I preferred writ petition.
You are challenging this?
Yes, in separate writ petition I have filed. Yes.
How?
This.
Who are you?
My lord, I am the complainant on whose instance, my lord, these proceedings I have started up. I am a layout owner.
Amendment
No, I have some other interpretation, my lord. In fact, there, even accepting that amendment provision, necessarily it has to be, permission has to be obtained from central government. That is central government. Central government
got a MSME certificate.
Yes.
That is the end of the matter.
That apart, my lord, he has to obtain permission. Anyhow, my lord, I have filed.
Anyway, you
Yes,
do
yes.
whatever you
Yes,
want.
yes.
If the writ petition is pending, my lords, that order is not attained finality. The impugned order, what they are now contending, we are not served with the notice in the writ petition. Now they say that, my lords, that order.
Anyway, no action will be taken.
Yes, my lord. In view of
from the electricity board. You want to contest that matter, you contest.
If that is, my lords, my right to continue the business without absorption of the electricity.
They have already
then my
taken,
interest would
they
be
have
brought.
already taken a decision that in future such notice will be issued to you.
Should not be issued
No
and-
such action can be taken.
Yes.
That is enough. Learned counsel for the appellant as well as learned counsel for the proposed respond number 4, who was filed an application for impleadment, submit that due to the subsequent amendment brought to the relevant provisions of the Karnataka Municipalities Act, 1964, in the matter of the trade license to be obtained by the micro and small medium industries, enterprises, bracket alli MSME, that such enterprises which have a certificate of MSME, need not seek trade license from the local authority, and pursuant thereto, the first respondent, JESCOM, has also taken a decision that in future, no notice will be issued to the petitioner on the ground that it has not secured trade license at the hands of the local authority, the matter can be disposed of. Full stop. Next paragraph. Learned counsel for the proposed respondent would however submit that he has filed a separate writ petition calling in question the amendments. Full stop.
The order, man.
Huh?
The order.
Which order?
The order passed by grievance cell. That is what my
99.
lordship has right now read.
97, page number 97. The order which is now.
Filed a writ petition calling in question
Page number 99.
the order dated 9/3/2023. Full stop. Next para. Having regard to the submission made by the learned counsel for the appellant, that the grievance of the appellant is redressed, having regard to the amendment brought to the Karnataka Municipalities Act and the order decision taken by the JESCOM.
Karnataka Power, KPTCL.
KPTCL. JESCOM ಅಂತ ಇದೆಯಲ್ರಿ ಇಲ್ಲಿ?
ಇಲ್ಲ ಅದು
Actually,
Lord sir, the decision was, the amendment was carried to the rules called not conditions of supply of electricity.
ಅದಾಯ್ತು. This order is passed by JESCOM.
Just come.
order by consumer readdress.
Correct. That is having regard to the amendment brought to the rules in terms of the decision of the KPTCL. We are not concerned of that. ಏನ್ ಹೇಳಿದೆ? In its order dated 9/3/2023, that no notice will be issued or no action shall be taken against the petitioner for not obtaining trade license from the local authority, nothing further survives for consideration in this appeal. Full stop. Next para. Accordingly, the writ appeal stands disposed of.
Observation made may not pending writ petition. Observation made may not affect pending writ petition.
ಅದಕ್ಕೆ ನಾವು put it there in that sentence. ಒಂದು sentence ಹೇಳಿದೀವಲ್ಲ, you have filed
Yes.
writ petition.
Please.
Yes.
Great.
Whoever melts once.
Starting ಅಲ್ಲಿ 47 days delay in filing the appeal is condoned.
One
Serial
submission,
number.
there may be some clarification because they will not understand not all these technicalities. They will try to implement annexure V. At least that may be clarified more. Annexure V ಅವ್ರೇನ್
ಮಾಡಕ್ಕಾಗತ್ತೆ?
ಇಲ್ಲ ಅದು ಲಾಸ್ಟ್ ಟೈಮ್ ಒಂದ್ಸಲ ಕ್ಲಾರಿಫೈ ಮಾಡಿದಾಗ ಇದೇ ರೀತಿ ಮಾಡಿ ನಾವು ರಿಪ್ಲೈ ಕೊಟ್ಟು ಎಲ್ಲಾ ಮಾಡಿದ್ರು ಅಗೇನ್ ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಇಶ್ಯೂಡ್ ದಿ ಸಚ್ ನೋಟಿಸ್.
Directions have been issued that no such notice will be issued, no action will be taken against you on this ground.
ಹೌದು.
ಮತ್ತೆ ಹೆಂಗ್ ತಗೋತಾರೆ?
ಇಲ್ಲ ಅದು ಅನೆಕ್ಷರ್ ವಿ ಏನ ಅದು ಬರ್ದಿದ್ದಾರಲ್ಲ ಅವ್ರಿಗೆ ಅದು ಅನೆಕ್ಷರ್ ವಿ ಹೋಗಿಲ್ಲಲ್ಲ ಅಂತ ಹಿಂಗ್ ದೇ ವಿಲ್ ಅನೆಕ್ಷರ್ ವಿ ಇಸ್ ದಿ ನೋಟಿಸ್ ವಿಚ್ ಇಸ್ ಇಶ್ಯೂಡ್ ಮಾಲಾಟ್ಸ್ ವಿತ್ ಇನ್ 3 days
they will cut down the my electricity ಅಂತ.
Part of that order itself, no, it is a part of that order.
ಅದು ಇಲ್ಲ ಅಂದ್ರೆ again they will do it same thing.
ಒಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ learned counsel Shri Kripasagar Patil appearing for the first respondent Discom would also point out that in the subsequent order dated 6/3/2023,
Yes, 9/3
9/3/2023, comma, all the notices issued to the petitioner has been taken note of. Please, full stop. This would mean that pursuant to the subsequent order passed on 9/3/2023, comma, all the earlier notices issued to the petitioner will stand recalled, and in future, no action will be taken on the same ground.
Lordship, in serial 56, parties settle the matter, my lords. Part 56, parties settle the matter, my lords. Unfortunately, some of the respondents are not present today. We will sit on Monday, my lords, 20 people.
No, no, no.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಸರ್ ನೀವು ಇರ್ಲಿ ಕೇಳ್ಕೊಂಡು ಮಾಡೋಣ ಅಂತ ನೋಡಿದ್ದು 230 ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಫೈಲ್ ಕೊಡ್ರಿ.
ಓ ಬಂದ್ರಿ ಚಾರ್ಜ್ ಅಜ್ಯೂಮ್ ಮಾಡ್ಕೊಂಡಿಲ್ಲ, ನಾಳೆ ಬರ್ಬೇಕಂದ್ರೆ ಮತ್ತೆ ಕಾನ್ಫಿಡೆನ್ಸ್ ಗ್ರೇಟ್ ಡೇ ಅದು, ಗ್ರೇಟ್ ಡೇ ಇವತ್ತು. ಇಲ್ಲಿ ಬಿಗಿನ್ ಟುಡೇಸ್ ನಾಳೆಯಿಂದ ಕರೆಕ್ಟ್, ನಾಳೆಯಿಂದ ಸೆಕೆಂಡ್ ಫೈಲ್ ಓದಿರಿ ಮೊದಲ ಹೌದು ಕರೆಕ್ಟ್. ಇವತ್ತು ಬಸರ ಡೇರ್ ನೋಡ್ಕೊಂತಾರ. ಎಜಿ ಅಂತ ಮಾಡ್ಕೊ, ಯಾರು ಹೇಮಂತ್ ರೆಡ್ಡಿ, ಮಲ್ಲಿಕಾರ್ಜುನ್ ಸಾವ್ಕರ್, ಎಜಿ HGP ಅಂತ ಮಾಡ್ಬಾರ್ದು, ಎಜಿ ಎಜಿ. ಇವತ್ತು ಒಂದ್ ವೇಳೆ ಅಲ್ಲಿ ನಿಂತ್ಕೊಂಡ್ರೆ ಅವ್ರದೇ ಹೆಸರು ಹಾಕಿ, ಈಗ ಅವ್ರು ನಿಂತ್ಕೊಂಡ್ರು ಅಂದ್ರೆ ಅವ್ರದೇ. ಬಸರಡ್ಡಿ ಪಕ್ಕಕ್ಕೆ ನಿಂತ್ಕೊಂಡ್ರೆ ಯಾವ ಕೇಸಿಗೆ ರಾಠೋಡ್ ಫೈಲಿ ಬಸ್ಲಿಂಗಪ್ಪ ಕೊಡು, ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರು ಅಂತ ಹೇಳಿ ಏನಕ್ಕೆ ಕೇಳಿದ್ರೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರು ಅಂತ ಅಷ್ಟೇ ಹೇಳಿ, ಬಸ್ಲಿಂಗಪ್ಪ ಕೊಟ್ಟು. ಸ್ವಲ್ಪ ಅವೆರಡು ಬರ್ದಿ ಕೋಟಿನಲ್ಲಿ ಡೀಲಿಂಗ್ ಅಂತ ಕೊಟ್ಬೇಡಿ. ನಾನೊಂದು ಈಗ ಕೊಟ್ಟನಲ್ಲ ಪಟ್ಟಿಯಲ್ಲಿ ಡೀಲಿಂಗ್ ಕಡೆದು ಒಂದು ಬ್ಯಾಚ್ ಬರ್ದಿದ್ದು ಕೊಟ್ಬೇಡಿ. ಮುಂದೆ 18 ಟೋಟಲ್ ಈ ಬ್ಯಾಚ್ ಅಲ್ಲಿ ನ್ಯಾಷನಲ್ ಹೈವೇ. ಕೇಳ್ತೀನಿ ಸರ್, ಒಂದು ಪಾಸ್ವರ್ಡ್ ಇದೆ, 230 ನೋಟಿಫೈಡ್ ಇದೆ, ಕೇಳ್ತೀನಿ ಅವ್ರು ಏನಂತಾರ ಕೇಳ್ತೀನಿ. ನಿಮ್ದು ಪ್ಲೀ ಆಫ್ ಜೂನಿಯಾಲಿಟಿ, ಪ್ಲೀ ಆಫ್ ಜೂನಿಯಾಲಿಟಿ My lord, on submission, serial number 56, ಆಲ್ರೆಡಿ ಸೆಟ್ಲ್ ಆಗ್ತಾ ಇದೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ. ಐ ಆಮ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಸೆಟ್ಲ್ ಆಗ್ತಾ ಇದೆ ಪೆಟಿಷನರ್ ಸೈಡ್ ಇದೆ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಏನಿದೆ?
It was for filing corpus petition today, my lords, since two of the respondents are not present today.
So next week.
Serial number 56. At the request of learned counsel on both the sides.
Both sides.
Release this matter
Monday, my lords.
Monday.
on 25th of November.
Yes, ma'am.
Apply.
Past over matter?
But I am filing the
Number eight.
compliance affidavit.
In this case, I appeal for petition.
My lord, the order of the learned single judge was to consider the representation, page number 18. There's a direction to consider the representations. Representations are considered early, but endorsement was not given. My lord. Endorsement we are given on lately. For that, we have sought for unconditional apology, my lord. This matter pertains to lifting of chicken, mutton wastage. Earlier also lordship in the contempt proceedings says. Here again, my lord, some persons are lifting illegally. Wherever the complaints are given, we are issuing notice to them and collecting fine, my lord. More than that, we can't do anything, my lord. That is done, and we are taking an undertaking that in future they won't collect the wastage, my lord. If lordship looks at page number 5, my lord, we have written the letter to the concerned health officer. Based on that, my lord, at page 6, we have no, my lord,
We are disposed of that contempt.
yes, my lord. Once again, they filed one more writ petition seeking for consideration of representations. Same, my lord.
Again.
Again, my lord. Again, we have taken action, my lord, and collected fines from the concerned vehicles, my lord, at page number 6 in my compliance affidavit, my lord. We have seized the vehicles, collected the fine and released, my lord, and we have taken an undertaking from them, my lord. In future, they won't collect the wastage, my lord. Except this, nothing more can be done, my lord, because we don't have any powers.
Yes.
My lord, this is the second round of litigation. Even in earlier end of contempt, my lord, the same set of facts were brought to before this court and complaints affidavit filed. Bring to notice that we have seized some vehicle and after collecting fine, they have released the vehicle. From the next day, same thing is.
So therefore, what else can be done? You please point.
My lord, let them give police complaint and let them send him behind the bars.
We have noticed in our previous order, please see the last line.
Yes, madam. That is not been done.
We are not able to understand how the police can involve in this matter. Please see the order, sir.
No, madam.
We have observed.
Yes, madam.
Yes, madam.
We do not see how the police could play a role in the context of this list brought before the court. So you tell us, what can be done now?
No, but I am agent of the corporation. I am the
Sir, we have understood, sir. It is not enough if you simply say, this is going on like this in spite of directions given by the court. Now you please tell us what other process can be adopted.
The only thing is, madam, they have to stand behind the bars.
Huh?
When, madam, they are violating the.
So they have now saying, yes, we have taken action against all these persons.
It is only on the papers. It is only on the paper.
There are receipts, my lord.
But actually, my lord, nothing has been done.
Hmm.
Even, my lord, after giving their endorsement, this is the, my lord, photograph, a GPS photograph. Even yesterday, day before yesterday, the another person lifting the material.
I am the successful bidder. I have paid 5,90,000 for 1 year. The corporation has to protect my interest. They cannot say that what can.
Going on from how many years now?
From last year.
Huh?
From last year.
Only for 1 year.
It was for 3 years, my lord. It is now 1 year is left.
Only 1 year is left. If you are not happy, you leave it. Nothing can be done.
Because now we have issued a notice to him to pay the second year fee. If he is not interested, he can, yes. He has not yet paid the fees also. He has not yet paid the fees also, my lord, in spite of notice.
The corporation has to protect the interest of.
That is what, sir. You please tell us what can be done. What direction can be given? Please tell us.
Strict action will be taken at those persons who have.
Strict action. Strict anta helidre aaytu. Yen aaytu? You have said they are going to take action. They are going to seize all that vehicles and other things that they are using. Adikke na bitti in yen madakagutte?
If I go to the police says no, it is between you and the corporation.
Yeah, that is why, sir, we are ourselves said we do not understand how the police can be involved in this matter.
Because it is between me and the corporation. Some third parties are interfering with my work.
Violation of a contractual obligation. How can the police get involved? You please tell us. When is it going to come to an end?
It has come 1 year. 1 year term is already ended, my lord. Now second year we have given a notice to pay the amount. License fee they are not yet paid, my lord. They are not yet paid.
If you are not interested, you don't take it anymore. ಅದಲ್ಲ ಇದು ಏನಾಗಿದೆ ಇವ್ರಿಗೆ ಕಾಂಟ್ರಾಕ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. They have said wherever mutton chicken shops are there, that waste products should only be lifted by them anta. So last time also same thing happened. In spite of the contract being given to them, some people are disposing of on their own. Ella ಬೇರೆಯವರು ಕೊಟ್ಟು ಕಳಿಸ್ತಾ ಇದ್ದಾರೆ ಅಂತ. ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? That is why we said if your term has come to an end, you leave it. If you are not happy with this, you leave it. Just ಇನ್ನೇನು ಮಾಡಕ್ಕಾಗುತ್ತೆ?
Corporation is an intermediate.
You have not made any further payment for the extending the contract.
We have issued a call letter, my lord.
That's all. They will make some other arrangement. ಮಾಡ್ಕೋತಾರೆ ಅಷ್ಟೇ.
When they have awarded the contract in my favor.
ಆಯ್ತಲ್ರಿ ಮುಗಿತಲ್ರಿ ನಿಮ್ದು ಟರ್ಮ್ ಬಿಗಿರಿ ಯಾಕ್ರಿ ಬಿಡ್ತೀರಾ ಈಗ?
ಇಲ್ಲ ಇನ್ನು 3 years.
If you are not happy, you leave it. No, you have not made payment for the second year.
Second year they have to make payment. If they make payment only, then it will be continued.
If you are not happy, then why do you want to take it? You will leave it at that. ಅವ್ರ ಕೈಲೂ ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ.
Corporation is a state. It is a state machinery. They have to take action. They cannot say helplessness.
ಯಾವ ಪ್ರಾವಿಷನ್ ಗಳು ಏನ್ ಮಾಡಬಹುದು ಅಂತ ದಯವಿಟ್ಟು ಹೇಳಿ. ಅದೇ ತರ ಮಾಡೋಣ. That is why, sir, we have observed that we do not know how the police can be involved in this matter.
Yes.
How police action can be taken? You please point out. Under which provision?
They are interfering with the administration of the state government. This is a corporation. It is between me and the corporation. They are interfering with the work of the corporation.
ಯಾವ provision ತೋರಿಸಿ sir? Let us see. This is a second round of litigation at the hands of the same party. Stop. Earlier, such contempt petition was filed before this court in CCC number 200175 of 2023. It was the grievance of the complainant that though a contract was awarded to the complainant at the hands of the respondent, Kalaburagi Mahanagara Palike, to lift and dispose of chicken and mutton waste and a consequential direction was issued to all the persons who are running the mutton and chicken stalls that they shall dispose of the waste material only through the complainant herein. Nevertheless, many of the shop owners were disposing of the waste material through some other source. Stop. An affidavit was filed by the Commissioner of the Mahanagar Palike stating that notices have been issued to all the concerned to enable lifting of the chicken and mutton waste within the city limits of Kalaburagi only through the complainant, and that strict action will be taken against violators. Full stop. The contempt petition was disposed of. That in terms of the notices issued by the commissioner and or the concerned engineer of the Mahanagar Palike, if any of the shop owners dispose of or attempt to dispose of the chicken and mutton waste material to any other unauthorized persons, the Mahanagar Palike shall take action in accordance with law. Full stop. We had also indicated that we do not see how the police could play a role in the context of the list brought before this court. Full stop. Next para. Learned counsel for the respondents, more particularly the Commissioner of the Kalaburagi Mahanagar Palike, submits that similar complaints have been made by the complainant, and on a writ petition filed by the petitioner, similar directions have been issued by the learned single judge in WP number 200861 of 2024, dated 18th of April 2024. Full stop. Today, Senate Counsel for the first respondent has filed complaints affidavit at the hands of the Commissioner, Kalaburagi City Corporation. Stating that the representation given by the complainant is considered and an endorsement is issued to the complainant by an officer of the corporation on 13/11/2024, informing the complainant that his representations were considered on 29/2/2024 itself, and necessary directions were issued to the health officer to take necessary action against the concerned persons who are lifting chicken and mutton waste unauthorizedly. Full stop. It is also stated in the endorsement that necessary action is also taken against the concerned persons full stop, along with the compliance affidavit and copy of the endorsement dated 13/11/2024 issued to the complainant. Copies of the vehicle seizure notices have also been enclosed. Learned counsel for the first respondent would therefore submit that action has been taken in terms of the directions issued by this court. Full stop. Some of the persons who permitted unauthorized lifting of such waste material have also given an undertaking that they will not do so in future. Full stop. Moreover, it is submitted that 1 year term of the contract given to the complainant has come to an end, and the complainant has not paid the requisite fee for renewing the contract. Full stop. Next para. Having gone through the complaints affidavit, we are satisfied with the action taken by the first respondent. Full stop. We are constrained to say that even on the previous occasion, we had expressed our doubt as to how police could play a role in these matters. Full stop. If the complainant is not satisfied with the action of the first respondent, and if the complainant feels that the first respondent is unable to fulfill the terms of the contract, then it would be advisable for the complainant to terminate the contract. Full stop. Next para. With these observations, the contempt petition is dropped.
Please.
ಇಲ್ಲ ಕರೆದು ಬಿಡಿ.
Seal number 64, Harshvardhan R. Mali Patil.
Lord, I would like to address on Lord 2-3 issues, Lord, which are raised by the others. One is, Lord, the effect of this Abdul Razak judgment, Abdul Razak versus Kerala Water Authority and others. And Lord, the effect of Satish Kumar, Lord, as
Judgments compilation.
There are two judgments, Lord, on the proposition. They rely on Lord Abdul Razak and others versus State of Kerala. It's listed at Lord 183 page number of their compilation, spiral binding. Here, Lord, the court, based on the Constitution bench judgment of UP Awas Yojana, has held that they are Lord a necessary party and they are required to be arrayed as a party. Lord, the first issue, my lord, in this is, this was an appeal by this beneficiary. Here also, my lord, Abdul Razak case, the state, the Kerala Water Authority, which claims that, my lord, it was a necessary party, filed an appeal. It was under this context, my lord, it was considered. Here we are, my lord, dealing with a situation where beneficiaries straight away come in, my lord, writ petition, not challenging the award. Second is, my lord, this authority is in a situation where, my lord, a corporation was incorporated by a statute giving, my lord, retrospective effect, my lord, to its existence. And, my lord, the liabilities and, my lord, the assets were under the statute, they were transferred. So this, my lord, is a different situation. The basis is UP Awas Yojana. They say in UP Awas Yojana, beneficiary is held to be a necessary party. So here this party is also a necessary party. Though, my lord, on facts, they appear to be, my lord, have come into existence subsequently. My answer is, my lord, this judgment has not considered the proposition of what is the consequences if the beneficiary or a third party comes into, my lord, existence subsequent to the acquisition and they become, my lord, liable to pay compensation. This is not answered. They assumed, or, my lord, they went on a proposition saying that they're the beneficiary, they're necessary party. So this judgment does not answer the proposition of law, which, my lord, are involved in the present case. Whereas, my lord, Satish Kumar case was a judgment directly on the point where it says that, my lord, what will happen if a transferee is, my lord, required to be arrayed as a party or whether he is a necessary party. That, my lord, is applicable to the present case. The distinction is this was a statutory authority by virtue of statute having retrospective effect. The basis was UP Awas Yojana, which was clearly in terms of, my lord, a beneficiary for whose benefit the acquisition was made. My lord, now, my lord, and my lord, the third difference is there was an appeal filed by these persons. We are dealing, my lord, with a situation where writs are filed. Page 186, your lordships may kindly, my lord, paragraph 4. Lord, I'll read, my lord, about 6-8 lines, my lord, from bottom. It starts with, my lord, oppose enhancement. 7th line, my lord, from bottom. Collected and oppose enhancement of said amount and also adduce evidence in this regard. Lord, they are now dealing with, my lord, I'll read the entire paragraph 4, my lord. This judgment also considers, my lord, what's the proposition of UP Awas Yojana Constitution Bench regarding writ and, my lord, the appeal that can be filed. The state of Kerala and Kerala Water Authority preferred appeals. This may kindly be noted, my lord. They filed appeals, laying challenge to several awards made by the civil court and for enhancement of the amount of compensation. During the pendency of the appeals before the High Court came the Constitution Bench judgment of this court in UP Awas Evam Vikas Parishad versus Gyan Devi, wherein it was held that company for whose benefit the land was acquired were also entitled to appear and adduce evidence for the purpose of determining the compensation. So this was the understanding, and based on this, one of the grounds which persuaded the Constitution Bench in forming the opinion was that the amount shall have to be paid by the local authority, and therefore it was proper party entitled to contest the proceedings. We need not reproduce in extenso the law laid down by the Constitution Bench. For our purpose, it would suffice to note that in the opinion of the Constitution Bench, the right conferred on the local authority under section 50(2) of the Land Acquisition Act in the light of the scheme of the Act carried with it right to give adequate notice, right to be given adequate notice by the collector as well as reference court, before whom acquisition proceedings are pending of the date on which the matter of determination of compensation will be taken up. The local authority is a proper party in proceedings before reference court and is entitled to be included as a party in those proceedings wherein it can defend the determination of amount of compensation by the collector and oppose enhancement of the said amount and also adduce evidence in this regard. This is important. Next, in the event of enhancement by the amount of amount of compensation by the reference court, if the government does not file any appeal, the local authority can file an appeal against the award in the High Court after obtaining leave of the court. So even as per this judgment, they explain what is the proposition in UP Hours, the Constitution bench. They say that in reference, they are entitled to participate by impleading. Before my Lord Collector, they are necessary party, notice has to be given. And if an award is passed by the reference court, then the next course is to file an appeal by taking my Lord leave of the court. What weight, my Lord, in the mind of the Lord Honorable Supreme Court while considering this judgment is, my Lord, at paragraph number 9. It's the judgment of, my Lord, Constitution. In our opinion, paragraph 9, my Lord, on page 187. In our opinion, the High Court has erred in taking the view which it has taken and directing the reference cases to be remitted to the civil court consistently with the law laid down by the Constitution bench, as KWA shall have to be included as party to the proceeding before the civil court. From very beginning, a retrial becomes unavoidable. So, my Lord, it is ultimately the Constitution bench judgment, my Lord, which is, my Lord, weighing the mind of the court. The next proposition, my Lord, the next line of argument is, my Lord, what is the effect, my Lord, for a moment, if we assume that, my Lord, Abdul Razak case says that a subsequent transferee or a allotee or a, my Lord, person who gets into that the project is, my Lord, not arrayed as a party, whether he becomes necessary party. My Lord, if that is the understanding of this judgment, my Lord, Satish Kumar case, my Lord, is subsequent, my Lord. This is of 2002. The latest judgment being that of, my Lord, Satish Kumar case, that will prevail upon, my Lord, the position of law. Just read, my Lord, one paragraph. Lord, ultimately, my Lord, the base. It's also listed. Chip is holding, my Lord, my compilation, my Lord, where Satish Kumar case is the first case, my Lord. The argument that, my Lord, we are required to pay, the assets, liabilities are transferred to us, we become liable, liabilities on us. My Lord, they were all discussed in this case, my Lord, paragraph number 4. It's on page 3, my Lord. Thereafter, the matter was dealt with by the High Court in the impugned judgment. The High Court held that the allottee had a right to implead as a party for the following reasons. 1, the state or the local authority for whose benefit the land is acquired may not lead proper evidence or advance effective arguments. My Lord, all these contentions, my Lord, which are now taken are already, my Lord, answered. A clause in the deed of the allotment in favor of the allottee provides for payment of additional price as a consequence of enhancement of compensation. So, my Lord, contractually, they are made liable. By virtue of a contract, they are made liable.
That is not so here.
Sorry.
That is not so here.
Maybe. As a result of, my Lord, enhancement of compensation reference of the reference court, the company in question was required to pay about 900 crores. My Lord, these are, my Lord, the broad contentions taken. The answer, my Lord, trouble, my Lord, paragraph 9, my Lord, specifically say that, my Lord, these cannot. Paragraph 9 on page 4. To determine the question whether post-acquisition allotment of land is necessary or proper party or has any locus to be heard in the matter of determination of compensation, we may refer to the scheme of the Act. The acquisition may either be for public purpose as defined under section so and so, or for a company under so and so. So, two different distinctions or categories of acquisition. If the acquisition is for public purpose, the land vests in the state, and after collector makes an award and possession is taken. Till the award is made, no person other than the state comes into the picture. Once the land vests in the state, the acquisition is complete. Any transferee, Lord, they don't, Lord, curtail the word, Lord, any transferee from the state is not concerned with the process of acquisition. The state may transfer the land by public auction or by allotment at any price with which the person whose land is acquired has no concern. The mere fact that government chooses to determine the allotment price with reference to compensation price determined by the court does not provide any locus to a allottee to contest the claim for enhancement. So the unqualified word is, my lord, transferee. If the transferee, my lord, cannot get into this litigation, be that.
Therefore, see, everything is again based on the Constitution bench judgment in UP Awas. We will look into that only.
Yes. UP Awas Yojana was a case where acquisition was for the benefit and it was initiated at the instance of the beneficiary there, and they were not arrayed as a party. That's the distinction, my lord, I'm trying to make, my lord, repeatedly.
With your lordship's line leave, if my learned friend has finished, I'll just take 2 minutes, my lordship. If my learned friend has finished.
Aita?
My lords, there's one more judgment in WP number 223567 of 2020. I think the copy is given to my learned friend. Abhimanyu is there, my lords. To which order passed by the learned single judge, my lords. Basically saying that the respondent KNL is a beneficiary and has to be made a party, my lords. Against which no appeal has been filed. It has become a final.
Yes, Srinivasa Gowda.
That is regarding Vaijanath and my learned friend had appeared in that matter, my lords. No appeal has been filed and this judgment has become final, my lords. MH Patil anta ide. Yes, my lord. Justice Anant Ramnath Hegde, my lords.
Yes, yes.
I'm sorry if my learned friend saying he is not appeared, then is not appeared, my lord.
He has not appeared in this. No, it is a fact that in many other matters where he is appeared, he has himself made a statement. All right, we don't press on this one.
No, there's a compilation of judgments which they'll share, where in the trial court he has made them a party. My lord, it's a case of convenience. My Abhim will give. There are cases where it's not that they have not made a party. Whenever they want, they made a party. Otherwise, they have left them as a party, my lords.
We have made them a party. My lord, I'll clarify that point. We have made them a party wherever acquisition was at their instance. My lord, once, my lord, in this case, my lord, Amarja project is handed over to them in the year 2005. Post 2005, wherever acquisitions have taken place, it is not that we make them party. The reference itself is be sent, and in that only they will say that so and so is the beneficiary.
Yes.
So that way, my lord, they are made as parties. That are, my lord, held against us, my lord.
No, these awards are also of the year 24/7/1995, where I think Mr. Naveen Nath will argue that, my lord. There are two things, my lord. One is this judgment has become final, my lord. In so far as this case is concerned, also the award is dated 2017 in NLC number 155 of 2016, my lords. And second is, my lord, ultimately the question is, the whole matters all these are based only on one judgment, my lord, on the count of parity. There is no basis at all. Apart from that, my lord, there is no basis at all. So let the matter be remanded back and matter decided all these cases within 3 months, my lord. We'll cooperate with the proceedings, my lords, in a time-bound manner. They cannot be a beneficiary pre and post. Ultimately, from date of transfer, as on today, the amount is being paid by KNNL, my lords. I don't want to repeat, my lord. The whole documents, government orders, everything, assets and liabilities, loan is taken by KNNL, mortgage is done by KNNL, liability is discharged by KNNL, execution is on KNNL. Last topic, para 7, page 4. The impugned order by the petitioner is an order passed of first appellate setting aside the order of the reference court. The first appellate court has enhanced the compensation pay. Then the present petitioner is the beneficiary and enhanced compensation is to be paid by the beneficiary. However, the beneficiary is not made a party, though it is necessary party in the proceeding seeking enhancement. Under these circumstances, the impugned order is untenable and set aside. And here, my lord, 6 months' time is granted to dispose of.
Difficulty is this, my lord. Here also it says that beneficiary, so and so is the beneficiary, is not made as a party, set aside. Lord, I am not disputing that proposition at all. The question is, who is the beneficiary? Other, Lord, that requires, my lord.
This does not arise from the same notification.
Same, my lords.
Same notification.
Same notification.
Same project.
Same project also.
Same project, Amarja project.
But acquisition notifications are different.
They may be different. That will have to be cross-checked. But this is also a similar case, Your Lordship.
No, he was mentioning
Yes.
that after 2005, if the notifications have been issued, then certainly there will be beneficiaries. No doubt about that.
We cross-checked in this, but there have been instances, Your Lordship, wherein the same council has arrayed us as a party.
The learned senior counsel also has pointed out that it's a concession made by him.
No, that's not on concession.
Not been on concession, Your Lordship.
It is not on concession, my lords. Where no concession alla. Pre-2005, also they made them party independently, without concession. We'll place those judgments.
Your lordships are referring to the order.
These are all cases arising after the notification.
My lord, there is one is
He's arising therefore that is not the same.
Not be held against him. For a Muslim. Assume that it was prior of. I cannot curtail my affidavit for that. This way or not be it on the council. I have learned council has accepted this. Non-ex council accepts that doesn't hold my lord. Party as against party, my lord, is hold. Party in this matter wants me to contest, but I have everything. I already answered. Lord, come to UP awards, please give this. Yes, I'll just find. Under which notification? Yes, I just find it.
Lord, may I just say this, my lord? I'm sorry. My lord, the compilation which my learned colleague will just hand over, my learned friend is not correct in saying that those were cases where subsequent to 2005, where the Nigam is a beneficiary has made them parties. The compilation shows that these are matters where the notifications are dated 1983. And in those matters appeals, he has made us a party and the same council appears. My lord, that is part of the third compilation which my learned friend will hand over to your lordships. All clearly borne out by the judgments.
Now we must be in a position to answer these, my lord.
You are also a party to that.
Lord, if your lordships have a look at the very first order at page 3. Page 3, if your lordship sees, my learned friend appears for the appellant, my lord, here, my lord, that is at page 3, Anna Rao. And at page 5, yes, and page 5, your lordship sees the fourth line. Section 4 notification is 26/2/1983. Yes. 91 LAC, Section 4 notification of 26/2/1983. And it goes on, well, all these matters are for the, in respect of those acquisitions. Page 14, 50, 15, your lordships is same. My learned friend appears in this matter also. Page 23. Same.
Second case also same.
Same. And at page 25, your lordship find the same notification. And then, my lord, at page 33, my learned friend appears. At 35, the same notification. Again, page 43, your lordship will note 43 and 45, same acquisition. Page 53 is the next order, my lord. At 55, 1983. '63, my lord, is different. My learned friend did not appear there. Of course, that's but of course the Nigam was made a party there. So I'm not.
Page 101
as well. Yes. And Lord, even at page, even where the other council appeared at page 63, the notification is dated 1997, which your lordships will find at page 66.
But page number 63, KNNL is not a party.
My lord, KNNL is a party. At page 65, your lordship will find it. Page 65. And my lord, 73 also another council appeared. This is a this is a notification of 1987, which your lordship will find at page 75. '83 again another council. My lord, this is also a notification of 1987, which your lordship will find at 85, para 2. So it can't, my lord, my position can't be subjected to the whims of a council, my lord, or a lawyer based on a legal advice. It has to be based on some basis in law. And then page 101, my lord, my learned friend appeared in this matter. This, my lord, is again a notification of 26/1991, which your lordship will find at 103. Bennitora project. And then, my lord, at 111 is the next order, my lord, that my learned friend did not appear there. This is a notification of, my lord, 1993. At 113, your lordship will find that. And page 121. This is also a matter where my learned friend did not appear. This is a notification of 18th February 1993, which your lordship will find on the very top of page 123. And my lord, the last order is at page 135. My learned friend did not appear. This is a notification of my lord, 1992 at page 137, para 3. No, my lord, I'm sorry that the section 4 notification 25/3/1993 at page 136.
All right.
So, my lord, that is how we stand today. My lord, only one more point, my lord, in law. My lord, irrigation is a state subject. well, it's in the list 2. Now, you can't say, my lord, are you trying to suggest that the state does not have the power to assign a irrigation project or a drinking water project to any of its entities created by itself? Well, this actually, the question is the larger issue about the executive power of the state, because this is a matter within its competence. And tomorrow to say that the Nigam is not required to be heard as a party, my lord, it has far-reaching implications. It's not merely related to acquisition matters or so many other things. So, my lord, that is all that I needed to say, my lord. I think I made my submissions. Grateful, my lord, grateful.
Me from my lord representing or contesting the position of law in this case. That's will be not the second contention. The third will be, my lord, even after contest, the result is, my lord, the same awards. Your lordships may see, well, judgment the connected matters, illi matte writ. The issue is this: they are picking and choosing, my lord, certain appeal or, my lord, the awards which they want to contest, saying that we are not hereditary.
My lord, that is incorrect statement. Let him not make that statement, my lord.
Allala, nan yak ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅಂತಂದ್ರೆ, there are, my lord, certain matters. If they don't, my lord, contest these matters, here they are, my lord, heard. What's the result? The result is the same award. The determination of compensation is almost, my lord, similar. So, if the result will be the same, why do they want to, my lord, insisting this court that technical compliance has to be made? So, my lord, my argument would be, even if it is assumed that they are necessary party, then still, my lord, the court has to look into whether there is a case, my lord, made out by them to set aside the award. The award doesn't stand on its own. My lord, age is right, my lord, in saying that we must establish what we are entitled to. I'm not, my lord, running away from, my lord, my judgments being tested. I'm only making out a case that testing before this court has to be done in a procedure note to law. You cannot take blanket orders, my lord, saying that all 300 cases, 500 cases, you please set aside, we are not hereditary. I'm opposing that proposition. If you come one-on-one case, no, this case is wrong, this has to go back. No, I have absolutely no difficulty on that. It's the blanket orders of, my lord, all cases where, my lord, they claim that they are not hereded as a party. That, my lord, being set aside en masse, my lord, is the difficulty. Lord, I was on the point of, Lord, that UP Awas Yojana. As your lordships rightly said that, Lord, the proposition in UP Awas Yojana will stand.
Yes.
That is, Lord, paragraph 23, page 160 of their compilation. What was the factual matrix there, Lord? The consideration there was, Lord, page 160, Lord, paragraph 23. The distinction which I'm trying to make is, Lord, that
paragraph
23, Lord, it's the second paragraph. Under section 52 of the Land Acquisition Act, the company for whom land is being acquired is also entitled to appear and adduce evidence for purpose of determining the compensation. Since the company for whom land is acquired stands on the same footing as the local authority, whatever has been said with regard to local authority would apply to the company. It is, however, made clear so and so, so and so. So it is a situation where, my lord, land was acquired for them. They are not standing as a transferee, assignee, allottee. Lord, mere change of name will not, my lord, change the position of law. My lord, the other point that was, my lord, brought to the notice of the court was, my lord, certain matters which were remitted back from the Honorable Supreme Court. My lord, there are 4, my lord, batch of matters which are, my lord, now ordered by the Honorable Supreme Court. 2 batch of matters, my lord, the contentions was same, my lord, Nigam not a party, all are, they are not contiguous land, you are relying on the same judgment. All those things were same. Some of them were argued on the same day. 2 matters, my lord, one before Justice Mohan Shantan Godur, he dismissed the, my lord, petition, the special leave petition of the KNNL and upheld the, my lord, award of the first appellate court therein. He observed that, my lord, the interest period delay, you are not entitled. My lord, that was clarified. That was the position. In another batch of cases, my lord, out of the 4, my lord, 2 are dismissed, 2 are remitted back. Worship may take, my lord, my compilation 143 page number. I'm sorry, my lord, I'm fluctuating from one compilation to other. Or else, my lord, in this compilation also it is.
Regarding what?
Revappa case, my lord. Huh? This is, my lord, another judgment where it is said that, my lord, Nigam contested on the ground that we are not arrayed as a party. We were not a party there. But still court said that on merit, you don't have a case because in some other matter pertaining to similar acquisition or say same notification, you have already satisfied the award, and the matters about 5-6 matters, my lord, a batch of 5-6 matters that was dismissed. Based on this, my lord, they are also conceding insofar as, my lord, this notification is concerned, saying that this is the award, it is settled, and some other matters are also disposed of. 2 batch of cases, my lord, are remitted back. I will point out those, my lord, matters which are remitted back. That's there in their compilation also.
Commencing from page 81.
Yes, from 81, my lord. I will only point out, my lord, page 91. My lord, the issue is, my lord, unanswered by the Honorable Supreme Court. What I'm trying to put forth is these remand orders cannot be a basis to hold that, my lord, Nigam is a necessary party. Page 91, they say that, my lord, accordingly, we keep all the contentions available to both the sides open to be considered by the High Court on its own merit and in accordance with law.
Yes.
So, my lord, they say that, my lord, court observed this, court did this, therefore, my lord, it's already settled in the remand order, my lord, cannot be a ground. Now, my lord, the next remand order, which is on the basis of this very judgment, Justice Suryakant's judgment, my lord, it starts from, my lord, page 107. I will read, my lord, from 117, my lord, last 2-3 paragraphs. There is a mandate, my lord, put on this honorable court regarding those remand matters, how it has to be dealt with. This mandate, my lord, I propose that it will be applicable for these set of cases also for determination. Page 117, my lord. Paragraph 14, my lord. 13. We have considered the rival submissions made by the learned senior counsel for the parties. It is not in dispute that a batch of cases has been remanded by this court for consideration by the High Court as seen above. It is also an admitted fact that those matters pertaining to same broader acquisition, though they possibly pertain to different projects in a peculiar situation where some of the judgments of the High Court attained finality as the compensation amount as enhanced stands paid, whereas the others are still subject matter of adjudication, we deem it appropriate to remand these cases also to the High Court so as to, this is important, so that a holistic view pertaining to the subject acquisition, at least project-wise, can be taken by the High Court. The High Court will make an endeavor to infuse uniformity in matter of award of compensation to the extent it is possible in accordance with law. Second, paragraph 15. It goes without saying that the High Court, while undertaking this exercise, will not reduce the compensation to a rate which has already been paid to some of the landowners and which has attained finality. Lord, the ultimate, Lord, the mandate is, if I show, my Lord, that some landowners similarly situated have been paid, then, my Lord, interference should not be called for. This exercise has to be done, my Lord, in the proceedings as well. It cannot be a blanket order of remand of all the matters saying that, my Lord, they will have to go back because they were not arrayed as a party. If I show that some person similarly situated has got the compensation at this rate, and my award stands on parity or lesser than that, then, my Lord, there should not be any interference. This order, in fact, my Lord, they sought for clarification. When this matter had come up, my Lord, before the learned single judge, they made a submission that we will seek clarification because this will come in the way. An order of clarification was also given, reiterating the same position that, where is that, Lord, that, clarification. I'll just submit that, my Lord. Lord, there was to point out, yes, that in respect of the compensation enhanced in your favor, yes, the same amount has already been satisfied in respect of another claimant. Yes, yes. If that is so, then this clause will be directions will be attracted. That it cannot be less than that. It cannot be reduced further than that. If they have satisfied this claim in respect of another claim. What happened to this matter after remand? They are pending before, my Lord.
Lodge, they've been placed before the learned mediator. They learned appeals entered the court. Learned single judge. Learned single judge is placed it before a mediator, retired judge. No, my Lord, it has been extensively argued, but then, my Lord, a suggestion came from the court that why don't you try to resolve it through mediation? So we said, yes, why not? So that's how the matter has been referred to. Resolve it through mediation. So we were also agreeable to that.
54 matters.
So, my Lord, that's before, my Lord, a learned retired judge of this court is the mediator, my Lord, parties are appearing before.
And about
20 matters, my Lord, are
disposed
on the contract.
Fifth,
My Lord, they are listed there before.
Fifth, my Lord, the matters are listed, and my Lord, the mediator, my Lord, making his effort for reconciliation. 54 matters were reserved, they were not against mediation. That's the position, my Lord, insofar as remitted matters. Out of the remitted matters, about 20 matters, my Lord, on their concession, saying that similarly placed matters we have already satisfied, though, my Lord, there also they were not arrayed as a party. In the appeal also they were not arrayed as a party. They gave that concession and they are dismissed. Sorry, allowed. The appeals are allowed, and, my Lord, the amounts are redetermined. About 21 matters, my Lord, are the compensation is, my Lord, redetermined at, my Lord, 1,52,000 odd, my Lord, for the notification of the year 1990. 20 matters, where, my Lord, they came and gave the concession that it is can be disposed of. So, any of the matters that can be correlated with the present to this matter. My Lord, my lord, my research was that, my lord, in this batch of cases, my lord, it arises, my lord, few matters they have not filed writ petition. Some of them they are filing. A batch of about 7 to 8 cases, my lord, which is disposed of. Told, my lord, some of them, the registry is showing only one writ petition, but my lord, I'm told some of them, my lord, the petitions are filed, others, my lord, are not filed. To quote, my lord, one example, my lord, I'll point out, my lord. Lord, at least those matters, my lord, where I can point out that, my lord, the notification of that year, my lord, for that village, this is the determination satisfied. Those matters at least should be segregated, and my lord, because, my lord, this order in this writ appeal will have a bearing on, my lord, about about 300, my lord, if I'm not wrong, matters which are in writ petition. The writ court, my lord, is holding the order, my lord, for the order of this honorable court regarding, my lord, the question. If that is done, my lord, that would, my lord, meet my apprehensions. My entire exercise of, my lord, asking them to file appeal is to have an opportunity to contest and defend, my lord, my case on merits. That exercise has to be done. That has to be done in this case also. The remand, the order now impugned is an order saying that, my lord, only because you did not make them a party, it goes back. This, my lord, stands against the latest order of this honorable, the Honorable Supreme Court, where they specifically say you cannot do this.
My lord, I didn't want to come in, but I must point this out, that my learned friends, please note his arguments are self-contradictory. He says, the writ petition is not maintainable, you should go and file an appeal. Now, he says in the writ petition, the court should follow the Supreme Court judgment and examine the merits of the matter. My lord, we are not on the merits today. The whole idea is, my lord, whether we were required to be a party or not, and if your lordship finds it that yes, we were required to be heard, then your lordship will relegate us to the remedy of an appeal, whichever way, my lord. So, my lord, the point here is not, you can't go into the merits at this stage unless and until the court issue is, because this will keep arising again and again. And, my lord, on merits, my lord, the matter will be argued only when I have legs to stand before the appellate court or whichever forum your lordship will relegate to me in these proceedings. So you can't take the court to and my learned friend is not right in saying that in clarification it reiterate it. The court has actually clarified, my lord, we'll pass on that order to your lordship, my colleague will hand it over. The court has made it clear, and we have also followed that. Same notification, same, my lord, day, same project, yes, uniform compensation, or same village, same compensation has to be followed. No difficulty on that. We are also saying the same thing. That's why we made those concessions on in the remanded matters. Some of the matters pertain to same notification, same village. Of course, regardless of whether there was any evidence led by the landowner, we have agreed to that compensation. But in these proceedings, my lord, on the merits, my lord, my learned friend is contradicting himself. He says these writ petitions are not the appropriate remedy. You file a permission to file an appeal and then contest the matter there. That, my lord, in case if your lordship, my lord, reject this appeal, my lord, in terms of the directions of the learned single judge, it has to go back to the appellate court. And there, my lord, the Supreme Court's orders will be tested, my lord, whether those principles stand satisfied in a particular case or not. That's the way to look at it, my lord.
My lords, the learned advocate general had handed over a judgment. Your lordships had asked us if that particular section 4.1 notification is available. We've traced out the first appeal order. It is dated 4th of February 1993, Your Lordship. That is prior to our incorporation.
This
Justice Hegde's judgment, Your Lordships.
24 January 2020.
This, writ petition number 223567 of 2020, Your Lordships. This pertains to a section 4.1 notification dated 4th of February 1993, Your Lordships.
What is the date?
4/2/1993.
4th February 1993, Your Lordship. That is the date of the section 4.1 notification prior to our incorporation.
Yes.
See, but even this one, what he's saying is, see, you may point out to many such cases where this contention is not raised.
Yes, sir.
This contention is not raised and not answered.
Yes, sir.
Then at best it can be held only against that party. You can't hold it against all the claimants, because here, in this particular case, this claimant is raising this issue.
My Lordship,
And that is required to be answered. That is his contention.
my Lord, Justice Hegde's judgment has held the law till this date. There is no appeal filed against it.
No, there is no such.
And-
This issue was not raised and it is not answered here.
Your Lordship, we had filed this writ petition. This was at our instance, Your Lordship.
Where is the issue answered?
Your
This
Lordship,
issue is not raised at all.
the grievance of the petitioner is that the land belonging was acquired for the benefit of the petitioner, which had undertaken the irrigation project. Aggrieved by the award, land acquisition
Correct.
officer had filed the petition.
This issue is not raised,
Yes, Your Lordship.
saying, no, they are not a beneficiary.
Yes, Your Lordship.
That issue was not raised, it was never answered.
Yes, Your Lordship.
It is taken for granted that they are beneficiaries.
Yes, sir.
That will not satisfy the requirement. Anyway, we'll consider.
Lord, in this case also, my lord, your lordships, if your lordship sees, my lord, the order impugned arises from a common batch of about 8-9 cases, my lord. So at, my lord, page 49. My instructions are that, my lord, only few cases, my lord, are in appeal, in writ petition. Others, my lord, they don't choose to file an appeal. All 8 cases, my lord, there is no writ petition, my lord, filed. Now, the consequence of this exercise of, my lord, they doing this pick and choose business, my lord, that was again, my lord, dealt by the Honorable Supreme Court in their own appeal. They are not doing only for this project. This has been, my lord, their consistent, my lord, approach. Lordship may kindly see, my lord, my compilation. Produce that. They. Page, my lord, 142 of my compilation. This is, my lord, by Justice B.R. Gavai, dated, my lord, April 11, 2023. Shivappa and, my lord, others. Paragraph 9, 10, and 11, my lord, I will read on page 144. In the said case also, the reference court had granted compensation. My lord, paragraph 9, my lord, on page 144. In the said case also, the reference court had granted compensation at the rate of 4,61,250 per acre. The High Court wide order dated so and so has allowed the said appeal to be withdrawn, and the same had been placed on record before this honorable court in IA number so and so. So some they may not withdraw it, some they are challenging. Though a period of more than 6 years had lapsed, the said position is not contested by the respondents. Now, my lord, paragraph 10. The state or its instrumentalities cannot be permitted to adopt an attitude of pick and choose. If the state has, para 11, if the state has accepted the award of reference court in respect of some of the claimants, it cannot be permitted to adopt a different treatment to the other claimants. Such an attitude smacks of patent discrimination. Your lordship may kindly turn to page 142. This is, my lord, an appeal against the Karnataka Niravari Nigam, where, my lord,
Therefore, we are asking you,
yes,
you will have to place that information.
I will place.
If you place that information,
yes,
this can also be viewed from that angle.
Oblige.
My lords, in this particular judgment, which my learned counsel cites, we are arrayed as a party. We are arrayed as a party before the High Court as well.
Correct.
Yes.
These were the observations.
Yes.
Even in your presence.
Yes, Your Lordship. We had sort of distinguished that judgment on facts, Your Lordship, not on the basis of us not being heard, Your Lordship. It started on the premise that our contention was that we were not heard. We were heard and we tried to distinguish before the learned single judge. We failed. Therefore, before the Supreme Court also, we attempted to distinguish. It is their SLP, Your Lordships. This is Shivappa versus the chief engineer.
Yes.
We are arrayed as a respondent. In that case also, Your Lordship.
See, the same argument will hold good for you also.
Yes, Your Lordship.
If the state has accepted the enhanced compensation and it has satisfied the award amount.
If the state has, Your Lordship.
Ultimately, who satisfied the?
If we have
not satisfied, if we have not paid the payment, Your Lordship.
Because
How is it possible that in some of the cases, state will satisfy and some of the cases we will
Your
Lordships in certain projects,
for example,
Penethora and Lower Mullamari, prior to us handing over, reference board awards were passed.
In
In those cases, still the reference board awards were passed.
That is
That is prior to our incorporation. Compensation was also dispersed.
by the state. In some
In some cases.
Thereafter,
the projects were wholesale
transferred
to us, assigned to us,
and
and
the appeals
the appeals were filed after 20-25 years.
In some
In some cases, we have made parties, in some cases, we have not made parties. But that judgment is not against that beneficiary. They contest with entire Bima litigation at the instance of beneficiary. Our judgment ಯಾವಾಗ satisfied ಇದೆ ಅದು ಅವರೇ ಸೆಕ್ಷನ್ withdraw ಮಾಡಿದ್ರು. ಇವಾಗ ಈ ಕೇಸಲ್ಲಿ they try to contest, they were parties in the appeal order. This is what he is saying. I'm not relying that, Lord, but by
especially
in this case,
in
in
respect of this
notification,
no,
we were
never made a party and neither the state nor we have satisfied any claim in this regard. That is why
Then, my lord, my answer would be, my lord, if your lordships, my lord, kindly turn to the writ appeal, my lord, compilation. The matter arises from a common judgment of about 8 cases, my lord, dated 6/10/2017. One is before this court, my lord. My instructions are, my lord, another 3, my lord, appeal, the writ petitions are filed. That will make it 4. Rest of the matters, my lord, there is no writ petition filed. For a moment, let us assume that, my lord, they are not arrayed as party. They are required to contest all of them. They cannot pick and choose that I will contest, my lord, as against LAC appeal 8, 9 and 10, we will give up other LAC appeals. If they don't file an appeal against them, my lord, or they don't contest that, my lord, this also, my lord, has to, my lord, have the same fate. My lord, this is subject to, my lord, my friend correcting, my lord. My instructions, my lord, I have furnished, I have checked in the, my lord,
you have to give a clear tabular column.
True, my lord. If
In respect of this notification, how many cases?
How many cases?
How many appeals have been filed?
Yes.
Or writ petitions have been filed?
And how many not filed, having, my lord, same award. If they don't file, my lord, or if they are making discrimination between the two, my lord, this will also, my lord, fail.
All right, you give that compilation.
Like.
You can also give it.
Yes, Your Lordship.
They will be
Also-
better if
We'll also take
Please
instructions.
verify.
Yes, sir.
If he gives it, you please get it verified.
Yes,
And if it's a true fact, then you'll have to accept it.
we'll assimilate that data, Your Lordship.
Yes. You want to give that information and then
I will do my best because, my lord, I don't have access to all the information. Cases where, my lord, parties who are referring me or, my lord, they may get, my lord, certain information. My lord, they are, my lord, better equipped, but I will make my attempt, my lord, and your lordships may say
Lordship,
that I will try to, my lord.
For this very village, for this very notification, we'll assimilate the data.
correct.
whether we
You
have
will
left-
have all the information with you.
For this
For this very
village,
village, for this very,
But
my entire concern
exercise
is done in each writ.
But even
But
if
even if I
my
do,
lord,
Lord,
petitions, my lord, I'm not
but I'm not worried.
my lord,
Lord,
cases
cases undeserving awards, my
may
lord,
have to be
may have to be set aside, they may have to go back.
Lord, I'm
Lord, I'm not
defending that.
defending that.
My
My
defense
defense is, Lord, they want everything to be set aside.
That's my
That's my
concern.
concern.
Lord,
Lord, in the morning session of, Lord, subject to
AG's,
AG's,
permission.
permission.
It was made
It was made a submission that
everything necessary
necessary part.
We are still
We are still paying that.
Things are
Things are there.
Federal
Federal one, we will have to, Lord, stick to.
If that is
If that is the proposition, it is permitted to, Lord, continue.
Award
Award ಆದ್ಮೇಲೆ KPGN
file.
They say
They say we are not added as a party, it has to be suppressed.
This
This trick should not be played very well. ಈ ತರ ಮಾಡೋದ್ರಿಂದ ನಮಗೆ difficulty of these payment. There are some black ships are not that. Overall concern.
If these
These people who are taken away their properties and taken away their avocation,
no
no payment for several
we
years.
are all
We are all fault there is delay
for which
interest is denied and other thing.
But my lord,
But without any consideration, what awards are made, they are such that it will be difficult. The award ಆಗ್ಬೇಕಾದ್ರೆ we pay huge amount of court fee.
That's a
That's a
huge
huge
pain.
pain. What
Court fee
court fee is now paid in these awards.
If I'm not
wrong, they constitute about 20 to 30% of what is paid by them. ನಮಗೆ ಏನು ದುಡ್ಡು ಕೊಡ್ತಾರೆ ಅದನ್ನ we'll have to reinvest in this. It's not different from the government. It's part of the government only.
It goes back
to the state only.
And we are
not asked to litigate. That we will
Lord, that I'm so sorry, my lord. These kind of arguments of prejudice should not be made. You make it on the basis of some data. My lord, I'm quite sure many of those petitions have not been filed because we are not aware of the orders. My lord, because your lordship knows that when a government body has to take a decision to file a petition, there has to be some kind of administrative work, there has to be some application of mind. If we have still not chosen to file writ petition, then your lordship will hold us accountable. My lord, there's no difficulty on that. But let him give those details and we will also check up and we'll place it before your lordship.
Mr. Naveen Nath, you want to say something?
No, Lord, all that I was trying to say was, Lord, these kind of arguments of prejudice should not be entertained because, Lord, we don't know whether those writ petition details, those appellate court orders are brought to our notice. Why were writ petitions not filed in some matters? We will, of course, these are all matters of detail, but Lord, these are matters of record. If a petition is, an appellate order is brought to our notice, our legal cell would definitely deal with it. And if your lordship finds that we have consciously not chosen to file a writ petition in a particular case, you will hold us accountable for that, my lord. That's no difficulty on that. So we will also place the.
There is one aspect of the matter.
Yes.
That we really like to know. If it is a clear stand of both you and this state, that the project is handed over to you and you are responsible for payment of compensation.
Correct.
But if it is found
yes,
that the state has satisfied some of the claimants,
absolutely,
then it will be a little difficult.
No, I quite see, my lord, your lordship is absolutely right. We can't be also inconsistent and just like the.
I will not hold them accountable for payments made by the state.
Lord,
Lord, let them be accountable for the payments made by them. Earlier also, Lord, when state was a party, they would send the government and Lord, they would the Nigam has said
at least
those cases where you have satisfied some of the Lord matters pertaining to notification similarly placed from the same village or same project.
At least
those matters should be segregated and why exercise of demand and technicality come when there is specific observations that this court cannot award something less than already said.
Next para. However, having heard the learned comma, we require certain information which may be provided by the appellants or the respondents, more particularly the KNNL. Stop. As regards which is that notification.
This is acquisition for notification dated 4/2/1999. It's on my note page number 3 of the writ petition. kindly turn to page 27, their writ petition. No?
Preliminary notification 4/2/1999.
99.
Huh?
Yes.
Preliminary notification dated 4/2/1999. ಎಷ್ಟು ವಿಲೇಜಸ್ ಇದ್ರಲ್ಲಿ?
ಇದರಲ್ಲಿ ಒಂದೇ ಸರ್, ಗೌಡ್ಗಾಂವ್.
ನಾಗೂರ್.
My lords, Gaudagaon village and Karbutga village. Two villages.
Two villages.
Gaudagaon village, your lordships. It's at page number 56 of the writ appeal.
Karbos Saga. There are two villages.
There is only one village, your lordship, in the first appeal. It is page 56 of the writ appeal, your lordships.
Page?
Page 56 of the writ appeal paper book, your lordships. Para 9. My lords, the dry lands of the appellants in the above case have been acquired from Gaudagaon village.
No, that is because these appellants belong to that village.
Yes, your lordship.
What I find here is,
Seeing, my lord, the chart mentioned in the reference court award, I suppose, no? Page 42.
There are two villages.
Two villages, my lord, which are disposed of by
Karbos Saga.
Karboska.
Huh?
Karboska.
Correct alla?
Karboska and
ಏನ್ ಹೇಳಿದೆ? Their lands in two villages, namely Gaudagaon and Karbosaga, were acquired for the purpose of
Amarja project.
construction of right bank canal of Amarja project. A list of all reference cases. Huh?
Yes.
All reference cases.
And the awards.
My lords, we have only whatever first appeal cases we've received for payment, only those we have challenged. The SLO writes to us. In our second compilation, we've produced that letter, your lordships. Only those we are have information on. We don't have information on other cases because we're not arrayed as parties in these cases.
SLO is here, he can furnish, but if they don't have.
SLO has the information. He's not our officer.
Not our officer.
Once the
SLO
more particularly
respondent KNL number, more particularly the SLA, respondent SLA. Let him give the information. That's all.
As to
which cases he is communicated to the legal.
No.
We are on a different point. Whether
reference cases. Orders of the first appellate court. MSS ಇದಾವ?
Even the
second appeal. I'm not aware. Miscellaneous second appeal. Writ petitions.
And also,
in all
all
cases
cases where
the
the
enhanced
compensation amount has been satisfied
either
either by the state
or by KNN.
KNN.
All
these information
will be
will
given.
be given.
Copy of
This
will be
will
served
be served on the
government
government
advocate
advocate
who shall
who shall in turn
serve the same on the SLAO, respondent SLAO, and ensure that these information are placed before the court by the next date of hearing. Full stop. Release this matter.
Two weeks, not I will also.
Huh?
2 weeks, other
On 2nd of December.
Monday.
2nd of December.
Monday. Please,
Huh?
please.
Yes.
Also direct the office to with the copy of the order to us.
ಹೇಳಿದನಲ್ಲ.
Please.
Yes.
Deeply pledged.
All.
Number 20. Mrs. Mohammadapur.
Notes that to appear for the appellate, appeal by the defendant notes suit for declaration and injunction decreed by the trial court. There is delay of notes 77 days in filing this appeal.
To notice to the respondents on IN number 1 of 2024.
Notes, may I make one small request? Notes, only status quo with regard to mutation entries. Notes, they are trying to change the mutation entries which are standing in the name of the, as on today till next date of hearing.
The RTC was standing in the name of your father.
The appellate. How?
Your father.
Husband.
Huh?
Appellate. They claim, respondent, she claims that there was a prior partition on the basis of which notes declaration is sought. Only on the basis of mutation entry notes, one paragraph order has decreed the suit. That is notes, if notes could peruse. Internal page number notes 7, index page 15, paragraph 10 ali, last paragraph. ಏನು ಡಾಕ್ಯುಮೆಂಟ್ ಆಫ್ ಟೈಟಲ್ ಏನು ಇಲ್ಲ ಸ್ವಾಮಿ.
70 days delay but ಇಲ್ಲಿ judgment ಸೆಪ್ಟೆಂಬರ್ ಕರೆಕ್ಟ್ ಇದನ್ನ ಹಾಕಿ 29th May. Next para, however, in the meanwhile, no precipitative action shall be taken by the revenue authorities insofar as rectification of the revenue records are concerned.
Please.
Come on to the next date of hearing.
Much obliged.
Seal number 21. Vishal.
24 ಅಲ್ಲ?
21.
21.
ಅವ್ರದ್ದೇ. Vishal. My lords, I have intimated Telangana. Appellant has studied in Telangana school, my lords. I have intimated them. So within 3 to 4 days, they'll come and with their register. Kindly.
Appellant?
Appellant has studied as per the Defense Council. They have filed the school certificate, my lords. So I have intimated, but being Telangana, it's a far, my lords, 1 week accommodation or otherwise a bone ossification test.
Additional SPP submits that insofar as consideration of IA number 3 of 2024 is concerned.
Yes, please.
Where a plea is sought to be raised by the appellant that he was a juvenile at the time of the incident.
Yes, please.
The learned additional SPP has written to the concerned EEO.
School authority, my lords, where he has studied.
You are director ಬರ್ದಿದ್ದೀರಾ?
My lords.
You written to the school authorities?
Yes. Through police.
He has written to the school authorities.
Yes.
At Telangana.
Telangana.
And information is yet to be received.
Yes.
Full stop. Therefore, the learned additional SPP seeks for a short accommodation.
Yes.
Full stop. Young man, ಯಾವಾಗ ಬೇಕು?
So 1 week it will take. 27 would be.
You have given that information.
I have given the information, my lords,
Birth
and I have also
Verified now.
Yes.
it has to be verified. And learned additional SPP also has sought permission for bone ossification test. If your lordship can permit him to conduct bone ossification test, that would also establish the
That will be a longer process.
Yes.
doctor.
So let them come. So let them come and produce their whatever the.
No, if that school information, whatever you have produced is genuine,
Yes.
then we can take it.
Yes. Yes. Ma'am. And on what basis he was admitted and birth certificate and all those are to be clarified. my lords.
Release this matter on 28th of November.
Please.
Grateful minutes.
Seal number 24. Vishal Pratap Singh.
This matter, the appellant had undergone sentence. He was under judicial custody from the last 10 years, my lords. He was taken in custody on, in the year 2011, 14/4/2011. And he is convicted on, my lords, 20th October 2023. All this period he was under judicial custody. So there is a Supreme Court judgment, my lords. And also, my lords, the evidence recorded after 8 years. The trial has commenced. The recording of evidence itself has commenced in the year 2019. So from 2011 to 2019, my lords, he was in prison without there being any trial at all. Now, my lords, subsequently, court has found that he is guilty. Now, the facts of the case are such, where, my lords, in that case, accused number one's wife, mother had won the election, and the deceased side, there are two groups. So after winning the election, she has become the panchayat vice president of that particular place. The other side was not listening to her. So there was a political rivalry between these two people. Because of this political rivalry, there was a fight. And in that fight, my lords, there was a case and counter case. Two people have died. Counter case also there. My lords, the law says that case and counter case has to go parallelly, but that was not followed in this case. And only one case is going on.
And in this case, there are total, my lords, 27 accused persons. Among the 27 accused persons, still some trial is still going on in respect of some split up cases, some split up accused. So few of them have been convicted. The remaining trial is still ongoing, my lords. So in this situation, my lords, Supreme Court has held that that judgment is also before your lordship. I have already placed, my lords. It is in respect of Sonadhar versus the state of Chhattisgarh. I have already placed file ಇರಬೇಕು. Sonadhar versus ಇಲ್ವಾ? So, so all persons who have completed 10 years of sentences and appeal is not in proximity of hearing with no extenuating circumstance should be enlarged on bail. And there is a judgment by this honorable court. I have only one copy, minutes, and I had on the previous bench itself. I had served. If with your permission, I can. I have only one copy, minutes. And copy that. So the headline itself speaks. So in view of this, and since already 10 years have passed and trial is going on for others, so therefore, to take up this matter for final hearing itself would impact on the trial of which is ongoing. So given this set of circumstances, given the fact that my lords, he is not an habitual offender, and moreover, he is also not the person who was directly winning the election. He was somebody, basically, not it's a caste fight. These people belong to Madiga community, those people belong to some other community, and in villages, one wins the election, the other people will not support. This is a fight. It's not something very unusual, happens in the remote villages. Now things have changed, but at that time, things were little different. Now things have settled down, but trial is ongoing, my lords. So in such a situation, given the fact that he has already completed 10 years of, and this judgment is also coming to our aid, I think bail can be considered, my lords. Taking into account the fact that he has no other criminal history, and moreover, my lords, I have also filed documents which shows that his economic condition is also something where he has dependent wife and children who are waiting for him from last 10 years. His custody certificate is on page 148.
Yes.
Melts. The trial has sum up and the punishment has been declared by the trial court. The allegation is he is the main prime accused and assailant of this party. It's a double murder case. Wherein, so I'd like to draw the attention of the honorable court. The page number 35, ink page number. 33 minutes, 33. The prosecution thereafter has got examined one person by name Basappa, namely CW7 as PW6. Said witness in the course of his evidence stated that CW1 is his aunt and so, and the entire the relation he has narrated, and thereafter, my lords, in page number 32, 34, my lords, when his brother Ashappa went into the village, then accused persons by name Narsappa, Ravi, who is appellant before this honorable court, Hanamanta, Chandrappa, Narsimha, and Narsimlu, being present in front of the total of one seat CW14, assaulted his brother with stones, and at that point of time he was in his house, and that his house is at a half-kilometer distance from the hotel belonging to CW14. And when he came to know about the incident from the public, then he himself, Lachmappa, Narsappa, Turzamma, and his father Sharanappa went to the spot. There accused Narsimha assaulted deceased Lachmana with sword on his head. Accused number 4, Narsappa assaulted with an axe on his right thigh. Accused number 9, Ravi, assaulted with an axe on his left eye. And all the accused which have assaulted, that has been narrated. In page number 35, next page, my lords, in fourth line, accused number 9 also assaulted with the handle of the said axe on his back. Accused number 3 assaulted with handle of the said axe on his right shoulder. And
now learned counsel is placing reliance on this judgment of the
yes,
Supreme Court.
good.
And he is also saying, in respect of some of the accused persons,
That is split up charge sheet is there, that is the trial is being conducted before the trial court, that is different, my lords. So as far as this appellant is concerned, my lords, so 1, 3, 4, 7 and 9 have been awarded a life imprisonment. The question of other accused, that does not arise, my lords. In so far as the accused who have been tried by the trial court, in some of the accused have been awarded some minimum punishment. The main assailant, there is a injured eyewitness is there also. One Ashappa, who is a CW 15, he has examined as PW 7, my lords. He categorically stated before this honorable court in his evidence in trial court, my lords, and this cannot be discarded. Where the question of the delaying a trial and other accused trial is going on before the trial court, that doesn't make any impact on this particular case.
consideration of this appeal,
yes,
will have an impact on the trial.
Yes, but this is the one. We are in suspension of
both ways. It can happen both ways.
Yes, my lords. And if it is final hearing, the thing would have been changed. It's a question of only suspension of sentence.
Court is saying,
yes,
in such cases,
yes,
where the convict has spent more than 10 years,
yes, ma'am,
in imprisonment, and there is no chance of the appeal being heard and disposed of.
No, my submission would be, he has been convicted by the trial court.
Same thing here also.
Yes, ma'am. Trial court. The other, the persons who have been absconded at the time of trial, my lords, they have been.
Other than this ground.
Yes.
That is an additional ground that he is saying.
Yes, that is that.
This one, there is no such case where trial is still pending in respect of other Adilla idralli.
Yes.
It's a simple case where the Supreme Court has simply said,
yes,
in such cases where the accused person who has been convicted,
yes,
has already spent more than 10 years in imprisonment.
Yes.
And the appeal is not going to be decided very soon.
Definitely,
it's a case for consideration of bail, suspension of sentence and bail. That is,
that is there in Supreme Court. What the Supreme Court has held in so many cases. I'll submit.
Sonadar versus
yes,
State of Chhattisgarh.
The day after tomorrow, it may be posted, my lords. I'll submit some citations pertains to that.
They have taken note of
yes,
various number of cases pending.
That is there, my lords.
In Bihar.
Either side also, there are so many citations.
Allahabad, everything has been taken into consideration.
Yes, that is there, my lords. He is the main culprit. And if he has been granted bail, the trial is going on in against other accused persons. Definitely, he may tamper and hamper the prosecution witnesses. There is a chance is there.
Bengal. Where is it? Where is that direction is given?
Let's say the direction I. My apologies, my lord. I have taken it from a live law instead of from this. The last lines.
ಏನಿಲ್ಲ ಒಂದು ಕಾಪಿ ಇಲ್ಲ.
The company called Promotional Corp.
We are of the view that all persons who have completed 10 years of sentence and appeal is not in proximity of hearing with no extenuating circumstances should be enlarged on bail.
Yes. Some of the person's trial is going on, my lords. If he has been granted bail, there is every chance of tampering the witnesses and threatening the witnesses. Because he is a main culprit. He assaulted with sword, he assaulted with an axe. And it's a double murder.
All witnesses have already spoken.
Trial is being going on in trial court, my lord.
That is in respect of other accused
Yes,
persons.
definitely, my lord. So against some of the citations I'll give, kindly it may post tomorrow or day after tomorrow.
And this is a 2022 judgment, not a very old judgment.
Yes, 2024, there are so many judgments. Even there. Can one,
Nothing can.
no, one short accommodation. Tomorrow or day after. I'll submit. If the honorable court is not convinced, I'll do. One short effort, maybe.
At the request of the learned additional SPP, we have heard learned counsel for the appellant on IA number 2 and 3.
Objection ಇಲ್ಲ. 2 na 3.
IA 2, my lords. IA 3, may I, one small submission, my lords. IA 3, honorable previous bench had directed me to file IA 3 under BNSS, wherein they say that this case is retrospectively applicable, wherein, my lords, the sentence which has already undergone, that has to be, that particular provision was retrospectively applicable, but in my case, it is not applicable. So I may be permitted to, I am not pressing IA 3. I am only confining myself to IA number 2. That also may be taken on record.
IA number 2 of 2020. Stop. However, at the request of the learned additional SPP, release this matter on 21st of November, day after tomorrow.
Please.
And it's
Madboda?
day after tomorrow, we can do it.
IA 3.
IA 3 not press markum.
Aduk munche, learned counsel for the appellant submits that the appellant does not press IA number 3 of 2020. I'm referred off. Accordingly, IA number 3 of 2024 stands disposed of.
Disposed of.
Idradu ಎರಡು copy ತಂದು ಕೊಡಿ.
I'll give one son.
If you want, you can take it back and you can get 2 other copies.
I'm grateful,
yes.
Serial number 26, Sparsha Shetty.
My lord, I appear for the petitioners.
Yes.
Like this, when the matter was listed for the orders, the counsel appearing for the fourth respondent took time. He wants to file objection to the IA number 2 of 2024. On the last date of hearing, my lord, the matter got passed over. I moved for an adjournment. My lord, this is a case where the appellant before your lordships worked for nearly 22 years on a full-time basis. And when we requested for regularization, page 22, paragraph 8, minutes, the learned judge observes in what manner she is entitled to be regularized. Page 22, para 8. And at one point of time, management wanted to be regularized.
Which? CH.
There is a notification, my lord, recruitment to the post of lecturer where there is a single post. That notification was also challenged. The learned judge observes that since she is age barred, therefore she is ineligible to challenge the notification. Of course, she has worked, my lord, at the time of initial appointment, she was within the age limit. And she can sought for age relaxation. But in view of 22 years of service, the learned judge should have directed, my lord, the regularization. The government advocate may be notified. So far as the age relaxation, my lord, of course, the number of judgment, including your lordships, where to the extent of the service, the age can be relaxed.
Yes.
That is a short question, Nadine.
Yes, what is your submission?
But my submission is that she worked for nearly 22 years and she challenged the notification where the single post was reserved. And for that, the learned single judge rejected the challenge to the single post because she was age barred. That is the reason given. When she is working, she is entitled for age relaxation. That is one thing. And so far as the paragraph 8 is concerned, in what manner she is entitled for regularization, that is the rider put by the single judge. After 23 years, from 2002 till today, that's the position. If somebody is
She has qualification, double limit.
she has got a qualification. When in 2014 a recruitment was made, page 38 annexure H, the college authority said, that she is working on for 12 years. College cannot go for recruitment in 2014 itself. Page 38, that is a communication.
Annexure A.
Please.
2014.
No, annexure H, page 38. When the recruitment was. Sorry, annexure A, page 38. The college requested to permit the appellant to continue the service when their department directed to fill up the post of lecturer. That was in 2014.
Yes.
Now totally she has completed 22 years. And without an interim order, there is a sanctioned post. In Kantraj's case, in Mysore University, your lordships issued the direction. Of course, the appeal is pending, that's a different matter.
The date of appointment, she has eligible qualification.
What is the interim directions you are asking for now?
To adopt appointment.
I only sought for an interim direction. The appointment which has been made pursuant to the notification, that would be subject to the result of this petition.
All right, that we can do.
One that may not also be necessary. Right from 2022, they have blocked this. The earlier writ petition was of the year 2022. ಅಲ್ಲಿ ಇಲ್ಲಿವರೆಗೆ ಇದೇ ಬ್ಲಾಕ್ ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ. Because of this, there are 4 persons who come under that notification for appointment. This pertains to only this person is the English lecturer which was reserved for scheduled caste, according to them. Now my submission here is, first of all, they do not have a locus standi. She herself declares her age as 48. Now they want to take benefit of Annexure A 2014 recommendation by the college. Ultimately, this is an accepted fact that it is not the college that appoints. It is the government that appoints. So if in case the college has done its bit, if they had intended to have an appointment, they should have approached this honorable court then itself. They don't do it. Now, 1. Number 2, this case is for challenging of that notification. Now you cannot have 2 different cause of action, joinder of 2 different cause of action. One is with regards to the notification. Another is their regularization. Regularization is totally independent of the notification. Even notification, let me be permitted to go ahead. Regularization, if they want, they have to make an application to the government. If the government considers it upon them, then they can create a supernumerary post and give it to them. It is not the college that can do anything in that regard, my lord. And the most important thing is,
No, this writ petition was filed in the year 2022.
22. ಅಲ್ಲಿ ಹಿಡಿದಿಲ್ದಾನೆ held up ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ. ಎಲ್ಲ held up proceedings held up ಆಗಿಬಿಟ್ಟಿದ್ದಾರೆ.
After this writ petition was filed.
Yes, after this writ petition was filed, only on the premise that the writ petition has been filed, the government has held up all further developments.
So, appointment.
ಈಗ ಆಗಿದಾವೆ after the disposal of writ petition.
After disposal of anyway, it's all right.
Appointments have not been approved till.
Appointment itself is made after the disposal of the writ petition.
Yes, ma'am.
We will say the appointment will be subject to the final outcome of the.
Let us hear it on merits itself. Finally, we can close up.
That
the problem is they have not at all applied for. Apply madidru, they would have sought for relaxation of age of ella kilabodittu. They have not at all applied. When they have not applied upon, where is their locus antan?
They have not applied.
They have not at all made application.
It is since it is a reserved post, I cannot apply my leaves. That is why the writ petition has been filed.
Apply madidra locus, relaxation, these were all things that could have been considered by this court. When they are not at all applied, how can we think of relaxation? How can the even government think?
When the notification itself says.
That is what the learned single judge has said, that if you have got an independent right, go and approach the government. Let them file an application thereupon.
ಈಗ regularization application ಹಾಕಿದಾರಾ?
ಅವ್ರು ಇನ್ನೂ ಹಾಕಿಲ್ಲ ಅವರು.
ಹಾಕಿಲ್ಲ
ಅದನ್ನು ಹಾಕಿಲ್ಲ.
Representation.
ಬ್ಯಾಕ್ಡೋರ್ ಎಂಟ್ರಿ ಕೇಳ್ತಾರೆ. ಬ್ಯಾಕ್ಡೋರ್ ಎಂಟ್ರಿ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ಬ್ಯಾಕ್ಡೋರ್ ಎಂಟ್ರಿ ಹೇಗೆ ಕೊಡ್ತಾರೆ?
There are 5.
ಒಂದು ಎಕ್ಸೆಪ್ಷನ್ ಕ್ರಿಯೇಟ್ ಮಾಡಿದ್ರು ಗವರ್ನಮೆಂಟ್ ಸುಪ್ರೀಂ
permission given to file a application. You will have to consider it only in accordance.
And that the government will have to do it because the
permission ಮಾಡಬೇಕು.
Government
can even recommend ಅಷ್ಟೇ.
I can at best recommend ಅಷ್ಟೇ. Beyond that I can't do anything. And for that reason to hold up this appointment of others, it becomes.
ಆಗೋಗಿದೆಯಲ್ಲ appointment ಆಗಿದೆ.
ಆಗಿದೆ.
Okay. Learned senior counsel.
ಅಂದ್ರೆ ಆಗಿದೆಪ್ಪ, ಇನ್ನ ಫೈನಲ್ ಪರ್ಮಿಷನ್ ಬರ್ಬೇಕು ಈಗ ಅಷ್ಟೇ ಗವರ್ಮೆಂಟ್ ಅಂತ. ಎಲ್ಲ ಪೇಪರ್ಸ್ ಎಲ್ಲ ಕಂಪ್ಲೀಟ್ ಆಗಿ ಹಾಕಿದೆ.
Appearing for the appellant. Although the learned single judge was satisfied and accepted the contention that a single post cannot be reserved, having regard to judgment of this court in the case of Srimati Rashmi MS versus State of Karnataka and others in WP number 51487 of 2019, which was disposed of on 17/4/2021, nevertheless, since it was found that the appellant herein was aged about 48 years and therefore ineligible to apply for appointment to the post of English lecturer, the writ petition was disposed of, permitting the appellant to seek regularization of her services comma, since she has put in more than 22 years of service in the respondent institution. Full stop. However, after the writ petition was disposed of, the respondents have gone ahead with the process of recruitment to the post of English lecturer. Full stop. Therefore, the learned senior counsel would submit that the appointment, if made by the respondents, should be subject to the final outcome of this appeal. Full stop. Next paragraph. Accordingly, it is directed that any appointment made by the respondents to the said post of English lecturer in the 4th and 5th respondent institution shall be subject to the final outcome of this appeal. IA 2 of 2024 is accordingly disposed.
Please. I have one small problem in this because last time I faced it, merely because the writ appeal is pending, the government will again withhold that granting of permission. The government shall proceed at the complete the process at least. Process complete madadalli told kutpadtare.
It is made clear that if the respondents have taken steps to fill up the post of English lecturer, they shall proceed in accordance with law.
Without waiting.
Adan first haki, amele, however, it will be subject to the final law. Yes.
29, Bapugoda Siddhappa.
For the appellant, claimant's appeal for seeking enhancement in the case of injury mode. Notice to the respondent number 1 may be dispensed not seek. The R2 is Tata A General Insurance Company.
Learned counsel Sri M. Sudarshan. Hospital evridara?
Sanjay Joshi. Tata A is
Illa Tata A is
Tata.
Sir, Sanjay Joshi, Tata is Sanjay M. Joshi is requested to take notice for respondent 2.
I filed the memo for dispensation notice to respondent number 1.
The memo, dispensation. Yes.
Delay is 58 days.
Respondent number 1.
Delay of 58 days months. 58 days delay in filing.
58 days is condoned.
Refer to local adalat.
Stop. Matter stands referred to local.
Local adalat.
Local adalat.
Seal number 30, Bapugoda Siddhappa.
It is R1 may be dispensed not seek. R1 may be dispensed owner of the vehicle.
Same.
Yes, the second respondent universal Sompo not seek.
Hmm.
Preeti Patil, Srimati Preeti Patil advocate.
Yeah, respond number
2 not seek.
Respond number dispensation.
Yes.
Same.
Yes. Delay of 46 days.
46 condoned.
Refer to local adalat.
Yes, local adalat.
Seal number 31, Bapugoda Siddhappa.
Notice to the army be dispensed. The second respondent United India Insurance Company. United India Insurance Company. Branch manager United India.
Second respondent.
Yes,
United India.
Shanabasappa M. Patil is.
J. Augustine. You with the other?
Shanabasappa M. Patil.
Shanabasappa M. Patil. Yes. Yes. For respond number
2 minutes.
2. Respond number 1 dispensed.
Yes.
1497 days.
Without interest.
Stands condoned. However, the appellant shall not be entitled for payment of interest during the delayed period.
Refer to local.
Yes. Yes.
Seal number 32, Patil Malkundi.
Insurance company challenge liability, madam. Insurance company appeal must say, second first time, madam.
Liability.
Yes, madam.
10 days delay.
Yes, madam.
Issue notice to the respondents. Stop. Learned counsel for the appellant submits next para that though there is a delay of 10 days in filing the appeal, nevertheless, since the claimants have filed execution case, the impugned judgment and award may be stayed subject to conditions. Full stop. Next para. Accordingly, there shall be an ad interim order of stay of the impugned judgment and award in MBC 203 of 2021 on the file of the second additional senior civil judge and JMFC, additional MACT, Kalaburagi, till the next date of hearing, subject to the appellant insurance company depositing 50% of the award amount before the tribunal within a period of 6 weeks from today.
Call for records. Call for records.
Call for trial court.
Much.
Lordship, appearing for the appellant lordship, matrimonial case lordship, appearing for the wife lordship. The appellant is agreed by the order passed by the family court that ex parte order is passed lordship. The respondent have filed the petition under section 9 of the family court act lordship. It is passed.
Restitution of conjugal rights.
Please lordship. Lordship,
what is the difficulty?
lordship, she don't wants to stay with the husband lordship.
Can anyone force you?
No lordship.
Then
Their allegation that the lordship she have left the house.
why are you asking for a stay of this order?
She don't want to stay with him lordship. That's the reason.
Don't stay.
But the court have ordered to she has to stay with her.
You want to obey?
No, lordship.
You don't want to obey?
Please.
Then ಅದು ಇಲ್ಲ ಇದು ಇಲ್ಲ ಏನೋ ಒಟ್ಟಲ್ಲಿ
I'm having the good case lordship. I'm having the grounds also lordship. There is a delay also lordship for 59 days. 59 days delay.
59 days, yes. Issue notice to the respondent on IA number 1 of 2024. Yes.
Much obliged lordship.
Seal number 35, preliminary notice. AGA, additional government advocate.
Appear for the appellant. It's only one objection, my lord. There is no attested by the, my lord.
There is no?
There is no attested in the annexures. Serial number 4. Objection number 4.
All annexures to be attested as a proof of competent authority. ಮಾಡ್ಬೇಕಲ್ರಿ, that's the requirement.
Is not. I'll do it, my lord, within 2 days, my lord. Within 2 days, I will do it. Also, next week, my lord.
Learned government advocate submits that office objection at serial number 4 regarding the attestation of true copy shall be complied in a day or two.
Please.
Full stop. Next para. If the office objections are complied, list this matter for preliminary hearing on 22nd. Agboda?
25th.
25th.
Please.
Seal number 36, Sindol.
Matter is called out. There is no representation for the complainant.
My lord, I am appearing in serial number 36.
Yes. Yes. Really? Consider annexure yes. Learned, the government advocate takes notice for respondent number 5. Issue notice to response number 1 to 4. Learned counsel for the complainant is directed to serve copy of the petition along with annexures on the learned government advocate. And notice returnable by 3rd of December.
Seal number 37, Siddharth B. Pujari.
Fair for respondent, man. Have it on day after tomorrow, man. Day after tomorrow, my lord. Senior is the obsession. We are Sarthi, man. Held up in other court, my lord. 37 senior counsel engagement.
37, this matter.
My lords, I am for the petitioner, my lords. Petitioner engaged senior counsel dear Ravishankar. Kindly take it up day after tomorrow, my lords.
Day after tomorrow, my lord.
At the request of both the learned counsels, release this matter on 21st of November.
Please, my lords, oblige me.
Reporting compliance, serial number 38, RJ Busari.
For last occasion, my lord, I filed the, my lord, affidavit of the first respondent along with compliance, my lord. As per the direction of the learned single judge, my lord, we considered the representation and rejected the, my lord, prayer of the, my lord, complainant and issued the endorsement also. Last occasion, my lord, he was taken the time. Today, my lord.
To secure instructions.
Yes, ma'am. Filed the, my lord, along with affidavit.
Regularization of appointment.
Yes, ma'am. That is rejected, my lord.
Learned government advocate submits that compliance affidavit of the director of the municipal administration has been filed along with copy of endorsement dated 12/11/2024 issued to the petitioner. Full stop. Learned government advocate submits that the directions issued by the learned single judge is that the respondents shall consider the representations given by the petitioner for regularization of his services. Full stop. Accordingly, the representation has been considered and with reasons the same is rejected. Full stop. Next para. Liberty is reserved to the to question the endorsement issued by the respondents. Full stop. Next para. Accordingly, the contempt petition stands closed.
I'll take notice for R1, my lord.
Serial number 39, admission matters, Praveen Kumar Raikote.
But sir.
With permission of your lordship. My lord, I am appearing in serial number 36 at the time of call. I was muted by the host, my lord. It is contempt petition, my lord. Notice may kindly be issued.
We have issued notice.
To the respondent number 2, they have not considered, my lord.
45, my lord, it was heard parted. My land was utilized for jail.
Serial number 36, my lord.
Notice issue madidivri.
They have to serve the copy to me, my lord. They will not serve.
Please serve a copy on the learned government advocate.
It was
heard.
Notice agida tamdu serial number 35.
It is heard partly, my lord. It is only the instruction directed to instant. 45. It was heard in length, my lord. A direction was given to government to ascertain whether compensation is.
Yes, we received, record is received, my lord. There is a, my lord, endorsement that, my lord, 34 acres, my lord, land, which is mentioned by the Assistant Commissioner. That was the road before, my lord, previous period. As per the circular, my lord, he is not entitled for the compensation. So that observation is not, my lord, in the learned single judge, my lord. I will produce that records, my lord. Any date may be fixed, my lord.
Serial number 45. Release this matter.
41 time.
Day after tomorrow.
Next week, only Xerox ತಂದಿದ್ದಾರೆ. I asked her to bring the original.
ಅವ್ರ ತರ್ಲಿ ನೀವೇ ಇವಾಗ ತಂದಿರೋದನ್ನ ನೀವು ಇಟ್ಕೊಳ್ಳಿ. We will have it day after tomorrow.
Please.
21st.
Item number 52. Lots have heard it. Yeah, item number 52. Kindly have it day after tomorrow. Matter
for the petition.
Howdu. Our information declare lots have already held that.
There is no urgency, my lord.
Notification.
In persons of the lordship direction, my lord.
Finally, it was. Finally, we will not take any adjournment. That was the observation. Kindly have it day after tomorrow.
Your lordship is directed us to, my lord. This court directed us to consider their appointment, my lord, application for appointment. We considered and appointed them also. They are also in service. They are also getting the salary also. But there is a huge, my lord, question before lordship, my lord, that relaxation has to be given to the other parties or not. That has to be considered, my lord. For that is a reason, my lord. Let it come, my lord. There is no urgency to them.
Finally.
With permission of
41, my lord.
court officer.
ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದಾರ ಸೀರಿಯಲ್ ನಂಬರ್
ಆಯ್ತು.
36.
Okay.
Yes. Yes.